GrantSmithEllis. I'm an on-time towel for yourself, for me, for the first day of opening statements in the Karen Reed and John O'Keefe retrial. I'm so glad you're here with me. I'm thrilled to welcome you and all of the other towel friends. And as always, it took me a second, but I was able to get the YouTube stream up and running, and I pray and appreciate your patience as that gets started. Oh, nope, I almost hit the wrong button. As that YouTube stream gets started and some of the wonderful towel friends join us. At 9 a.m. today, there is expected to be the beginning of opening statements in the Karen Reed and John O'Keefe retrial. Now, we'll talk a little bit about what procedural housekeeping matters may need to be addressed first. We'll talk a little bit about what else is going on in general in the lead up to those opening statements. There's only two outstanding motions we really need to deal with. One is a compliance deadline for Reed related to material from her experts from ARCA. Apologize for that ping there. I'll mute that. And then the other thing we're looking for is a notification, a motion from Hank Brennan related to opening statements. Okay, so that may actually delay for some time, or at least we may need to talk about this outside the presence of the jury. So while we are expected to start around 9 a.m., there's going to be a little wiggle room. Now, my name is GrantSmithEllis. I'm so glad to have you all with me. It's great to see you, Goldie Lawrence. It's great to see you, Dixie Doodles. It took me a second to get the YouTube stream up and going today, but it is indeed working. And really, I'll be here with you. I want to talk a little bit about, as I mentioned, those outstanding motions related to opening statements. This has to do in particular with Reed's desire to introduce a picture in opening statements that the prosecution, Hank Brennan, feels might be an attempt to circumvent a prior ruling from Judge Canon prohibiting Reed from using a third-party defense entirely, whether it be related to Chewbacca, Colin Albert, Brian Higgins, Brian Albert, or otherwise, but in particular not during opening, because Reed can only, even during trial, if she develops with competent evidence I don't think will come in, because it doesn't exist, be able to introduce potentially third-party culprits that are not Colin Albert if that evidence comes in, right? So it's not expected to come in during trial, which is why Hank Brennan has put a motion forth related to opening statements, because during the last Karen Reed and John O'Keefe trial, there was a ruling from the bench from Judge Canon that Karen's lawyers were not to open, specifically not to open on a third-party culprit defense. Now, if you're wondering, why is this such a big deal? Like, people can just make their defense, right? Well, no. A trial is a staged, managed production because the jury, fundamentally, under the rules of evidence, can't just hear everything either side wants to say. That's not how the system works. Both sides have to propose to the judge what they'd like to do for the most part, in particular with regards to making certain defenses or introducing certain evidence against a defendant. This is all done via motions in limine leading up to trial. We've seen a lot of them, 70 of them or more that I've kept track of leading up to the second trial alone. Now, the reason why this specific issue is so important is that during, as I mentioned, during the first Reed trial, there was a ruling from the bench from Judge Canon that Reed could not open on a third-party culprit defense. It was enumerated specifically in an oral ruling from the bench. Now, an oral order from the bench is the same exact thing as a written ruling, but as an attorney, you show the same level of respect for both. Now, I'm not a lawyer, I'm a towel, and none of this is legal advice, and you should get a lawyer if you have questions about the law. Get a towel if you're striving to prove unconditional love exists in a world that seems to resent the very concept. As an attorney, if you move for a pretrial motion allowing you to use a third-party defense, and it is overruled by the judge or denied by the judge, which happened in the first trial for Reed, and you then go on and do it anyway during opening, it is considered an extreme faux pas. Now, maybe you're not going to get sanctioned in that moment, but it absolutely can create a situation whereupon the judge during a retrial will do something like issue a formal order from the bench, which Judge Canon did. We can take a look at it, but it's way, way back on my feed. A formal order, as Judge Canon did from the bench, confirming that Reed cannot use a third-party defense. Now, in particular during opening. Now, Hank Brennan has moved again, I think it was last Thursday or Friday, just a few days before opening arguments, which are going to happen in just over an hour from now in the Karen Reed and John O'Keefe retrial. Moved again for another ruling from Judge Canoni because of what Mr. Brennan saw in pretrial disclosure from Reed's team related to the exhibit that Reed wanted to use in her opening. Hank Brennan has moved again for a ruling from Judge Canoni prohibiting Reed's defense from using this in a third-party culprit in their opening. Now, here's the thing. This could actually play out in a very interesting way because, okay, so objecting when another lawyer is asking a question or on direct or cross, very, very common. Objecting when another lawyer is making their opening, oh my goodness, it is done, okay? Like some lawyers will say, of course, you should be objecting, if something comes up. But it's classically, it's a faux pas. It's the kind of thing that most lawyers would not do to another lawyer. Now, maybe some of you were watching the Lori Daybell trial, and you saw that during her closing, because she was pro se, there were a lot of objections. That's where you might see in an opening or a closing a lot of objections. But in terms of an opening from another lawyer, very rarely would you see an objection. That's just my opinion. It's kind of disrespectful. But in this situation, depending on how the if we go right into openings, you could very well see Hank Brennan have to stand up and interrupt Alan Jackson's opening. Because of the fact that, because of how limited Reed is in what she can present at all about it, she can't present anything about a third-party culprit. And so if Reed tries to just violate the spirit of that again, or the direct content of Judge Canoni's ruling during opening, like David Yannetti did during the first trial, then absolutely you could see Hank Brennan object. But we don't know whether we're going to see this procedural housekeeping motion from Brennan brought up before opening start. Judge Canoni is very businesslike, so I could see her being like, okay, we're going into openings, but you can't really leave this motion from Brennan on the table that he put in Friday, confirming that the defense can't use a third-party culprit during opening, whether it's Chewbacca or a dog or anyone else or anything else for that matter. By the way, I was doing some review. If you're wondering, Tal, why are you not just down there? Well, I was doing some review for one of the finals I have to take this week. And one of the questions was, say a dog barks loudly in the direction of a defendant while a police officer say a drug dog alerts to the presence of drugs during a search, and then they want to introduce that at trial. Is that hearsay? And then the answer was no, because a dog is not a person. I was like, oh dear God. But I still think there is case law about like using an animal as a third-party culprit, even though they're not sentient. Oh goodness, I forgot to check on the chat for a little bit. Let me go back. Good morning, Christina. Good morning, Maui Swift. It's great to see you. Jew Drops, as always, it's so wonderful to have you. I'm thrilled to have so many of you Tao friends with us for this adventure. It is going to be an adventure over the next 6 weeks, but as I've said to you multiple times, I'm going to be here with you for it. I'm going to juggle a lot of things that I've got going on, and we are going to analyze and watch this trial, and in particular we're going to spend the next hour together making some predictions. If you have any questions that you want to ask, I'll try my best to answer them. And then at 9 a.m. together, I have multiple different sources, multiple different feeds we can tap into. I am permitted to broadcast the court's official Zoom feed. So if there's any technical issues on the camera pool, I have a backup Zoom feed ready to go for us. I have multiple live feeds ready in case any of the audio goes bad on any of the pool feeds. And then also this week, I'm working on sending a tech person down there, and then I've been given permission to plug into the direct pool feed from the pool, and I'm gonna get the raw feed set up, and then hopefully I'll be able to have that as a backup too. So Towel has lots of plans. Towel's grateful to have you all here. Let's see. Oh, Angela Widdick, I saw you pop up. Great to see you, Angela. I love your profile picture. 5-MEO-DMT. I'm pretty sure that's some type of drug. Welcome. It's great to see you. I'm thrilled with your username. If that is indeed some kind of chemical, I think that is very creative. I like science. What else do we got here? Grant, we have a question. Grant, do you think Judge Canoni should wait till next week to see what Supreme Court does on Friday? After their Bridgegate opinion, I have zero faith in the Supreme Court following law. No. By Justice Jackson denying the state. Okay, so first of all, procedural history. Karen Reed made a ill-fated appeal to the federal courts under habeas, I think 1142, maybe 1134, 18 USC, some habeas petition for someone in pretrial state custody. Reed tried to get the federal question doctrine invoked and avoid Younger abstention by claiming that her rights were violated during the first trial and that there was actually an acquittal. But Reed ran into this horrifyingly difficult precedent to overcome pursuant to Renico and its progeny, which is Bluford v. Arkansas, and then also these cases, Tanner v. U.S. from 85 and Pena Rodriguez v. Colorado from 2017. She just ran into this mountainous hill of precedent. And so she got denied at the federal district court by Justice Saylor, Chief Justice Saylor. She got her motion for stay. She tried to use the federal appeal to get a motion for stay granted to halt the lower court proceedings. She lost on that motion. She went up to the Fourth Circuit Court of Appeals, First Circuit Court of Appeals, above Judge Saylor, a three-judge panel of the Fourth Circuit denied again on the merits Reed's actual petition, and then they also denied her another stay. So she's at that point lost 2 stays and 2 motions on the merit to the federal court. Then, and this was all over February, March, April of 2024, maybe not into April, mostly through March. Then in late March, early April, Reed goes up to SCOTUS on a petition for a writ of certiorari, which you're not entitled to an automatic appeal to SCOTUS. You have to ask their permission to appeal to them. So Reed goes up to SCOTUS. She submits to Justice Jackson on April 1st a petition for stay of her state court proceedings again. That gets denied, and so the only thing left is the Supreme Court justices having their conference on April 25th to determine whether there's the 4 votes necessary to get this petition up to the Supreme Court. Now, Justice Jackson is a liberal. Reed's only hope of getting SCOTUS to do anything would have been if there were 4 justices who voted to hear this case. Now, what Reed did was she went to the Bluford dissent from Bluford v. Arkansas in 2011, where a jury foreperson actually stood up in open court, announced that there was an acquittal, and then the jury went back to deliberating. So the Supreme Court determined that there was not finality to the jury foreperson's announcement of a partial acquittal, and therefore there was no manifest necessity to prevent a retrial. Okay, or there was manifest necessity for a retrial. Okay, so those facts are far stronger than anything Reed presented in her federal appeal, right? So what she was really trying to do is there's a dissent to Bluford by Justice Sotomayor that said on a stronger set of facts, the Bluford was decided wrong and should be overturned. But the problem is that the 6 justices on the Supreme Court right now who are conservative, some of them lean, some of them sway. The 7-2 on the ruling preventing the president from invoking the Alien Enemies Act to deport people, that 7-2 vote shows the swings. The swings are Chief Justice Roberts, Justice Kavanaugh, Justice Gorsuch, Justice Coney Barrett. Then there's 3 liberals, Justice Sotomayor, Justice Jackson, and Justice Kagan. And then the 2 hardcore conservatives are Justice Alito and Justice Thomas. Now, all of the conservatives are going to back the Chief Justice on Bluford, okay? So every single conservative. No one's going to swing on that. It's 6-3. And Karen really needed a 4th liberal on the court to get the 4th vote to even get her case heard. So 0.0000001% chance the Supreme Court does anything. No reason for anyone to delay the state court proceedings. All the motions for stay to this point have been denied. I hope that has been helpful. As someone asked if Chloe was driving the Lexus. No, it was Chewbacca, Angela Whittick. Chewbacca was driving the Lexus. Morning, Grant. Good morning, Melanie. It's great to see you. Welcome. Leave Chloe alone. Justice for Chloe. Free Chloe. I hope you aren't missing school to cover this trial. No, I'm working on finals right now, which is part of the reason why I'm sitting at my computer, because as we are watching the trial today, I'm also going to be doing academic-related things, and hopefully in the next 2 to 3 weeks, I will get my 5 remaining finals done. I had 7 this semester because I'm a towel. I'm a dedicated towel. Let's see. Dixie Doodle says, hi, Christina, Angela, and Melanie. So glad today is finally here. Let's go. Justice for John. Yes, if you missed the morning pre-trial towel poll, oh goodness, there's a lot of you watching. The morning pre-trial towel poll, which ran for 3 days, had Hank Brennan with the momentum at 56.6 to 43.2. Now, I also put up a poll just a few minutes ago that has more votes than minutes have elapsed, asking, will Hank Brennan's 9 a.m. opening statement in the John O'Keefe and Karen Reed trial include data from Karen Reed's Lexus GPS showing Reed went back to Fairview Road at 5:23 a.m. on 1/29/2022 to confirm John had died in the same spot where Karen hit him with her car at 12:31 a.m. That vote is at 64.7% yes, 35.3% no. The opening statement, by the way, for the prosecution, I think is what most people are looking for. It is going to, I think it starts with the prosecution. It starts and ends with the prosecution in Massachusetts. So if folks who have been waiting, we are just over an hour and 9 minutes to go. And Hank Brennan's opening statement is going to be the theme of our discussion this morning, really. Maybe I'll even do a practice opening statement for you at one point, as if I were Mr. Brennan. That might be fun. I have no notes. It would be unscripted, but... good morning, Diana and Natalie. Grant, I sent you a confidential message. Okay. I shall check my confidential messages. Hold on one second. Where is this? I don't know which specific Facebook page you sent it to, but I will look into that, Diana and Natalie. Sending love to Peggy and family, says one of the comments... sorry. Oh, it's Dixie Doodle. Sending love to Peggy O'Keefe and all friends and family of John O'Keefe. Yes, God bless you. That's something we can all agree on. And by the way, I was watching some random Karen Reed stream the other day, and the folks were saying, who's Margaret O'Keefe? And I just, head in hand, like that is, come on, guys. That is John's mom. Okay. Sorry, I got distracted by this, message, which I haven't been able to pull up yet. Rest in peace, John O'Keefe, says Dewdrops. I hope all jurors are fair and impartial. Yes, I think that's very important indeed. Also, I did not get your message, Diana and Natalie, so you may try sending it on another platform, or make sure you're sending it to the right GrantSmithEllis. When towels hang together, they have a rap session. That's funny. Angela Whittick, your wonderful towel puns are always appreciated. Ed Job says, one of the arguments from FKR is that the interviews with the witnesses weren't recorded. Yeah, that's just another excuse. They documented the interviews. Hi, Kim Courteau, great to see you this morning. I'm only going to watch Brennan's opening, can't stomach watching Jackson's. Well, listen, we have to watch it because it could result in Brennan objecting, and that could shut down. If you plan to do an opening and you get objected to and the judge sustains it and it changes what you have to do, you're screwed. Also, sorry, I kept things on top chat instead of live chat, so I was wondering if I was missing some of your comments, so I had to readjust it, and I'm starting again. Well, from where I where I left off, so sorry if I missed any of your comments. I hope the jury sees right through Karen and her lying clowns. Good comment, Dewdrops. Good morning, all. How much time do we think Karen will do? I'm thinking 3 to 10. Good morning, Diane and Melanie. Dewdrop says she doesn't want to. They don't want to listen to Jackson either. Let's pray together for fair, honest jurors, strength to the O'Keefe family, and good health and effectiveness to Hank Brennan. Yes, and let's pray for the Holy Father's spirit in heaven as well. If you're a Catholic, even if you're not a Catholic, I think a lot of religions around the world. I even saw statements from various groups in the Middle East, like Hezbollah and whatnot, wishing well to the Pope after he passed this weekend. So, God bless the Holy Father. Good morning, Grant. Eva says, I'm the greatest of all time, or towels. I like greatest of all towels, but we'll go with that. Now, let me see. What poll, does anyone have a suggestion for a towel poll? Grant, if she's convicted on manslaughter, what is the min-max? Well, it depends what type of manslaughter. So Karen Reed's charged with 3 different offenses. The first offense is second-degree depraved heart or malice murder, which requires a reckless intent to do an underlying act that a reasonably prudent person knew or should have known in that moment would pose a strong and plain likelihood of death. To wit, in this case, Karen Reed allegedly backing up her Lexus with a BAC between 0.13 and 0.29 to 24.2 miles an hour at exactly 12:31, turning over to 12:32 a.m. on 129.22, whereupon she allegedly made contact, struck John O'Keefe, and then John went to the ground, whereupon he suffered a head injury, causing him to become incapacitated, and then reddening of his pancreas indicated, according to the medical examiner, that hypothermia contributed to John's death because Karen left John to die in the snow for 4 hours. Allegedly then returning at 5:23 that morning to confirm John was dead before leaving, going to pick up 2 witnesses and trying to stage the worst cover-up of all time. Karen, that is, trying to stage the worst cover-up of all time, which did not work, in my opinion. But the question was specifically the distinction between, the question was, what is Karen charged with? It wasn't really the question. I'm just bringing it out to those 3 parts of the indictment. Malice second-degree murder, okay, which requires the recklessness underlying act, right, backing up the car while drunk, plus a theory, which is a little bit of a heavier burden. It's not an intent to kill, but it's a heavier burden than what we're going to talk about next, which is the second indictment, which is OUI manslaughter. Now, OUI manslaughter has a very high, has a lower threshold than what we just talked about. It's just a recklessness act plus alcohol, and we know there's the BAC reading, so that gets them there on that. But the difference is the 2 things are very similar. It's the recklessness standard for OUI manslaughter, so a reasonably prudent person knew or should have known that the act that they did had a strong and plain likelihood of causing serious injury or death. But it doesn't require, there's a slightly elevated theory required with the second-degree depraved heart murder versus OUI manslaughter. Now, second-degree malice murder can lead to life in prison. OUI manslaughter, I think, is 2.5 to 20, and then there are 2 lesser included offenses, which is involuntary manslaughter, which is similar to OUI manslaughter, but without the OUI. And then there's motor vehicle homicide while OUI, which is, again, similar, but includes OUI. So all 3 of those have very similar penalties. I believe they are all in the range of somewhere from 2.5 to 20, but I think only OUI manslaughter goes up to 20. Involuntary manslaughter and motor vehicle homicide, while OUI might have a slightly lower cap. And then the other thing is, I think if you get convicted of either voluntary or OUI manslaughter or motor vehicle homicide, while OUI, it comes with a permanent lifetime license revocation, whether you plead to it or get convicted of it. Voluntary manslaughter, if there's no OUI element, might not, I don't think. And then the third crime Karen is charged with is leaving the scene of an accident causing serious bodily injury or death. So all of those offenses tied together, the distinction between what I think Hank Brennan really has to focus on if he wants a conviction on malice second-degree murder or depraved heart second-degree murder is the subtle but important distinction between recklessness plus a theory of the act and then just recklessness for malice second-degree murder versus OUI OUI manslaughter, because it's not a huge difference. It's not intent. Karen did not have to intend to kill John O'Keefe for malice second-degree murder to apply, and that's almost how I would open at some point in my opening. I would be sure to emphasize that none of these charges that we're talking about required Karen Reed to have intended to kill John O'Keefe. But if you find that Karen Reed acted in a reckless way, did so while drunk, did so in a way that a reasonably prudent person knew or should have known could cause serious bodily injury or death, then there's enough for malice second-degree murder. And then I would also say, but if you find that Karen Reed acted just purely recklessly and she was drunk while doing so, and you don't, and I would be very careful about explaining the distinction between manslaughter and second-degree murder, but if you don't think it gets to that level of the theory of her act, if you think it was reckless and she was drunk, convict her on OUI manslaughter. You know what I mean? So that's the distinction, and the jail term difference is 10 or so years, obviously, for the lesser included offenses. But if Hank Brennan gets a guilty vote on malice second degree murder and really spells out why there's no intent to kill requirement, she could be looking at life. And Hank Brennan's good enough to do it. That's why, to me, I was always thinking this woman has to think about a plea, because there's so much on the line. And if you go up against a competent attorney who can convince 12 people on the jury, that 12 deliberating jurors, that this was a reckless act that a reasonable person in that moment knew could have caused John's death, that's malice second degree murder. That's life in prison. Can the jury convict on all charges? Yes, of course you can. I don't think you can convict on, maybe you can. I don't think you can convict on the lesser included offenses of charge 2 and the top one. I think you'd more likely just go guilty, guilty, guilty on 1, 2, and 3. You could also technically do guilty on 1, like guilty on the lesser included offense of 2 and guilty on 3. So yes, but I don't think you can do guilty on all 5. Maybe in Massachusetts you can, but I don't think you can. Karen has to do 10 years for what she did to those people, says 5 MEO DMT. That's a very strong argument. Good morning, Eva. Again, great to see you. Grant, sorry, I saw a question. Grant, do you think Karen Reed wins the Academy Award for the worst actress in a true crime series? JF5, that's hilarious. I would say that's hilarious, except for the fact that let's watch an example of Karen's acting. Let's pull it up in our towel time machine. We're going to call this archive of clips the towel time machine. But there's one specific clip I want to show you that is just so vile and represents, in my opinion, Karen Reed's true depraved heart, no pun intended, that I actually want to play it, because it embodies her style, her theatrics, but in such a negative, disturbing way that it would be an injustice not to play it in response to your wonderful insight, JI5. And I know the clip that I'm looking for, because Karen's eyes in that clip are just absolutely absurd. Come on, where is it? It's not the dog bite clip. It's not the oh, there it is. There it is, Karen. You know Karen knows she loves this clip. There's nothing you can do about it, Karen. You will never, ever, ever in a million years outrun this clip, Karen Reed. All right, let's watch it together.
His mother leans over the kitchen island and says to me, I think it looks like he got hit by a car. It looks like he got hit by a car. And his mother leans over the kitchen island and says to me, I think it looks like he got hit by a car. It looks like he got hit by a car.
Now, I just want to point out, I hope you all realize that moment right there, was just a few hours after Miss O'Keefe learned that John had died. This was after Karen had been hospitalized by her own parents for making threats of self-harm at the scene. Her parents requested that she be sent to the hospital. That's actually how the state got her blood, because when she was sectioned for threats of self-harm, they took her blood at the hospital, which is very interesting. I think her parents feel very guilty about giving the state that evidence against Karen, but they wanted to save her life. How can she hold that against them? They showed more care for her than she showed for John, that's for damn sure. But that scene right there, what Karen's describing, is after Karen gets out of the hospital, after it's confirmed John is dead, Karen makes a weird call to John O'Keefe's sister-in-law, Paul O'Keefe, his brother's wife, Erin. And Karen says she wants to come over and see John O'Keefe's thrice now orphaned niece and nephew, who John had adopted, by the way, like 5 years before he got into a follow-up relationship with Karen. They had originally dated like many years before that, briefly. But John had adopted his niece and nephew after their parents, their mother died of a medical condition, and then shortly thereafter their father died of another medical condition. John adopted his double orphan niece and nephew. And Karen, who had said in text messages that she didn't like how the kids were distracting John from her. She really saw the kids as like a problem in the relationship. She strangely said to Erin she wanted to come over and see them. So Karen and her family, I think it was maybe 1 or 2 cars, they drive from the hospital, Good Samaritan Hospital, Good Sam in Brockton. They drive all the way back to Canton. Karen's parents live in Dighton. They drive all the way to Canton. the murder weapon, alleged murder weapon, is still in John's driveway with a broken taillight, okay? Karen goes in to see John's family, but instead of talking to them, she just goes upstairs with her dad for 15 to 30 minutes. Her brother and his wife, both of whom are on the witness list for the retrial, Nathan Reed and Caitlin Bordeaux, the wife, they're just standing outside the house, okay? Kind of like, I don't know, acting as lookouts. I don't know what the hell was going on there. And then the Reed family, after saying very little, Karen says very little to John's niece and nephew, has this conversation. Reed has this conversation in front of her dad with John's mom. And by the way, John's mom is on the witness list. It's probably about this conversation. Karen says in that moment, that's what Karen's mocking there. As John's mom is sitting at the kitchen table, Karen's coming down. It's sometime in the morning, late morning, early afternoon of January 29th. Karen's coming down to leave John's house. And this is the conversation they're having. And John's mom is saying, I think it looks like John got hit by a car. And that's how Karen decides to reenact that moment. But that's not the end of it, because then Karen and her family, they get the murder weapon, they drive it back to Dighton, okay, and on the way back to Dighton, they're in two separate cars at that point, Karen calls Aaron again, and Karen says that she's going to have to remember the bad times and that she'll probably never see Aaron again. And Aaron's like, what? Aaron was testified in the first trial. She was very perplexed by this. Like, what are you talking about? Like, we'll talk again. Aaron never heard from Karen ever again. And so that is what Karen was mocking. Oh, and just to wrap up that part of the timeline. So then Karen and her parents get back to Dighton. They park the alleged murder weapon in the driveway. And by 4:12 p.m. that day, the state police are there, or it was some collection of state police, local police, whatever. They get there, they collect the car, they bring it to the Canton PD for processing. So I'll tell you right now, folks, Karen Reed, I don't know if I would give her an Academy Award, but she certainly is an actress, and she certainly is vile. Hi, Lisa Cox. It's so wonderful to see you. Sorry for that rapid changeover. I just had to go back to the comments because I was going to keep saying mean things about Karen if I continued to watch that clip. Yes, Drew Drops, thanks so much. If you're watching this stream for the first time, or even if you're a return viewer, if you haven't subscribed, that's a great way to help the channel. And if you click the like button, I don't really understand why clicking the like button and subscribing while the video is live is like important to this whole thing. But someone is who's smarter than me about this whole thing, the streaming thing, has said that if people like the video and subscribe while the stream is live, it helps the channel. So if you want to do that, it means a lot to Little Towel, and I appreciate it. Ed Job says, we don't know why all of Karen's phone data wasn't used the first time around. Yeah, it's more than just that, Ed Jobs. It could be potentially the Lexus GPS data. So let's go back into the Towel archive here. By the way, folks, it's coming up on 8:10 a.m. We are within 1 hour of the start of the Karen Reed John O'Keefe retrial. It is just about 8:10 in the morning. As I said, the session should start at 9 a.m. on the dot. Towel has multiple feeds ready and prepped for you all. No matter what, we will have some kind of coverage. We have the pool feed, we have the court's approval to use the Zoom feed, which I also have, and we will be watching these openings very closely. But let's take a look. This is what I wanted to show you all here. Let's take a look at what I think we're going to hear about from Hank Brennan. We're going to watch two different videos, but let's watch this one first. And I'm actually going to make this a little bit more legible for all you wonderful Towel friends. As you can see, I like to make my maps. I'm a big fan of maps. All right, and you also heard me saying earlier about Karen's return to Fairview. Well, let's find out a little bit more about that from Mr. Hank Brennan.
Account for all the discovery and make sure the defense gets everything that I can as soon as I learn about it. Looking to investigate this case all the way to trial, but our discovery should be completed by Wednesday.
Okay. Does that include the analysis of the data from the Lexus?
That has all been turned over, or we're sending it over on link. Is something like 8 gigabytes on my expert, so it takes a long time to download. It was all sent to us yesterday. That's all included.
All right,
the analysis is done. The accident reconstruction is done.
So I forgot to mention, folks, right around that 5:23 a.m. spot, Karen leaves a voicemail for John, screaming, as you just heard, John, is that you? But if you're wondering what else might Hank Brennan drop on us in terms of this Lexus GPS data, well, thanks to the incredible and incomparable murder by Maestro, I have this other clip that I can show you that's just 2 minutes long that explains in pretty good detail what I think we might hear in today's opening. So let me grab this clip as well. I don't need to play the Chewbacca clip. The Chewbacca clip is pretty funny, though. I'm convinced Alan Jackson's going to get up there and say Chewbacca did it. And if you're confused by this, you must acquit Karen Reed. As long as you're confused by the concept of Chewbacca being the real culprit, you must acquit Karen Reed. What am I looking for here? Oh, that wonderful video from Murder by Maestro, which I think I did rehost at one point. I know that it's the one I'm looking for because it just has a cropped in picture of me, I think, as the first screen in the video. So it's relatively easy to find because that is not my normal style. All right, hold on. I have another plan to find this. I shall not be deterred. I thought I just uploaded it, though, because I remember sharing it and being like, Murder by Maestro made such a helpful video. All right, where is it now? No, it's not that one. It's not that one. All right, there's only one option. Hold on. The reason why I'm searching for this is the clip that Murder by Maestro created is just so on point as to what Hank Brennan might bring up during his opening. I found it. I'm a towel. All right, here we go. Laid plans. I didn't even catch it the first time. Did you all hear what he just said? The best laid plans of mice and men, folks. The best laid plans of mice and men.
What he realized is that all of that data was unreadable. And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was a discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure. Navigation information, phones that were plugged into the radio, travel logs, information that is going to be extraordinarily inculpatory or exculpatory in this case. And so after he realized his oversight, he filed a supplemental report. And what we learned is not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader, so that way the information was not available. Also, in the infotainment system, there were actually 3 boards, not one. Only one was taken out. So there is a plethora of information on these chips.
Wait a minute, I didn't even catch that the first time. Did you all hear what he just said? Hank Brennan said that it wasn't just that only one of the 3 chips was read. The reads expert used the wrong software or the wrong chip reader, which is hardware. Oh my God. Oh my God. Oh my God. Murder by Maestro. You were right to be yelling from the rooftops about this, my friend. I will tell you right now, you nailed it right on the money. Could not be any more prescient. Nailed it. Nailed it. Nailed it. Absolutely 100% nailed it. There is a lot there, folks, and we haven't even heard the disclosures about what this detail is going to contain. I have my prescient forecast based on my extrapolation of all of the evidence in this case, being one of the few people who has read every single thing on this godforsaken 700-item docket at this point. But I'm telling you, folks, I'm telling you this is huge. I'm telling you now that it's huge, because it wasn't just the chip-off was incomplete and only one of 3 chips was extracted and read. It was that the wrong software was used initially, too. Oh, my God. Oh, my God. It was definitely, I have a strong feeling Karen Reed's expert was like, oh my God, I can't believe Lally's letting me do this. Let me give myself some plausible deniability. Well, Brennan's got all 3 chips now, and the data went from 2.4 gigs to 8 gigs. Oh my word. I'm so glad we watched this. I hope you all understand not only what I was just saying there, but what we could be about to see in less than an hour. And the implications are that, so this is relatively complex, but I'll lay it out like this. During the first trial, Karen Reed and the state proposed that Karen Reed's expert would do what's called a chip-off to extract data from Karen's Lexus GP infotainment system. During that chip-off, for some reason, Karen Reed, there were 3 chips on the board. Karen Reed's expert, whose name is Maggie Gaffney, who is on the witness list for the second retrial. For some reason, Karen Reed's expert used the wrong chip reader, which is a piece of hardware that you actually use to interpret the chip. Used the wrong chip reader and only read 1 of 3 chips, leading to 2.4 gigs out of 8 gigs being extracted for some reason. This time around, Hank Brennan's got Aperture for an expert. And that's what Hank Brennan was just talking about there. Now they got 8 gigs. And the 3 chips were read. And you can be damn sure it contains time and place information, collision information. This is the whole kit and caboodle, friends. That's why I said I was really glad we watched it, because that is the ball game. You just saw it. It's not so much the phone data, it's the way the phone data was stored on Karen's Lexus infotainment system. And you really have to understand how aggressive some of these newer models are with their data collection, even passively when your phones hook up to the Bluetooth, not to mention the monitoring systems, how much of it gets stored in that system and how much of it Hank Brennan has. And by the way, Karen's phones were also subject to search in January of 2024 following a long campaign allegedly of Reed and Aidan Kearney tormenting witnesses. That search warrant, of course, was obtained on the basis of Aidan Kearney revealing information to journalist Lindsay Gattani, as well as an intermediary between Lindsay and Aidan and Karen named Natalie, who is on the witness list as well. Lindsay's not on the witness list for the Reed trial. She is one of the named victims in Kearney's open felony indictments for witness intimidation, but she is not on the witness list for the Reed trial. Natalie is, though, and that communication between Natalie and Turtleboy to torment witnesses led to Karen's phone being taken, 2 phones being taken in January of 2024. But what was weird is someone from the Stoughton District Court potentially leaked the fact that this warrant issued, because before it could be served on Karen, she mysteriously flew to Florida for a week. And by the time she came back, it was either wiped or hard for them to access. And I think, I don't know this for sure, but I heard reports that it took like 6 months for the state police to brute force one of Karen's other devices. I think that was said in court, actually. And what that means is Apple doesn't allow you to just hack into an iPhone if you're the police. You're allowed to use something called Gray Key, which overrides the ability, the lockout function of the phone. It was required in this settlement between Apple and the government like 5 or 10 years ago in some case. But police departments can basically do unlimited dictionary-based brute force attacks on Apple devices if they have a warrant using a software called Gray Key. It's very confidential, but it is what it is. It's out there. You can find out about it if you look hard enough. And so they did that. It definitely took them like 6 months. So I would guess her password was anywhere from like 8. It was probably the max length password if she was intentional about this. But, you know, a lot of characters. 6 months dictionary-based attack using modern computing spells out that she was using a long password, because a dictionary-based attack is the length of time required to solve the puzzle goes up directly exponentially in line with the amount of numbers in the password. So if the password's 4 numbers, it doesn't take that long. You could brute force it in like a month, probably quicker. But if it's like 12 numbers, and numbers, thankfully, if the password on iPhones are all numbers, it's a little easier. But 12 numbers is going to take you way longer than 11 numbers, which will take you longer than 10 numbers, etc., etc. And it's exponential. It's an exponential logarithmic curve because of the numbers of combinations that get created when you go from like 8 digits to 9 digits to 10 digits. And so anyway, that's probably what took them so long. And by the time they got it, I think it was useless anyway. But her GPS and her phone information from the infotainment system from that night, that captures a real-time picture. It doesn't matter what Karen did to her phones afterwards. I hope that explanation was helpful. I'm sorry I went a little bit down the rabbit hole there, but I think it was important. JF5 says, I hope today goes well. I do believe one thing is for sure. Hank Brennan will do his absolute best to bring justice for Officer John O'Keefe and his loved ones. I agree. Trevor McIntyre, great to see you, sir. Trevor McIntyre says, where'd you go? You dropped off the screen. There were so many comments. Let's see. Where are you, Trevor McIntyre? I know you're here. Oh, sorry. Good morning, Grant, says Trevor McIntyre. Will you be live streaming the trial? Yes, the whole thing. Towel has a whole network. Towel got permission to hook into the pool feed. Towel's got this whole system set up and running. Towel has correspondence. Towel is very excited. Oh, by the way, Towel has a new website. It's called toweltribune.com. You should check it out. It's not just me. I have some folks that are helping me. It is a wonderful website. Please do check it out. And please don't forget to like the stream and subscribe if you haven't. That really helps Little Towel, especially as I'm going to be with you all every single day over the next 6 weeks. And I hope we all have camaraderie and get an opportunity to watch this trial and support justice for John O'Keefe and, of course, his family. My name is GrantSmithEllis. It's coming up on 8:20 a.m. We are within 40 minutes, folks. Can you feel it in the air, the atmosphere, even through the screens? You can feel the electricity. The momentum is with Mr. Hank Brennan, and the support of all the towels, washcloths, flannels, soap dispensers, beach towels, paper towels, hemp towels, and otherwise are with Mr. Hank Brennan. Go, Hank, go, says Lisa Cox. Rest in peace, John O'Keefe, says Jew Drops. Karen doing life would be beautiful. It says 5MEODMT. Trevor McIntyre, I don't believe you can be guilty of murder and manslaughter for the same act. Yeah, Trevor McIntyre, that's why I was hedging, because I think you can obviously be convicted of multiple indictments in one case, but I don't know how exactly the rules preclude either. Like, if you are found guilty on the top charge of the second indictment, that obviously means you can't get found guilty of the lesser included, but you also make a point about murder and manslaughter for the same charge. I'm obviously not a lawyer. I don't specialize in criminal law. I'm just a towel. Good morning, all, says Amber Am. Today's the big day. Go, Hank Brennan. Ed Job says, does anyone know why Karen wasn't arrested right away? It took them 3 days. I think it was because Karen, Ed Jobs, if you think about it, everything Karen did over those few days was those few hours between 12:31 a.m. and 5:08 a.m. Or 5:35 a.m. when she got to Jen McCabe's, but really 5:08 a.m. when she left Meadows Ave, where John lives, to go back to Fairview at 5:23 a.m. and then go to Jen McCabe's after 5:35 a.m. to collect two witnesses, Jen McCabe and Carrie Roberts. All of that, I think, and that it was planning so Karen could try to avoid getting arrested at the scene. And furthermore, that's why I think Karen deleted the 17 ring videos. There were 18 ring videos on John O'Keefe's system between 12:37 a.m. when Karen got back to John's house and 5:08 a.m. when she left, and only one of those videos somehow wasn't deleted. And the the record officer from Ring is on the state's witness list. So let's skip the trial and go straight to sentencing, says Barb 417. We can't do that, Barb. We must go through the trial. That is the democratic process. Karen's so awful. Depraved heart, says Eva. Jewdrop says Karen's a vile psychopath. Amber M says, send prayers for Hank Brennan today. He has so many FKR against him. Do we think she's going to plea? I don't know, Ed Jobs. I don't know. By the way, let's take a live look in. We won't use volume, but let's take a live look in over at Tommy's coverage. What's going on here, Tommy? Looks like Tommy's at the buffer zone. How many people are there? All right, hold on. We're going to watch Tom here, who's one of the streamers. We're going to watch it without sound. This is live on the ground, folks. We're taking a live peek in here. We're going to see who, if anyone, is at the buffer zone. No one, it seems like, is actually in the buffer zone. That's a news truck. Tom doesn't have the best connection here, so I'm going to try to, I have it on a slightly bigger screen. That's a news truck. Now, Tommy's going to turn right. He can't even go over to the court where Karen's going to come in. He's going to turn right. Looks like there's no one there at all. It's just the news. And you notice Tommy didn't even try to film in front of the court where it didn't look like anyone was standing. Now let's jump ahead a little bit here because Tom's going to come up on the crowds. Oh, yeah, you can see they don't want the Karen Reed supporters park. Oh, all right, how many? Did Karen pay for crowds this time? Let's see. Hold on, let me get over here. All right, so it looks like there's about 20 of them. Looks like there's about 20 Karen Reed fans. This is, by the way, folks, this isn't you. We're watching a stream where Tom CPU is running a phone camera and the connection isn't great. It looks like there's about 20 Karen Reed, maybe 15. Drastically reduced presence. Almost like there's no money for paid supporters. So let's see. Yeah, let's 5. Yeah, I'd say about 25. Yep, about 25 or so. And then maybe some smattering of 2 or 3 at the end. So, yeah, I'd say about for the first day of the trial, opening statements. Folks, we are seeing only 25 Karen Reed supporters. Just shocking here. And I don't know what Tommy's doing. Oh, Tommy's showing how all up and down the road there's no parking signs. So the Karen Reed supporters are hundreds of feet away from the court, and they can't park anywhere near it, and it looks like their total crowd is about 25 people. Wow, folks, what a way to start the morning. My name's GrantSmithEllis. I'm going to clip this. So I'm going to put that clip up for the folks who aren't watching with us live. But my word, folks, my word, I expected a decrease in crowds, but I did not expect it to be down to just that. Now, I'll leave that up on the stream for you so you can keep watching. But here, let me write this post up now, and let's see. Here we go. Not abandoning you, by the way. I'm just writing up the post that I want to share about what we just saw, which is truly shocking. I mean, the crowds during the first trial, right around this time of year, too, just hundreds of people. But now, no, not at all. So how shall I write this up? Let's see. Well, folks, there you have it. With just how many minutes? Just over half an hour to go before opening statements in the John O'Keefe and Karen Reed retrial. The Free Karen Reed movement is down to about 25 people. You did it, Hank Brennan and the O'Keefe family. You did it. God bless America. Well, folks, there you have it. With just over half an hour to go before opening statements in the John O'Keefe and Karen Reed retrial, the Free Karen Reed movement is down to about 25 people. You did it, Hank Brennan and the O'Keefe family. You did it. God bless America. All right, I have posted it. You all got to see real-time towel post drafting. I hope it's everything you could have imagined and more. As you watch our live look-in at the courtroom in the lead-up to the John O'Keefe and Karen Reed trial, I'm commentating on live look-in at the courtroom from Tom CPU, who is standing alone on the side of a road with a grainy camera pointing it at what seemed to be amorphous pink blobs, roughly 25 or so in number. Is Tom going to jaywalk? Don't do it, Tommy. Don't do it. Oh, no. Tommy's jaywalking. I'm sure this is the kind of thrilling real-time legal commentary you all come here for. This is our live look on the ground, by the way. Not much going on in today's Karen Reed and John O'Keefe trial, but I will be monitoring for you as developments occur. And, of course, I will further follow up with video, if we get it, from someone on the ground of Karen Reed's arrival. We won't be getting that video from Tommy, though, I assure you of that. Barb417 says, Karen Reed was on Glare last night, obviously intoxicated. She said, chocolate glip cookie. Did I pronounce that as she pronounced it? Justice for Ed, no, she wasn't offered a plea deal, says Dixie Doodle. Interesting. Justice for John O'Keefe and his family. Lock her up and get the justice they deserve, says Jew Drops. Let's see. JF5 says she referred to the kids as toxic from memory. There's only one toxic person in that situation, and that is certainly KR. Yep, that's true. Approximately 1 week prior to the murder, John had locked himself in a room to escape Karen after telling her the relationship had run its course. Yep, those text messages from John O'Keefe certainly affirm that. Can we do a poll regarding how much time we think Karen will do? Yes, here's the poll. Hold on 1 second. I have to type the towel poll, so apparently I have to... I still haven't unscrewed my microphone stand from my other desk. I'm working on it, towel friends. I'm working on it. All right, here we go. How much time will Karen Reed serve for causing John O'Keefe's death? Let's see. 0 to 3, 4 to 7, 8 to 15, 16 to 20. Oh, I can't do it that way. Okay, so 8 to 20 or 20 to life. 20 to life. Okay, folks, the requested towel poll is running. Special towel poll for this, the first day of the John O'Keefe and Karen Reed retrial. The numbers are off. The horses have left the stable. If you're just tuning in, we're just about 30 minutes away from the potential start of opening arguments, although I do anticipate we may see a flurry of administrative issues that need to be discussed. If you're also tuning in, we have a live look-in on the ground with commentary from Towel provided by CPU Mobile, which is Tom's CPU. Although Tom and I don't agree on Karen's guilt, I do appreciate Tom taking the time to go down there and stream from the ground to show the 25 people left in the Karen Reed movement. The poll is running. Off to an early lead is 20 to life with 39%, 8 to 20 with 39%, 4 to 7 with 21%, 0 to 3 with 0%. Folks, keep it up, keep voting. I'm very interested to see all of your thoughts. I'm very interested to hear what you all have to say. I also have to share this video of the 15 to 20 Karen Reed supporters in one of the groups because I think this is such a strong testament to the decimation of Karen Reed's PR apparatus, which was artificial and I think based on money for the most part. Which is why I take such pleasure and such vicarious catharsis in seeing that movement destroyed. All right, so I got that post up. Now let me go back to some of your comments here. The poll is very, very close, folks, between 8 to 20 and 20 to life. It is neck and neck. So if you're interested in the Towel poll, take a look at it. It's on your screen. I'm going to go back to reading some of your comments. There's a lot. The JI5 leaves a note for his fellow honorary towels saying, keep an eye out for Just Me Gaming. They are not here to have respectful discussion, but just to disrupt and derail. Well, that's why it is literally an army of towel friends in here, and I know you all do a very good job keeping an eye on the different... The only rules in this chat are don't be derogatory, don't be discriminatory, and don't sea lion. If you don't do any of those things, you're generally going to be okay. Let's see. I'm going way back in the comments now because I just want to make sure I didn't miss any of your questions. Someone says, Hank's going to knock it out of the park today. Well, thank you, GrantSmithEllis fan. We don't have to watch Karen's interview, by the way, because it's definitely her just promoting things. But she did. It's so telling. She went on all she could do the night before her trial was go on a small YouTube stream. Amber Am says John O'Keefe's mom is on the witness list. Yep, great. Now Hank Brennan can get in the clip of Karen mocking her. Yep, we watched that clip earlier. A mother knows he was hit by a car and she knew it ASAP. Yep, let's watch that clip again. Just because you brought it up, and I think I also want to see if JLR is live yet because I heard JLR was coming to Boston. And if JLR's on the ground, he can't get into the buffer zone, but he might... Nope, nothing yet. He might be at least able to go over to where the Karen Reed fans are. Now, I want to show this video of Karen here. Hold on one second. I scrolled all the way earlier to find it, but you know what? I'm going to just... We're going to scroll again because it's worth it. And you can see all the other videos of Karen. We can also watch Karen talking about pulling glass out of John's nose, which is absolutely horrifying. Actually, we'll watch that clip. We'll watch that clip second. We'll watch the clip of Karen mocking John's mom and John's mom tellingly saying to Karen in the early morning or afternoon of 1/29/2020, late morning, early afternoon of 1/29/2022, that John's mom knew John had been hit by a car, and Karen then mocked John's mom for saying that. So for those of you just tuning in late, the Karen Reed and John O'Keefe retrial is going to get started here in just under 30 minutes. It's 8:33 a.m. on the East Coast. My name is GrantSmithEllis. I'm a towel. I'm grateful to have you with me. I'm going to be providing coverage every single moment of every single day of this trial, and I will be here with you on this YouTube channel. So if you're looking forward to that, feel free to click the subscribe button, click the like button, and Towel will indeed be with you throughout. All right, let's watch this clip as requested in the comments. If you're just tuning in, this is how Karen mocked John's mom. Hold on one second. Such a pleasant expression.
And his mother leans over the kitchen island and says to me, I think it looks like he got hit by a car. It looks like he got hit by a car. And his mother leans over the kitchen island and says to me, I think it looks like he got hit by a car. It looks like he got hit by a car.
Disturbing. And let's now watch Karen talking about the glass in John's nose. Even more disturbing. Do it. Karen, that statement about glass in John's nose seems to undermine your entire case.
I ran over to him And John is perfectly still. His mouth is open a little bit. He's got cuts and blood on his face. And he's just wearing the thin clothes he had on the night before. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And I just pulled it. And as soon as I pulled it, it just gushed blood down his face.
Also, you said you're a control freak. Don't you think that goes to motive for why you tried to yell at John when your relationship was breaking down? It was kind of a telling interview, Karen. I liked it, though.
I am not going out of my way to catch this. I have not watched my own Dateline, and I've watched about half of 2020. And part of it is a personal challenge that I have so little control over my life, and I'm a controlling person in a lot of ways. And I have so little control that it's almost like a game I play with myself. That if I'm skeptical about this or skeptical of how I'm portrayed on Dateline, I will not let it infiltrate me. And I'll tell everyone around me, I don't want to hear about Dateline, or I don't want to hear about the document. If it's negative, I don't want to hear it. If there's negative things that are important for me to know or I should be aware of, I'll find out about it. But I do take some pride. I'm picking up Liza, and as soon as she...
Notice how quickly she bailed out of that conversation. But yes, that is also another clip that could certainly be used against her. All right, so let's see. Maria says, I hope they will have all the data extraction and GPS tracking. No, it will not help Karen Reed because it will show she went back to Fairview at 5:23 a.m. Criminals have been convicted for less, says Ed Jobs. I agree. There's a mountain of evidence against Karen. I agree. Barb says she went for a walk last night and she knows she'll be resting all day. That's good, Barb. Welcome. I love to have you. I'm thrilled you're here. Be right back. Girls need walking. Jew drops. Enjoy your quick walk. We'll be here when you get back. Make sure you get back in the next 24 minutes for the start of opening arguments. Yeah, Ed Jobs, I'm sorry about the source audio. Not every clip. I didn't make the audio for every clip. Some of these clips were recorded from feeds where the source audio wasn't great. I try to boost them, but then it makes it a little crackly and it'll pop in your on your speaker. So just let me know if any specific clip needs to be played again. I can get the clip back and boost the audio a little bit. Karen doesn't have to prove anything. Yeah, she doesn't, but she's still screwed. Karen Reed, get your ass in prison right now, says the Sunken Grave. Hi, Sunken Grave. Good to see you. It's the final countdown. That's a great song. This concerns me that incorrect data was read. What about others that have been let off from this? Yeah, Ed Jobs, I am worried about. I don't understand why Lally let Reed's expert do the chip off initially. All right, I'm jumping down to the bottom because I'm ready to do a practice opening for you. Hi, Special Towel. Hey, Cookie Ramlaw. It's great to see you. Great. Hope you're streaming. I am Cookie Ramlaw. We're less than 23 minutes away from what should be the start of court today, although it could take a few minutes after for some procedural and housekeeping motions. But opening statements are on the way. Crime Cricket says, Karen picks glass out of John's nose but doesn't call 911. Damn good point. Karen never called 911. Karen doesn't watch her own interviews because she knows she did it. I agree. Crime Cricket, you're making very rapid pace towards becoming an honorary towel. Jewdrop says, if Karen's got nothing to hide, then take the stand. Karen tells on herself a lot, says Maui Swift. She's fooling no one, says Crime Cricket. How do you see glass in a snowstorm? I crack up every time you congratulate on her on that interview. I liked it, though. It was funny, Tom. I'm back already. Welcome. Good Jew drops. I finally got caught up on the comments. I skipped a lot of them because we don't have a lot of time today. The data in Karen's own words will convict her. I agree. No sea lioning or penguining or dolphining. That's true. Welcome Oliver Hernandez as a new subscriber. Apparently I get alerts about this now. I'm so thrilled to see those of you joining the channel, clicking like on the video. I don't understand what the hell's going on with this thing, but you all seem to figure out the YouTube quite well, and I know how to read the chat. So look at that. I'm a towel making progress. All right, so let me do my practice opening. I'm going to do a very condensed opening as if for the prosecution. And unlike for the defense, I'm actually going to go into details a little bit. And remember, this is no notes. I haven't rehearsed this. I'm just going to think of kind of a theme, and then I'm going to try to present to you how I would, now not how I imagine Hank Brennan will do it. He has a way more time to prepare all these exhibits. He gets to play things. But what I'm going to do is I'm going to give you my high-level overview of what I think a good argument for the prosecution would be during opening. Members of the jury, Karen Reed didn't just kill John O'Keefe at 12:32 in the morning on January 29th, 2022, after a night of drunken arguing and weeks of tormenting John emotionally, as the evidence will show you. Karen Reed did something so depraved, so grotesque, so disturbing as to shake the core of our shared morality as a people. Karen Reed left the man she proclaimed to love on the ground, as the evidence will show you, incapacitated after being struck by Karen's vehicle, to die from hypothermia in a blizzard. That is a fate worthy of no human being on this earth. Not to mention a man like John O'Keefe, who lived nobly and humbly in the service of others and his family. And members of the jury, my incredulity comes not from the fact that Karen did that grotesque act. There are people in society who commit grotesque acts on a daily basis. That is why we have a justice system, to adjudicate their responsibility for those acts. My incredulity comes from a place of reverence for that very justice system. And members of the jury, the evidence in this case will leave you with only one possible conclusion. Not only did Karen Reed, while drunk, with a blood alcohol estimated to be between 0.13 and 0.29 at the moment of impact, back her car into John O'Keefe, breaking her car's taillight in the process. But Karen Reed did then leave John on that lawn to die from his injuries. She did return to confirm he had died, as evidence from her own Lexus GPS system will show. And then she left John again. Why, ladies and gentlemen? Not to go render aid, not to call 911. You will see no evidence, members of the jury, did. Instead, members of the jury, you will see that Miss Reed set in motion a plan to avoid accountability for her actions that night by trying to obfuscate the real truth of what happened in those dark, cold moments at 12:32 a.m. in a blizzard to John O'Keefe. To blame anyone and everyone but herself for her actions in that moment. And members of the jury, Ms. Reed is charged with 3 crimes, 3 indictments. The first of those indictments is malice second-degree murder. And you will see evidence, members of the jury, that Miss Reed did, according to that evidence, not only engage in a reckless act, sorry, folks, we have video of the O'Keefe family coming into court. I'm going to bring it up on your screen in 1 second. We're finishing this opening. Not only did Miss Reed engage in a reckless act, but she did so in a way that any reasonably prudent person knew or should have known posed a strong and plain likelihood of death. And I will say to you right now, members of the jury, if that evidence, and it will, shows Miss Reed acted in a way that any reasonably prudent person knew would have posed a strong and plain likelihood of death, And if that evidence shows, and it will, that Miss Reed backed up her car with a blood alcohol level above the legal limit to 24.2 miles an hour and struck John O'Keefe and then left him to die, you must convict Karen Reed on the charge of malice second-degree murder, which, ladies and gentlemen, you will hear reinforced throughout this case, does not require Miss Reed intended to kill Mr. O'Keefe. Only that Miss Reed did an underlying act, to wit, backing up her car while drunk to 24.2 miles an hour while another human was around that car, that would have... Plug the microphone back in. Yeah, so the sound was showing as working on my end, folks. I'm not sure what was going on there, but the sound was working. Hold on, that was another interruption to my closing. So now let's finish the closing. And ladies and gentlemen, Miss Reed is also charged with OUI manslaughter. And if you find that Miss Reed was intoxicated at the time when she struck John O'Keefe, and that the evidence shows that Miss Reed did act recklessly when she backed that car into Mr. O'Keefe, then she is guilty of that indictment. And ladies and gentlemen of the jury, if you find that Miss Reed either once or twice or both left John O'Keefe after striking him with her car while drunk, then Miss Reed is guilty of the crime of leaving the scene of an accident causing death. And members of the jury, over the course of this trial, you will be presented with one inescapable foundational conclusion. Karen Reed didn't just kill John O'Keefe in those early morning hours in a blizzard. Her actions and lack of attempts to even call 911 led directly to his subsequent death from hypothermia and catastrophic brain injury. That is why, members of the jury, upon the conclusion of presentation of this evidence, when you are charged by Your Honor, when you hear closing statements, you will go into deliberations with only one thought on your mind. And it will not be just, was Karen Reed responsible for the death of John O'Keefe? It will be, how shall we hold Karen Reed accountable for the death of John O'Keefe? Thank you. Thank you for allowing me to do that. I'm so sorry if there was an opening, if I was going in and out. I'm a little perplexed because I can monitor the real-time audio on my end, and the real-time audio on my end is fine. So if you're having some speaker problems, I apologize about that. I am seeing the audio in real time, so please just let me know if for whatever reason the mic does that again in the future. Thank you for those of you who did listen to the opening. For those just tuning in, I was giving a mock opening there in the lead up to the Karen Reed and John O'Keefe trial, which starts in 13 minutes. But what I'm going to do for us now is I have video from Law and Crime of the O'Keefe family walking in to the courtroom. And I'm getting some feedback that the sound was okay, which is good. I'm thrilled to hear that. But even if you think you might be the only one with a sound problem, tell me. I'll take a look into it. I'll look at the back end, and the worst comes to worst, I fix something that isn't broken. But thank you all so much for your commentary on my opening. I really enjoyed it. It wasn't the perfect opening because I don't have all the exhibits Hank Brennan will use, but that's, I think, how I would generally frame it. I wouldn't even get into the consciousness of guilt stuff yet because you build to that. You don't do the motion in the beginning. But okay, hold on. Let me get this up right here. Oh, I'm hearing reports for Dixie Doodles that Alessi and Jackson broke the gag order. How so, Dixie Doodles? What do you got for us? Oh, you have me on a Bluetooth tower, Amber M. Nice. I'm glad I'm coming through clear. I'm trying to talk into the microphone. Dixie Doodles, if you got more information for us on this Alessi and Jackson situation, definitely let me know. I'm ready to follow up. Now, I'm going to bring something else for you all up right now. Hold on one second. I got this here. Take a look. Exclusive. It's not exclusive. It's from Law and Crime. And I appreciate Law and Crime. I enjoy being able to comment on their material. Let's take a look at the O'Keefe family arriving for opening statements. Hold on one second. Want to get you guys the full video. All right, hold on. I think this is where it jumped in. Oh, they really got us. All right, there we go. You can see Paul O'Keefe from the O'Keefe family. This is just minutes ago, folks. Just 5 minutes ago, the O'Keefe family arrived into court. That court officer calls me Grande for some reason. There's Miss O'Keefe, Miss Peggy O'Keefe. Margaret is her full name. There's Paul O'Keefe. Then it looks like we have members of the O'Keefe family. That noise you hear is from the audio feed, by the way. So they're not saying anything. There's Miss O'Keefe. Hold on one sec. I think this is clip-worthy. There it is, folks. The moment members of the O'Keefe family arrived into court ahead of opening statements for the John O'Keefe and Karen Reed retrial. There's Papa O'Keefe. That was the moment. Now, we will just pause that for a second, and then I will write that up as well. Hold on one second. I can't believe it was so peaceful for them walking in. That was absolutely wonderful. That was everything they deserved. They used to get tormented walking into court. John's parents for no reason, too. Here's the moment John O'Keefe's family, including Papa O'Keefe, Paul O'Keefe, and others, arrived ahead of Tuesday's opening statements in Karen Reed's retrial as to causing John's death. The peaceful quiet brings joy, brings solace to my heart. You earned this, O'Keefe. You earned this coming justice, O'Keefe family. All right, now here's the moment John O'Keefe's family, including Papa O'Keefe, Paul O'Keefe, and others, including his parents and brother, and others, arrived ahead of Tuesday's opening statement. All right, there we go. Perfect. Just perfect, folks. That was such a touching moment. I'm glad we all got to see that. If you're wondering, by the way, it is just moments until the expected start of the retrial for Karen Reed and John O'Keefe. Opening statements are on the way. I'm going to try to get you coverage of Karen Reed's arrival as well, so give me 1 second here as I get this uploaded. All right, let's see. Do we have the video of Karen Reed coming into court now? I'm going to jump ahead a little bit in the feed. Now, by the way, as I mentioned earlier, I have both the pool feed ready and the other feeds, so hopefully we will not miss anything. We're waiting in particular for Karen Reed's arrival, so hold on 1 second here, folks. Hold on 1 second. Karen Reed normally comes in a little bit after, but we cannot be guaranteed of that. Only about 7 people there, no supporters at all. Oh, who's that? Is that Mr. Reed? All right, looks like we have or is that, I can't tell who that is. Oh, looks like we have the arrival of the Reed family. See Karen Reed's parents. They are normally arrive a little bit ahead of Karen. See, they're walking in alone today. Let's see if there was any audio for that, by the way. No. Nope, they didn't put the audio back on, so. We are watching just minutes to go now, folks, until the start of the Karen Reed and John O'Keefe retrial. Yep, I'm keeping a very close eye on time. And don't worry, this trial can't start without us ready because I'm in the Zoom. So as soon as it starts, I'll be ready. All right, here we go. Ed Jobs has the clip of Alessi and Brennan potentially violating the gag order. This is big, folks. Karen Reed's lawyers are gagged, so let's see. What do we got? What do we got? Oh, it was apparently, that was last night. Huh? I saw a clip of that. I didn't realize that was last night. I had no idea. This could actually cause problems for Jackson and Alessi. Let me bring it up on the screen here. I want to make sure I find the original copy of it. But yeah, that is a big problem. That is a big, big problem. There's apparently video of Alan Jackson violating the gag order. Let me just bring this video up for you all right now. And just so if you're wondering, I am in the court Zoom. It has not started yet. As soon as the court Zoom starts, we're going to know before any other feed, any other pool feed is up. The court Zoom will go up, and that'll be our indication that we're about ready to go. Thank you for providing this clip, by the way. First of all, there is so much going on right now. I'm jumping from source to source to source. Let's see if we have Karen Reed's arrival. Oh, here we go, folks. Perfect timing, perfect timing. Here's Karen Reed's arrival. Thank you very much to Law and Crime for this. Oh, Karen Reed walking with no one, huh? All right, here's Karen Reed's arrival. All right, the Zoom has started, folks. We don't have a camera yet, but the Zoom has started. Should be any second now. And if you're wondering, there is no audio on this Law and Crime feed. They cut it, although we had audio earlier. Here's Karen Reed's arrival. Looks like no commentary. Somebody getting in there. So that was Karen Reed's arrival. Quiet. All right, so you can see they were actively controlling the audio, which is why we didn't get the feed there. But all right, so we're going to go to live on the Law and Crime feed, which should show us either inside the courtroom or outside. All right, and then the other thing we're going to do is, because this is exclusive, I'm one of the only people allowed to broadcast this, I can bring up this for you all. Now, do you see that? As soon as we get movement on that, folks, on that Zoom webinar, it is time to go. So I am going to put that up in the corner of your screen there. And that I'm going to do a dual feed, actually, during the trial, so you will be able to have two camera angles. But that Zoom is real time, okay? It's ahead of every other stream. And as soon as something happens, you all will see it. Now, we also have this video that Ed Jobs was kind enough to share. This is apparently comments from last night that may be Karen Reed's lawyers potentially violating a court-imposed gag order. So we're going to bring this video clip up. Give me 1 second here, because I just downloaded it. So I got to scroll through a bunch of files, but I have the video for us here. Where is this video? No, I had just downloaded it. 1 second. All right, I got it. Sorry for the slight delay. I just saw it. There it is. Okay, let's take a look. Oh, one of the courtroom folks.
Not only tonight, but every night, every day that you're doing whatever it is you do to support this team. I want you to know it's recognized. Every member of the defense team sees it, feels it, and loves it. Keep it going.
And then there were remarks from Alan Jackson as well. Now, as you can see up there, folks, we are getting exclusive footage right now of Karen Reed arriving into the courtroom, her lawyers arriving into the courtroom. You have to have special permission to broadcast this feed. It cannot go out on most channels, but you are seeing it now. Now, I want to... Oh, what did I do here? Oh, they turned the camera off. I was so excited. I bet it's the... I bet they're just redoing the camera, actually. Okay, hold on 1 second. And then, of course, I moved my own webcam frame while I was trying to do all that. No, that's not it. Where is it here? There we go. All right. There we go. Real-time video editing with GrantSmithEllis. But as I said, we have the courtroom Zoom up here. We have the live feed, and at this point, we are just waiting, folks. We are just waiting for court to start. You are not going to miss a minute of it. We are on 2 different feeds at once. We have the feed below from Law and Crime, and then up top we have the feed from the court itself. Oh God, you don't want to watch the Law and Crime feed. I have terrible news. It's a fan. It's the most dizzying fan you can possibly imagine. All right, so what I'm going to do for you throughout the day is, instead of making you watch that fan spin, we will just use this courtroom 25 as a placeholder, because watching that fan spin is tormenting. All right, folks, it's almost time. It's 9 a.m. This should be it. This should be it. I hope you are all ready. I hope you are all tuned in. We are about to see either some motion discussion, or we are going to see the start of the of opening statements. Now, if you're wondering, they are there. The parties are entering. We saw Karen Reed arrive. We saw her family arrive. We saw the O'Keefes arrive. They're all in the courtroom. We have a direct feed into the courtroom right now. You see the Zoom up on your screen. And then the other thing I will show you is, while you're watching, what I'm going to be able to do is, I have this whole setup ready for you. We're not going to watch the fan, but I have that set up for you. So when we actually go into trial, you'll be able to watch it this way. And then what I'm going to do as well is, I'm going to add this Zoom webinar here as an extra part of the feed while we're watching. So you will have 2 views while watching. We're going to do a simulcast. All right, so there you go. We have our simulcast ready. The Zoom has not yet started. We are not yet in session. If you're just tuning in, the Karen Reed trial as to the death of John O'Keefe is about to get started. We are sitting here. We are all waiting. The court Zoom has come on to show us that the initial session is about to start. We don't know if we're going to go right into opening statements. We are absolutely, though, ready to see what happens. And I'm not making you watch the spinning fan for a reason, because that is entirely unnecessary, and it makes people dizzy. Now, are we going to see objections during openings? Are we going to see a discussion before openings start about Hank Brennan's motion regarding what the defense can talk about? I'm going to be here with you through it all. If there are recesses, I'll stick with you. If there's a lunch, I'll stick with you. I will make sure I get my lunch before the lunch actually happens, so that I can be with you through the breaks. I'm a towel, and I'm grateful to have you all here with me. By the way, every 1.5 hours, this is a public information service. The best ways that you can help support Towel's public information service are twofold. One, if you're able to like or subscribe to the channel, apparently that's very, very helpful. Like the video or subscribe to the channel. And then also, if you want to help support this content, I have a bunch of things going on right now personally. I want to say thank you so much to everyone who's been reaching out with offers of support. I was able to see my family member over the weekend, and truly, God bless you all. It meant so much to me. It really, it was very important. But also, this trial is going to be a lot to cover. This is a revenue negative operation. And if you'd like to donate, I need to actually send my tech guy to the courthouse this week to hook into the live feed. So if you want to donate to support the stream, now's a good time to do it if you're interested. You only get reminders every 90 minutes on this kind of feed. It's a public information service, and if you want to support the work being done here, the donation info is in the YouTube description, or it's above my head. And Towel is grateful for everyone out there who considers supporting Little Towel's efforts. I do my best. Towels Assemble says, Def Otter, you're here. It's so wonderful to see you, friend. Towels Assemble. Let's go, says Crime Cricket. Oh, Def Otter was kind enough to drop the information in the chat. And actually, I have a new PayPal link, which is paypal.me. Actually, let me make sure I get this 100% right. It is paypal.me/GrantEllis. And I will go ahead and I will just drop those in the chat. You all are some of the nicest towel friends I've ever met in my life. You make me less anxious. You make me feel appreciated. And also, you're all wonderful towels, honorary towels. As we're waiting for court to come into session here, folks, by the way, you are going to be the first people in the world to see the Karen Reed trial come into session because we are actually in the raw feed from the court. I will take a look at our poll. How much time will Karen Reed serve for causing John O'Keefe's death? 8% of people say 0 to 3 years. 24% of people say 4 to 7. 27% of people say 20 to life. And 8 to 20 people say, 41% of people say 8 to 20. So it looks like our poll winner, although it does not have a majority, it does have a plurality, is 8 to 20. And that just jumped up to 42%. All right, now let me see what's going on here. Got flurry of different towel information coming in, waiting to figure out what exactly is going on. Oh, that's great. I was just getting some feedback on the stream is looking good, and someone sent a donation. Oh, dear God, I'm overwhelmed. Are you all trying to make Little Towel cry? You're giving me positive feedback and supporting my efforts. I don't know what to say. I'm a towel. Okay, of course I wouldn't miss this historic moment, says Deaf Otter. Never without my fellow towels. Blue Towel here, says Crime Cricket. Oh, Crime Cricket, you are absolutely elevated. All right, folks, we're back in the courtroom. No audio yet, but don't worry, we are in the courtroom. Towel is also monitoring closely the nauseating fan, but more importantly, we are in the courtroom. Now, there's no audio yet coming from that Zoom, but don't worry because we have both that option and we have the option from the actual main courtroom. So don't worry about that. And then we also can mute the Zoom webinar, and so we'll be able to watch that feed while Oh, look at that bigger screen. That's the screen Hank Brennan's going to use for exhibits. He put it right up. Oh, that's so good for the jury. He put it up above the heads of Karen Reed's family. That is genius. Ingenuitive. Brilliant. Towel loves it. Towel loves it. All right. Now, we are over on this side here, and we are now waiting. It is still, if you're wondering, a fan just spinning. But as soon as court is in session, we will know. Now, you can also see we have a direct line. Other channels don't have this. If you are watching on other streams, you do not have this view into the courtroom, and only certain people have permission to broadcast this. So we are getting the most available, up-to-date information from inside the courtroom. You are looking in the courtroom. Right now, these are live pictures ahead of any other feed. And then in the background, I'm not tormenting you with a picture of a fan blade spinning because you will get nauseous. But I will know as soon as that is in session. Now, we're not going to use the audio or the Zoom webinar because the feed isn't really attuned to the judge and the prosecutor and things like that, going up to the podium. We're going to go over to the law and crime feed from the pool for that, but Towel is ready. All right, hold on. The law and crime feed has now gone black. I don't know what that even means. It could mean we're about ready to go. All right, looks like we're getting very close, folks. The moment is about to be here. And let me just, oh, no, we're back to the fan on the law and crime stream. But that is all right. That is all right. You are going to be the first people in the world. I'm not gratuitously stretching here. We are literally waiting on the court. I don't know if Turtle Boy's there. We can't. The court feed just has Reed's family and supporters and whatever. But yeah, we'll find out. Towel. If I wasn't working on the final, I would be down there. But they're holding my seat for me till 11. If I can get my final done, like I'm sitting here with you all, so it's hard. I can't do commentary from court. I could broadcast it from court, but it would be too hard to do comment. You can't talk in the courtroom. So for me, it's more interesting during the breaks and the lunch. I don't want to go sit in the sub shop. I'd rather sit with you all and digest what just happened. So this is actually my preferred method of doing this, and I can smoke weed the whole time. Imagine if I was in court and I was like, I have a medical condition. I request the accommodation of smoking weed during trial. No, Grant, you may not smoke weed in the courtroom. But Judge. All right, here we go. They were testing the. Here we go, folks. Get ready. Here we go. Here we go. I hope you're ready for the moment. We could be about to go live. And remember, when we do go live, you're going to see me go off the screen. We're going to go over to the Law and Crime feed. What you're seeing now is a unique, exclusive. Towel has court permission to broadcast this view into the courtroom. I forget what I said, Eva, but it was probably funny. And by the way, you're not late. Court in Massachusetts oftentimes takes a few minutes to get going. But we are here. There's Karen Reed. Karen Reed makes an appearance in the courtroom. A lanking, I wouldn't call her a hulking figure, kind of lanky. She can be a towel, though. Not an honorary towel. She can just be a towel. All of God's children are towels. We must, whether or not we actually like someone, don't go too far to the left. Whether or not we actually like someone or not, Karen Reed is a human. And even if she is guilty and a sinner for causing John's death, it is important to remember redemption is possible. Okay? And even if she's guilty, the point is not like to kill her. The point is to put her in jail and make her repent for her sins. And the reason why we punish, by the way, is yes, part of it is just purely punitive, but then there's also rehabilitation, and then there's also deterrence, and then there's also this idea of like reform. You know, we're not just gratuitously locking these people away. We're trying to get them to reflect on what they did. So just remember that. Is defense team color coordinated today? All black. Yeah, well, okay, Eva, you make a strong point about like soulless towels, but like I'm not God. I don't ever want to be in that role of judging people's souls. So I have to just assume, even if people do bad things, that their soul is at the very least still subject to judgment by God. So I can't just assume that someone is soulless. I can see people do actions over a repeated period of time that might make me feel they're irredeemable in the eyes of God, but that's still just my interpretation. That doesn't mean I'm right, and I still should try to give, like, everyone is a human, unless you're some kind of like alien or like hybrid, I suppose. But even those people I would be very nice to, or I don't know if they're people, but I would be very nice to them, and I would be like, I would give them a chance and try to find the good in them. And just because someone has done very bad things, that doesn't mean they can't be reformed. It doesn't mean she's reformed now, but it doesn't mean she's incapable. You have to give them a chance, and then if they can't reform, then you'd go from there. Karen does try to be important. B in Chance says she's out of control already, making an entrance, and the other lawyer is sitting in the back. Yep. Dewdrop says she's a drunken psychopath. Eva says she's not even allowed in purgatory. Oh goodness. All right, Eva. I will. Maybe you're right. I don't know. And that is not a judgment for me to make. Dewdrop says rest in peace, John O'Keefe. Yes, that we can all agree on. And no. I dropped my coffee. By the way, it was empty anyway. By the way, you are not missing anything. You all on this feed have the direct live feed into the court Zoom. So about a minute before the Law and Crime and everyone else is ready to go, we are going to see that Zoom come into session. Yes, Ed Jobs. We saw John's dad walk in a little bit earlier, Papa O'Keefe, as he is affectionately known. Very good man. Very good man. Him and Peggy O'Keefe are raising the niece and nephew, the thrice orphaned niece and nephew, those poor kids. Amen, says Macy. Hopefully jail will bring Karen to repentance. 65 CJ5 says Karen will lose it. Turn on Jackson and blame everyone if convicted. Oh, sorry, hold on. Nope, I thought we were about to come into session. I thought that was some kind of warning beep. It is not. Also, warning. There might be beeps like that throughout the day. That's testing the sidebar beeping and things like that. I'm going to do my best to make you not have to listen to anything like that or stare at a nauseating fan. I'm going to sit here with you and try to make this, for what it is, as pleasant or non-tormenting an experience as it is as it can be technically. I make no guarantees about that. There have been situations where the pool feed audio just wasn't working. There have been situations where the camera wasn't working, but we have backup cameras on this stream. We have we'll do a dual stream. I'm going to actually get off the stream once it actually goes live, and then I'll be joining you for breaks. My name is GrantSmithEllis, by the way, and I'm a towel. I am so grateful that all of you are here watching. This is going to be a six-week process, but we are going to get through it together, and we are going to keep justice for John O'Keefe and the suffering of John's family in mind, and hopefully Karen will be held accountable. Blessings for the O'Keefe, says Jew Drops. B and Chance says, I'm waiting for my coffee to brew. Did anyone see her walk in? No crowds. I love the buffer zone. Yes, we can watch that clip if you'd like. B and Chance, Karen Reed did walk in. I don't want to go too far back here, but I have the clip up on YouTube, on my Twitter, I believe, actually. So let me just grab that for you. All right, where is it? Should be the most recent thing I posted on my Twitter, actually. So let me just pull up my profile here for you and see. I'm such a effective towel that I can. What I'll do is I'll just throw the different windows on hide, so I can just pop them up. Hopefully, it almost worked. I have to shrink one of the top ones. 1 second. All right, but let's take a look at this here. If you want to see Karen Reed walking into court, there was no audio, but I did get the footage. There it is, folks. The moment members of the this was John's family. There it is, folks. The moment members of the O'Keefe family arrived into court ahead of opening statements for the John O'Keefe and Karen Reed retrial. There's Papa O'Keefe. And I didn't actually post Karen's walk-in because there was no audio, so there wasn't actually anything to say. Oh, we're back with the Zoom. Hold on, let me get rid of that. Karen walked into no one, though. Like, I guess we could go back on the Law and Crime feed. Hold on 1 second. That's what I'm saving you all from, by the way. It's tormenting. This was Karen's arrival, I think. Hold on, that might have been actually when her parents arrived. Where is it now? Where is it? It just showed her, like, yeah, right here, right? Yeah, this was Karen's arrival. No, that was actually her parents' arrival, which means her arrival is a few seconds later. There was no audio, by the way, on the Law and Crime feed, but this was Karen's arrival to no one. She just walked down the street alone. There was like 7 members of the media there at the base of the stairs. All right, folks, we're about to go into session. I can't guarantee it. Oh, is that Judge Cannoni's chair? What is that?
This whole week.
Why are we just staring at a chair? Where even is that? Oh, it's the witness chair.
I'm right there.
That's actually very... Oh, no, it's the judge's chair. Wait, what? I've never seen that. Is that her chambers? What is that? Why are we looking at that odd angle? Is that in her chambers? That's not in the courtroom, is it? I've never seen that blue screen before. That's the coolest thing I've ever seen. How do we even get a camera in there? Why is there a camera in there?
All right.
Okay, here we go.
This court is in session. Please be seated.
2282CR117, the Commonwealth versus Karen Reed.
So, good morning. I see all counsel are present. I see all counsel are present. Nobody said anything to Mr. Clerk about needing to see me, but I received 4 motions over this weekend that I assume we need to at least talk about briefly. Commonwealth's motion regarding defense opening statement. I think the first 2 motions we can do quickly. I'm not issuing an order. Mr. Brennan, the defense knows third-party culprit will not be in the opening. If you think that their opening goes beyond it, you can object. Defendant's opposition to the Commonwealth's request For use of independent readers, because there's an objection, the defendant's motion's allowed. So you will not have an independent reader.
Present is
Is it
Mr.
fair
I.C.
to
All
say-
counsel are present. Nobody said anything to Mr. Clerk about needing to see me, but I received 4 motions over this weekend that I assume we need to at least talk about briefly. Commonwealth's motion regarding defense opening statement. I think the first 2 motions we can do quickly. I'm not issuing an order. Mr. Brennan, the defense knows third-party culprit will not be in the opening. If you think that their opening goes beyond it, you can object. Defendant's opposition to the Commonwealth's request for use of independent readers, because there's an objection, the defendant's motion's allowed. So you will not have an independent reader. Is it fair to say that the 3rd and 4th motions, Commonwealth motion to enforce compliance with court's April 16th ACCA discovery order and the Commonwealth's motion to preclude new expert testimony or alternatively to continue the trial date, that those motions will take a little bit of time, Mr. Brennan?
I don't think I'll be long in my argument.
I think that I need more information on one of them, and I think we'll do that at the end of the trial. I mean, at the end of today, we'll hear both these motions. Mr. Jackson, I did see that a list of text messages, 100 or so, is in your response to my order on Friday. Did you provide the text messages themselves?
No, Your Honor.
All right. In light of that and the fact that we don't have time, this juror's been waiting for some as many as 3 weeks now, I'm going to prohibit you from mentioning ACCA in your opening statement. And then we'll deal with this later today. I ordered those text messages and they weren't delivered. So we're going to be bringing the jury in. I'll be in recess for 5 minutes.
Heard on that, I think the court respectfully may be factually incorrect on a key assumption of what Your Honor is ruling.
5 minutes, Mr. Alessi.
Mr. Jackson's going to give you the facts. I would like to hear the law.
That's more than 5 minutes. I'll see you at sidebar. Come up here.
Holy shit. So who said Judge Canoni doesn't have stones? Who said it? You were completely wrong. Completely wrong. 100% completely wrong. Did you all just see that? Did you all just see what just happened? Was everyone watching the same thing that I was watching? The defense can't even mention ARCA. Can't even mention him in their opening. Oh, my dear word. Okay, I got to write this up. Hold on. We're doing this together. This is a collaborative trial. This is a collaborative towel effort here because we're all little towels. How is this even possible? I knew that was coming. I knew it was coming. All right. Breaking news. Judge Karen Reed's defense team has failed to comply with discovery obligations related to experts from ARCA, and Judge Canoni has just banned Reed's lawyers from mentioning ARCA during their opening. As a result, my word, what a twist! Oh my word! Third party culprit also banned. I gotta shift it to breaking. I must find alarm emojis for this. This is the biggest thing oh my dear God. Bob Alessi had a meltdown. This is the greatest thing I've ever seen in my entire life. How can things like this keep happening? How is it possible? I'm just a towel. Oh my dear God. Oh, my dear God, folks, do you remember when I said the worst thing possible to happen is when a judge forces you to change your opening either through an objection or whatever at the last minute? Oh, my God, this is the worst possible thing. It ruins you. You can't. Now you have to do a whole new opening. You can't. Oh, my God. Oh, my God. Oh, my God. I don't even know if I can appropriately frame the scope of the implications of this. If you're a lawyer and that just happened to you, run. Run for the hills. Run for the freaking hills. You're screwed. You're absolutely screwed. You're screwed to the fucking wall. I'm sorry for cussing. You can't. What can you do? You can't. How are you going to get out of this? Now you have to make a whole new opening in 5 minutes, and the judge is like, we're making the jurors wait. We're not debating this. Listen, there better be something. The Reed defense better have a fucking rabbit in their hat to get out of this, because otherwise Alan Jackson just got fucked. Listen. There are some things where people are like, oh, that was a bombshell because of tone or whatever. No. You want to really ruin someone's day as a lawyer when you're a judge, you change their opening at the last moment. Yes, she can change her mind, Cookie Ramlaw, but not in. Listen, Bob Alessi better have something really good, really good. It's not about giving in, Dewdrops. Bob Alessi has to go up there and say, I have this, and therefore we should be able to mention ARCA. He better show her something like they can get out of this. I'm not saying it's impossible, but he better have something big. That was a huge moment. Oh my God, I cannot believe that just happened. That was an absolutely huge moment. Wow. Yeah, everybody in the comments saying they're hoping Judge Cannone doesn't give in. I agree, but it's not just a matter of giving in. It's a matter of the law. He either goes up there, Alessi, and presents something that gets them out of this, or he doesn't. It's a zero-sum equation. Oh, wow. And by the way, we're also watching the Zoom here, folks. We're watching the Zoom so that we are going to be the first people to see it. We are going to be the first people to see when they come back into session. Oh, looks like the text must be pretty damning. Jackson's not happy. Yeah, no, did you see Jackson freak out? Okay, folks, hold on. We're going to recess. The defense is back. Hold on, we're going to see it. You're going to see it on the Zoom, and then you're going to hear it first. And then, hold on, you're going to hear it come over the law and crime. All right, so as you notice, by the way, so this is the one really good spot. So we're going to recess. She said 5-minute recess, and then they lost. She didn't come back and change her mind. Oh, my dear God. Oh, wow, folks. Could it get any bigger than this? 5 minutes, and the best part of this is we're going to get like a 30-second heads up because we're going to see them come back on the Zoom. So 5 minutes. That was unexpected. How do you properly react to a bombshell like that? They're going to go in that hallway and absolutely freak the fuck out. I'm telling you, I'm not a lawyer, but I'm in law school, and I know what it's like to prepare and how you have to do this kind of thing. Like, it has to be it's all like very rehearsed, very researched. That was the worst sanction the defense could have got. That was fucking brutal. Listen, we all knew it was coming, okay, but that was as brutal. I've never seen anything that brutal in my life. There are some really brutal procedural things that judges can do to people. That was unrepentant. That was just, you're fucked. And as a judge, you're fucking them over by doing that. Like, and it's a penalty, right? So like you don't feel bad for them. They brought it upon themselves. That Judge Cannone people have been waiting for her to put her foot down. No one will ever be able to say ever again that Judge Cannone didn't put her foot down. That was her putting her foot down in an unbelievable way. Hi, Emma. Hi, Sema. I hope you just saw what happened. That was absolutely unbelievable. I don't think anyone tuned in late. If someone does say they tuned in late, I'll do a replay. But oh my dear goodness. What a moment. What a moment. I could not believe that just happened. That is the worst possible thing to happen to a defense attorney and prosecutor. It cannot get worse than that. You've spent all this time preparing your opening. You're already boxed in because you can't use third-party culprit. And now you can't mention ARCA. Oh, Sema, we shall watch this clip. We shall watch this clip. You must see this. That was incredible. It was one of the most incredible things I've ever seen in my entire life. All right, hold on a second. Got to bring that window up. Okay, now I got to bring this window over here. All right, good. No, wait, was that the wrong one? No, that's the right one. Where is it now? Come on now. All right, here we go. Where is it? Where is it? A towel. All right, hold on one second. Now keep an eye on your screen here, folks. We're going to rewatch. We're in at recess, so we have just a little bit of time to rewatch this. Just a little bit. Hold on. Hold on a second. Tal's bringing the clip up for you. It was a moment. It was a moment unlike any other moment. All right, come on. Stop being a towel. No, you're a towel. I am a towel. That's true. All right, there we go. We're going to one moment. Here it is.
Alternatively, to continue the trial date, that those motions will take a little bit of time, Mr. Brennan?
I don't think I'll be long in my argument.
I think that I need more information on one of them, and I think we'll do that at the end of the trial. I mean, at the end of today, we'll hear both these motions. Mr. Jackson, I did see that a list of text messages, 100 or so, is in your response to my order on Friday. Did you provide the text messages themselves?
No, Your Honor.
All right. In light of that and the fact that we don't have time, this juror's been waiting for as many as 3 weeks now, I'm going to prohibit you from mentioning ARCA in your opening statement. And then we'll deal with this later today. I ordered those text messages and they weren't delivered. So we're going to be bringing the jury in. I'll be in recess for 5 minutes.
Heard on that, I think the court respectfully may be factually incorrect on a key assumption of what Your Honor is ruling.
5 minutes, Mr. Alessi.
Mr. Jackson couldn't give you the facts. I would like to be able to go off that.
That's more than 5 minutes. I'll see you at sidebar. Come up here.
And then they went to sidebar and that was it. Okay, so it was that ARCA, it was that Reed failed to comply with Judge Canoni's order, and she lost her ability to mention ARCA in opening statements. I mean, it's as simple as that. That's what happened. That's crazy. That is wild. That is the worst, and I was saying, Sema, that is the worst sanction that can be imposed by a judge on an attorney like that, because what it does is it kneecaps your whole opening. You spend weeks preparing an opening. It involves a theme. You have to sketch it out. It has to have this schema. It has to have a structure. It has to flow. Every word is practiced. And now she just cut Alan Jackson off at the legs. And I know he didn't win because she said, okay, I'm seeing movement. Nope, that's just a clerk. I know that Jackson didn't win because Judge Canoni was like, okay, we're going to our recess and then we're going to start. Oh my God, that was huge. It's not taking a while, Jew drops. It's just a 5-minute recess to bring the jury in. How can you have a motion to continue the trial after the jury has been sworn in? Trevor McIntyre, because the motion was made a month ago, Judge Canoni just said it can be revisited up until April 28th. So she's asking if it's going to be revisited. I thought Aiden was not in the he was not in the media lottery last week, Courtney Myers. Wow, 100 texts between ARCA and Reed's team, and they didn't actually disclose them. It was just a list. I don't understand why they're having a 5-minute break. They're bringing the jury in. Please dumb it down for me, Grant, says Emma Sema. So it basically means that Jackson has to change his whole opening because Reed's defense was ordered by Monday or last Friday or Monday. It was either Friday at 5 p.m. or Monday at noon to turn over all text messages between Reed's lawyers, Reed and ARCA. They didn't do it. Instead, Reed's lawyers turned over a list of when the text occurred. Judge Canoni said, did you turn over the text themselves? Reed's lawyers said no. Judge Canoni said, your sanction is you can't mention ARCA in opening. Best ever moment, says Barb. I agree. This is fast, a pantomime. It is very fast. They didn't comply with Judge Cannoni's order. Yep. I know, being Chance. What the hell was the defense thinking, says Crime Cricket. I have no idea. They fucked up. And I don't think Alessi got them out of it because Judge Cannoni just went to the recess, and now we're going to come back and the jurors are going to be there. They should never have been allowed anyway. I agree. Thanks, Courtney Meyer, says Grant. Happy to help. Justice for John O'Keefe and his family, says Dewdrop. Much deserved slap down, says Crime Cricket. Wham! Sema says, thanks, Grant. Happy to help. Jack in the Box, Alessi. Thanks, Grant. I'm just nervous. Must be incriminating if they didn't provide them, says Eva. Dewdrops posts a bunch of blue hearts. Yes, you're all correct. This is wild. Out of everything that I thought was going to happen, that is not what I thought was going to happen. I'm a pretty prescient towel in some sense. I was not expecting that. Like, that is such a self-enforced error. It's like Serena Williams in a Grand Slam final trying to get number 24 to beat out Margaret Court. She just makes so many self-enforced errors, she never got it. That's what the Reed defense just did right there. Oh, Courtney Myers asks where you can send monetary contributions. Okay, this breaks my rule of doing donation reads every 90 minutes, but I'll put in the chat the way you can donate. That is first of all, it's such a kind offer for you, and second, I'm actually not doing that well, but I was able to see my family member over the weekend, which made Little Tal very, very grateful. But yeah, I'll put my donation info in the comments, and God bless you all. You can also find it in the description and then in the above my head sometimes on the stream. But the other thing I want to say is we are in a recess right now, and we are waiting for opening statements to start. That was an absolutely bombshell moment. Just bombshell. You can't retool in 5 minutes. You can't retool. Macy says, do you think Jackson will force Brennan to make an objection by trying to mention third party or ARCA? He could, but he does it at his peril because Judge Cannoni is going to be glaring at him, and she's just going to stop him. And it's worse to get stopped in the middle of your opening. I don't know if you heard me do the opening earlier. I was getting stopped and picking it up, but it just sounds fragmented and broken. I think because people were saying my mic was going in and out. But when you stop for any reason, it's an opening is a story. So anytime you get stopped, as long as the prosecutor is not overruled, anytime you get stopped, you're screwed. Oh, Dewdrop says, we love you, Grant. Oh, I'm happy to help. Macy, I bet the FKRs will be losing it and calling it corruption. My pleasure, Courtney. Justice for John O'Keefe and his family, says Dewdrops. Oh, thank you, Def Otter, for helping to share the information. I made sure I got a comment in there, too. I'm a bit pissed Judge Cannoni didn't allow the readers. Well, at least it was over. The defense objected, so the case law must say that means Judge Cannoni should say no. So that's what she did. They have no true defense, so it's all smoke and mirrors and shenanigans, says Macy. I agree. The defense deserves it. Let's see how skilled they are now. Defense has no defense left. Yeah, I don't know that was their whole opening, folks. That's what I'm saying. How do you open now? Do you waive your opening? Do you plea? What the fuck do you do? I don't know what to do. That's true. SEMA is FKR, but SEMA is always very respectful, and there's no rule against having any viewpoint on this channel other than don't be discriminatory, don't be derogatory, and don't sea lion. Yeah, so if folks were wondering when was Judge Cannoni going to step up and drop that hammer, it just got dropped. You can't drop a hammer harder than that. It's impossible. It's that, like, you have to understand, like, a legal sanction isn't getting referred to the BBO. Like, that's one part of it. A legal sanction is you getting screwed tactically. Like, the worst thing, a judge knows the tactics of the trial better than you as a lawyer. And the worst thing a judge can do is kneecap you like that. That is like the corporate death penalty. That's the worst thing that can happen to you procedurally as a lawyer. That is it's just as bad as humanly possible. That's why I'm saying I don't even know if people truly understand. I know a lot of you who watch this channel are like, oh, Tal is, pressy and his analysis is good. But I don't know if even I'm doing justice to how devastating it is to have that happen to you right before your opening. I mean, yeah, it should make, if you are a supporter of the rules of the court and the justice system and Judge Cannoni finally stopping the defense, this was a big moment. This whole opening has got to change. Listen, the odds just skyrocketed for a conviction. Skyrocketed. That was like the seminal moment. That was before the trial even started. It's impossible for a moment to have more weight than what we just saw. And yeah, it's more than just being upset at Karen Reed's lawyers. It's punishing them tactically. It's punishing them in a way that nails them to the cross. Like, you can't get out of this. You must now go into opening. You have however many minutes. You must go into your opening. Maybe she gave him, like, I think out of fairness, she might give him a little more time to retool the opening. But read the commentary, folks. Every single person. Oh, it's a 20-minute break. They're due back at 9:47. So listen, she gave them 20 minutes. 20 minutes to retool their opening. You can't retool an opening in 20 minutes. You can't. I'm telling you, I did it on the fly earlier, okay, with no notes. It was a fine opening thematically, but it wasn't. These have to be 45 minutes long. They have to be really well done. You have to keep a jury's attention for 45 minutes. It's really hard. And now Alan Jackson has this whole thing he printed out. He's got to go through and strike. He's got to control F ARCA, strike every, and not just ARCA, but every argument that derived from ARCA. He's got to strike it. And then he's got to strike, he didn't have any third-party stuff, but he's got to strike all the conclusions from ARCA. Listen. If that just happened to me as an attorney, I would quit. I would quit the profession. I would never come back. What the, just, oh my God. What? Wait, what? Oh my dear God. Okay. We got to stop overwhelming Little Towel. Do you want to make Little Towel cry? With your support. So I don't always read donation names directly because people don't always attach it to their YouTube name. But Courtney, you said in the chat you sent a donation. You did send a donation, and sometimes I forget to look at my phone, and I'm not doing this gratuitously. I'm just saying thank you because I'm a Little Towel, and I'm awkward about this kind of thing, but it truly makes such a big difference to me, and I'm very grateful. So thank you for supporting Little Towel's efforts. I will try to keep my composure. So if you're just tuning in, we have 9 minutes until what could be the most intense series of events you could possibly imagine related to the Karen Reed trial. The Karen Reed defense has been banned from mentioning ARCA. They're only real expert witnesses that have any, even though they don't have much merit. The witnesses related to accident reconstruction, because Karen Reed's team failed to comply with reciprocal discovery multiple times over the course of this trial, including hiding payments and communications with ARCA until 2025 from the court. Reed's lawyers have already been sanctioned with a finding of fact on the record a few months ago that they had indeed withheld that information related to ARCA. And now, 20 minutes before opening arguments, Judge Canoni has sanctioned Reed's lawyers and banned them from mentioning ARCA in their opening because they didn't disclose all of the text. They apparently sent a list, but not the actual content of text messages between Reed's team and ARCA. Boom. Oh my God. They were withholding hundreds of I see Judge Canoni on the Zoom. Okay, folks, it's going to be earlier than we thought. Get ready. Everybody get ready. Towels ready. I'm here with you. You see Judge Canoni on the Zoom. I see Judge Canoni on the Zoom. It's time. Now what I'm going to do is I'm going to switch over. Okay, here we go. Switching over, folks.
You are muted. You are unmuted.
Main camera's only a few seconds behind, folks. Don't worry.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Canoni, the Justice of the Superior Court, now holding in Dedham, within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
2282CR117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record? Morning, Your Honor. Adam Lally for the Commonwealth.
Morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Morning, Mr. Brennan.
Morning, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. Good morning, jurors. So I have 3 questions I have to ask you because I haven't seen many of you for a long time, and we do appreciate that you are all here ready, willing, and able to get started early. We sometimes have to deal with a few things before bringing you in, but we do appreciate your patience. So those questions are, were you all able to follow the instructions and refrain from discussing this case with anyone since we last saw you? Everyone said yes or nodded affirmatively. Were you also able to refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we last met? Everyone said no or shook their heads. Thank you very much.
Jurors, can I have each of you stand and raise your right hands, please? Do each of you solemnly swear you shall well and truly try the issue between the Commonwealth and the defendant according to your evidence and according to the law, so help you God?
Yes.
Thank you. You can have a seat. Jurors, hearken to these indictments. Karen Reed of Mansfield in the county of Bristol, on or about January 29, 2022 at Canton in the county of Norfolk, did assault and beat John O'Keefe with intent to murder such person, and by such assault and battery did kill and murder the said John O'Keefe, and is guilty of murder in the 2nd degree and not in the 1st degree in violation of Massachusetts General Law, Chapter 265, Section 1. 002, Karen Reed of Mansfield in the county of Bristol, on or about January 29, 2022 at Canton in the county of Norfolk, did operate a motor vehicle upon a way as defined in General Law, Chapter 90, Section 1, or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, with a percentage by weight of alcohol in her blood of 8/100ths or greater, or while under the influence of intoxicating liquor, and did so operate said motor vehicle so the lives and safety of the public might be endangered, and by such wanton and reckless conduct so described to cause the death of another person, to wit, John O'Keefe, in violation of General Law, Chapter 265, Section 13 and a half. 003, Karen Reed of Mansfield in the county of Bristol, on or about January 29, 2022 at Canton in the county of Norfolk, did operate a motor vehicle upon a way or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, and without stopping and making known her name, residence, and registration number of her motor vehicle, to go away to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to John O'Keefe, such injuries having resulted in the death of said person in violation of General Law, Chapter 90, Section 24, Subsection 2, Subsection A and a half, Subsection 2. To these indictments, the defendant has pled that she is not guilty, and for trial has put herself upon the country which country you are, and you are sworn to try the issue. If she is guilty, you are to say so. If she is not guilty, you say so and no more. Jurors, hearken to the evidence.
All right. Thank you. All right, members of the jury, I'm about to make some preliminary remarks to you to acquaint you with some of the legal principles, procedure, and terminology that you may inquire during the course of this trial. These comments are not intended to be a substitute for the more detailed instructions on the law that I'll give you at the conclusion of the case. So you'll remember that this is a trial of a criminal case. Ms. Reed is charged with 2nd-degree murder. She's also charged with manslaughter while operating under the influence and leaving the scene after causing personal injury or death, the indictments that Mr. McDermott just read to you. I'll describe the law in detail at the end of the case and the elements of these charges, but briefly, murder is the unlawful killing of a human being. In order to prove Ms. Reed guilty of 2nd-degree murder, the Commonwealth must prove beyond a reasonable doubt that she committed an unlawful killing and that it was done with malice. In comparison, manslaughter while operating under the influence is an unintentional, unlawful killing caused by wanton or reckless conduct while under the influence of intoxicating liquor. And leaving the scene of an accident after causing personal injury or death requires the Commonwealth to prove that Ms. Reed knowingly collided with John O'Keefe, that she caused him injury or death, and then she fled the scene. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, please remember that Ms. Reed starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. It is merely a formal manner of accusing a person of a crime and bringing that person to trial in the Superior Court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence alone requires you to find the defendant not guilty. The law never requires a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I am sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to stop making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, please consider them as individuals rather than as members of a particular group. And finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, when I finish these initial instructions, the Commonwealth, Mr. Brennan, will make his opening statement. Then Ms. Reed's lawyer, Mr. Jackson, can choose to make an opening statement or not, because, again, remember, the defendant has no burden of proof and doesn't have to prove anything. Her lawyer does not need to make an opening statement. An opening statement is a summary of what the lawyer expects the evidence at trial will be. It is intended simply to introduce the main issues in this case to you. Next, the prosecution will introduce evidence in support of the charges in the indictments. After that, the defendant may present evidence on her behalf if she wishes to do so, but she is not obliged to do so. Remember, the burden of proof is always on the Commonwealth to prove that the defendant is guilty. The law does not require any defendant to prove her innocence or to produce any evidence at all. After all the evidence, each side will have an opportunity to offer you closing arguments about what conclusions you might draw from the evidence. Like the opening statements, the closing arguments are not evidence. They're merely intended to help you understand the respective contentions of the parties. Finally, after all the evidence and the lawyer's arguments, I will instruct you in detail on the principles of law which you are to apply in your deliberations when you retire to consider your verdict. Your verdict must be unanimous. Let me speak briefly about our respective roles in this case. As the judge, my responsibility is to see that this case is tried orderly, fairly, and efficiently. It's also my instruction to decide any questions of law that come up during the trial and to instruct you about the law that applies to this case. It is your duty to accept the law as I state it to you, whether you agree with it or not. Your function, you folks are the most important people in the courtroom. Your function is to determine the facts. You are the sole and exclusive judges of the facts. You alone determine what evidence to believe, how important any evidence is that you do believe, and what conclusions all the believable evidence leads you to. You will have to consider and weigh the testimony of all the witnesses who will appear before you, and you alone will determine whether to believe any witness and the extent to which you believe any witness. You can believe all of what a witness says, some of it, or none of it. It's entirely up to you. It is part of your responsibility to resolve any conflicts in testimony that may arise during the course of the trial and to determine where the truth lies. Ultimately, you must determine whether or not the Commonwealth has proved the charges beyond a reasonable doubt. The lawyers have their own important role in this trial. They are, of course, advocates. Their job is to bring to your attention the evidence and arguments that best support their position. They may also object to evidence offered by the other side that may not be admissible under our rules of evidence. Similarly, we may engage in sidebar conferences out of your hearing. These sidebar conferences are not intended to keep secrets from you, but to allow the lawyers a little more time to argue their points so that I may rule on what you may consider as evidence. If I agree with an objection to a question, the term I will use is sustained. You are to disregard that question, and you're not to speculate as to what the answer might have been. In the same way, you're to disregard any evidence that I tell you is stricken from the record. If I reject or overrule an objection, I'll permit the witness to answer. This happens a lot. You'll find this during the course of the trial. If I let the witness answer the question, but you're not allowed to give the answer any more weight than you would have no objection had been made. Please do not hold it against the lawyers if they make an objection. That's the important part of the lawyer's job. The lawyers have to let me know when there is a potential issue about the admissibility of certain evidence under our law. You must decide this case solely on the evidence presented in this courtroom. This will include the sworn testimony of witnesses and may also include any exhibits that are admitted into evidence, any facts that I tell you have been agreed to by both sides, and any facts that I indicate to you may be taken as a matter of common knowledge. Questions to witnesses, no matter how artfully phrased, are not evidence. Only the answers which you receive from the witnesses who are testifying under oath are evidence. So, if a witness is asked, isn't it true that after you learned that your uncle left you money in his will, you poisoned him? And the witness's answer is no. Based solely on that question and answer, there is no evidence that the witness has an uncle, that the uncle had a will, that the uncle left the witness money, that the witness knew that he did, or that the witness poisoned him. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I may make, the lawyer's openings and closing arguments, and any comments they may make are not evidence. I will emphasize this point because it's crucial to your understanding of your role. If the lawyers or I make any comments during the trial, those comments are not evidence, and your verdict must be based only on the evidence. In Massachusetts, lawyers are not allowed to make comments other than during opening statements and closing arguments. They are permitted only to ask questions, but they cannot comment on the witness's answer. If a lawyer comments, you are to disregard it. In this way, communication in the courtroom is not like everyday conversation. If a lawyer seems to agree or disagree with an answer, or if a lawyer expresses confusion or any other reaction or emotion, you are to give no weight to what that lawyer does. In the interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. In a similar way, any comment I make is not evidence. But of course, you can't disregard what I say when I provide you with instruction or direction. Remember, however, I'm the only one who can instruct you or direct you in any way. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. Now, in this case, I anticipate that we will go by bus to an area that you'll hear about during the trial. You may consider as evidence anything that you observe about the layout of the area, including the scene of the alleged crime when we do go there. I will give you further instructions prior to our leaving for the view. Now, in this case, I'm going to allow you to take notes. Any jurors who wish to take notes during the course of the trial, except during opening statements and closing arguments, because remember, those aren't evidence. If you wish to take notes, you may do so once the evidence begins. Notebooks and pencils will be provided to you. The notebooks will be collected each day, and they'll be locked up, and they will remain confidential, and they're destroyed at the end of the trial. Nobody sees them. You're not required to take notes. The choice is entirely up to you. Some jurors may feel that notes are helpful, particularly if the case involves many witnesses or complicated issues. Notes also can help you remember specific testimony or evidence, such as times, places, dates, names, relationships, events, distances, things like that. Other jurors may feel that note-taking is a distraction and may interfere with hearing and evaluating the evidence. If you do take notes, I suggest you keep them brief. They are not and cannot be considered official transcripts of the trial testimony. However, bear in mind that although the court reporter is recording everything that transpires here, we do not have the capability of providing you with a transcript of the testimony at the conclusion of the trial. So you'll have to rely on your own memories of the testimony, perhaps supplemented by your notes. Regardless of whether or not you take notes, please remember that how a witness testifies may be just as important as what he or she says. Therefore, your observations of the witness's appearance and demeanor on the witness stand may play an important part in your assessment of his or her credibility. Do not let note-taking distract from an appreciation of all the evidence. If you have any trouble hearing or seeing during the trial, please raise your hand or let a court officer know, and we'll make any necessary adjustments. We generally take a morning recess at around 11 o'clock or so, but if you need a break at any other time, please raise your hand and let a court officer know. We'll take a break. If you need to communicate with me during the trial, and I'm not suggesting for a minute that you need to, but if you do, please speak with the court officer or give the court officer a note to bring to me. Now, I'm going to address the issue of public interest in this case again, and the duty of this court and this jury to adhere to the rule of law, because it is so very important. John Adams famously said that we are a government of laws, not of men, and that the law must be deaf as an adder to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with great intensity, but unbound by any oath or even any inclination to follow the actual evidence. The law works in a different way, and the difference is crucial to our system of justice. This jury, selected for this trial, will hear and judge the evidence. You will decide what the facts are. Where the evidence is contested, you will determine where the truth lies. Ultimately, this jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this trial will be decided by you. An independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So, while public comment will likely continue, you must ignore it so that the rule of law will be upheld. Which leads me to the fact that it is very important that during this trial, until you deliberate, you must not discuss this case with anyone. This includes your family and friends, and even your fellow jurors. Nor should you allow anyone to communicate with you about any specific aspect or any aspect of this case. You must not conduct any independent research about this case, the matters in this case, and the individuals involved in this case. In other words, you must not consult the internet or do anything else to try and find out information from any source outside the confines in this courtroom. Please be very careful with your social media use. Please do not use X or Twitter, Facebook, Instagram, or Reddit. Though you may never have seen anything about this case before on your social media feed, you cannot control what may pop up. You should also remember that use of these platforms can be public and traceable, and any searches undertaken or information received by you can and likely will be discovered. So please be extremely cautious. If you inadvertently see something about this case, please disregard it and let us know. As best as you recognize them, please have no contact with any of the participants in this trial or anyone associated with either side, including the lawyers. Please do not visit any locations that may be mentioned during the trial. We'll go on a view, as I told you, and I'll discuss that with you before we go. Remember, you were instructed that you must not, and you assured us that you would not read, watch, or listen to any account of any aspect of this case in any news media, social media, or from any other source. It is critical that you follow that instruction. Finally, please continue to keep an open mind. I know that you will try this case according to the oath that you've just taken as jurors. When you took that oath, you promised that you would well and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. If you follow that oath, approach this case with an open mind, and make your decisions fairly and without prejudice or bias or sympathy for anyone, then you will arrive at a true and just verdict, and that's all we ask of you. So it's now time for the opening statements. Mr. Brennan.
Thank you, Your Honor. At 6:04 a.m. on January 29, 2022, the alarm bell sounded in the Canton Fire Department. Firefighter paramedic Timothy Nuttall knew what that meant. His heart skipped a beat, he raced to his equipment, and he picked up his bag, which was... There was a sign and a signal, and then there was a voice commanding that there was cardiac arrest. The most serious of calls for a firefighter and paramedic, that means that a person's heart has stopped. He didn't know who it was. He didn't know where it was. He took his bag. He had just gotten to the station, and he rushed to the ambulance. He was one of the most senior paramedics that morning. Another paramedic, Anthony Flamati, would be running this mission. He jumped in the back of the ambulance, the door shut, and they headed off to 34th Fairview Road. As they drove, firefighter Nuttall could not see anything. He couldn't hear anything other than the engine of the ambulance. He could feel it sliding across the road. It was near blizzard conditions. He calmed himself, he steadied himself. This is what the firefighters and paramedics are trained to do, to focus. And he focused on his task. He looked around the back of the ambulance to make sure all the tools were in place. The ambulance was meticulous as well. This was Anthony Flamati's ambulance, and it was well stocked. He calmed himself, and he thought about what was going to happen. What should he be looking for? What is his next steps? He played the scenarios through his mind, and every calm was above him. As the car pulled up to 34th Fairview, the ambulance, he stood at the back door, the doors open, and he stepped out into bedlam. He could hear a woman screaming and shrieking, the cold, hard air slapping on his face, and the wind, blizzard conditions swirling around her. You will hear him tell you how he trudged towards those screams in the darkness to snow, and when he got there, he saw 3 women surrounding a man lying, not moving on the ground. He walked up to the man, and he reached down, and he tried to find any signs of life, pulse, anything, and he found nothing. And he got up and he walked over to the woman, and he walked over to that defendant, Karen Reed, and he told her that he thinks that that man is gone. And then he heard the yell from Anthony Flamati, the chief, and he said, "Come back, let's go." Because you'll learn that in the cold, even if somebody's heart stops, even if they're presumed to have passed, sometimes you can still save a life. So you'll see on a dash cam video, you'll hear through testimony, he went back to that man, who was John O'Keefe. He went back to him, and that crew, coordinated effort, they did everything they could to save his life. They got on their knees, they began CPR, and firefighter Nuttall will explain, as he knelt over John O'Keefe, he looked up, and the defendant approached him, and you'll see it on the video. Now, he wanted any information, because when you're trying to save someone, you want to know, are they on drugs, medication, do they have a heart condition? And he looked up at Miss Reed, and he said, "What happened?" And you'll hear her words through firefighter Nuttall. She said, "I hit him, I hit him, I hit him." And it was at that time, through the words of the defendant, that she admitted what she had done that night, that she hit John O'Keefe. Now, those words didn't mean anything to firefighter Nuttall. They weren't in context, they didn't reconcile with the injuries, it didn't help him in his treatment, so he ignored it. Now, firefighter Nuttall is not a police officer. He is not an investigator, he is not a detective. He's a first responder. And so he takes that information, it was useless to him, he continues to work on John O'Keefe, trying to save his life. You'll see the team put him on a stretcher. And when they lift him from the ground, even though there is snow accumulating, underneath John O'Keefe is simply grass, hard, brown, frozen. And beneath his body lay his cell phone. They bring him to the ambulance, and while they bring him to the ambulance, you'll see on the videos that other first responders speak to the defendant. One first responder, Mr. Flamati, she will say, "I hit him, oh my God, I hit him." And then she was interviewed or asked questions for background information, not a criminal investigation, just background to try to help John. And she was asked questions about his background, and during that conversation, you won't hear her see the defendant was a person by the name of Jen McCabe and a firefighter McLaughlin. And she tells Fire McLaughlin, the third first responder, "I hit him." They bring Mr. O'Keefe to the Good Samaritan Hospital, and his body is cold. The doctors work feverishly. They treat him, trying to save him. They try to warm his core. And unfortunately, firefighter Nuttall's first instinct was accurate. John O'Keefe passed. So why are we here today? We are here today because John O'Keefe was killed by the actions and conduct of that defendant, Karen Reed. You will learn through this case, through facts, science, and data, you will learn that on January 29th, 2022, when the defendant and Mr. O'Keefe were in front of 34 Fairview Road, all the way to the left side in a dark corner near a flagpole, you will learn that Mr. O'Keefe got out of the car. He got out and he stood by the side of the road after an argument with the defendant. That argument, that anger fueled by heavy intoxication, you will learn from the science and data as he stood by the side of the road, the defendant in her SUV drove away. She drove at least 35 feet away. The argument was over. It had ended. But then she stopped. She stopped. She put the Lexus into neutral, and she waited for 2 seconds. And the facts and the science and data will tell you that despite the fact the argument was over, she then put the Lexus into reverse, put her foot on the gas pedal, and began to press. Not 25%, not 50%, up to 75% acceleration. There was a light dusting of snow. The Lexus tire spun backwards. She went backwards at least 70 feet. She clipped John O'Keefe. He fell backwards, hit his head, broke his skull. And there he lay at the corner of Fairview Road, on the ground, lying on top of his cell phone, alone. And then the defendant will later tell that when she left, he didn't look mortally wounded. Yet he was. And she simply drove away. Now, before I tell you about the data and the facts and the science, and I walk you through that, I'd like to tell you a little bit about John O'Keefe. John O'Keefe was a young man, a local kid, very well liked, loved. John O'Keefe is the son of Peggy O'Keefe, John O'Keefe Sr., and the brother of Paul O'Keefe. Grew up in Canton, worked hard, he became a police officer. But what you're going to learn, the fact that he worked for the Boston police officer, as a Boston police officer, was just a fraction of his life. It was a small, really unimportant part, because the biggest part of John O'Keefe is he was a family man. Not in the traditional sense. You see, John O'Keefe never had biological children. John O'Keefe was never married. But John O'Keefe had a sister, and she had 2 children. And when the children were 6 and 3 years old, his sister unfortunately died. And shortly after, his sister's husband died. Now, John O'Keefe was a helper. He didn't sit by. He saw these 2 recently orphaned children, and he stepped in and he said he was going to raise them. So he put aside his career, he put aside his job, and he moved in with the children and raised them like they were his own. They were his passions, his love. He was a new parent, successes, failures, like all parents. And he raised the children with the help of people in the community, with the help of his brother, with the help of his family. And they led a good life. Enter Karen Reed. Around COVID, the defendant and Mr. O'Keefe reacquainted, and they started a relationship. And you'll hear that even though the defendant had her own home, she was staying with Mr. O'Keefe a lot, 4, 5, 6 times a week. And to most of the world, it was a pretty good relationship. They spent time together, they did activities with the children together. She helped with driving the children, feeding the children. It was a steady relationship until about the beginning of 2022. And then things began to unravel. There was tension, there was arguments. In fact, just a few days before this incident, you'll hear that Mr. O'Keefe asked her to leave. But she wouldn't. You're going to be able to read text messages of their conversations on January 28, 2022, and you will see the tension and the unraveling of the relationship. You will read about the discord between the defendant and Mr. O'Keefe. You will see that when he would ignore her calls, they would become incessant. When he would try to push away, she would come closer. You will read those text messages and you will realize that this was the beginning of the end of this relationship. That night, they decided they would go out together. I want to tell you something about data and science before we get to that night. I mentioned that underneath John's body was a cell phone. A cell phone is an amazing piece of technology. It is like a computer. It carries extraordinary data. And when they found the cell phone, the only containing John O'Keefe that night, they studied the cell phone, and there'll be some remarkable data that you will use in this case to find the truth. I want to mention 3 different things you will find in a cell phone that are critical to this case. The first is called location data. Waze we've all heard of, Google Maps. Well, at some point that night, John put his Waze on, and Waze is like a breadcrumb that will show exactly where the phone goes, second by second. It is the strongest, most accurate location data that you can have. And that night, John was using Waze. It also will have healthcare data. Healthcare data will show when somebody is moving. Sometimes it's qualified as steps, but it doesn't necessarily mean somebody's stepping. Moving their arms, walking, turning. It doesn't show what direction or how far, but it shows movement of a person. Healthcare data. And the third thing, remarkably, there will be an expert in this case who found a data file on the phone, and it tracks the temperature of the cell phone battery. That will be critical to your analysis in this case, the temperature of the cell phone battery. And so with that, I want to take you back to the timeline of that night. After the discord, both the defendant and Mr. O'Keefe decided they would meet at a bar called McCarthy's. Now, McCarthy's is a local bar, a blizzard is pending, and people are getting together in a celebratory mood. They go to McCarthy's, and you'll see a video of McCarthy's, and you will watch both Mr. O'Keefe, friends, and the defendant drinking alcohol. And you will count 8 vodka drinks that the defendant drank. They arrived at 8:50, they stayed till 9:45. She consumed at least 7 of those drinks in less than 2 hours. The last drink, you'll see when they leave the bar, she puts it under her jacket, and they walk out and they go to another bar to meet other friends called the Waterfall. They reach the Waterfall sometime around 10 p.m. And when they go into the Waterfall, you'll see a video. And when I said celebratory mood, you will see a group of friends of John O'Keefe, many who are friends with Karen through John, and you'll see them clapping and happy and joyous as they're there. You'll see many hugs between John O'Keefe and his friends and the defendant and many of the people there. And they spend some time together, they're drinking, and they all do a shot. And that will be at least the 8th drink within 3 hours that you consume. You will see from the data, not just the cell phone data, but there's some other very important data, and the other piece of data that goes hand in glove with the cell phone is information on the defendant's Lexus vehicle chips. You might have heard of black box in an airplane, or there's some type of event that captures a small amount of time. Well, that was captured in the defendant's Lexus. That black box information with the cell phone data will tell you everything you need to know in this case. It will bring us step by step through the entire night to the death of John O'Keefe. And so they leave the Waterfall bar at 12:12, and you'll see that the ignition goes on to the defendant's Lexus. And both John O'Keefe and the defendant in the car, and they decide that they're going to go back to 34 Fairview Road, that we talked about earlier. They're going to go there for a get-together for one of the homeowner's sons who's having a birthday party. And so as they drive back, we'll be able to follow them with this location data. When they go back to Fairview, they don't know exactly where it is, and they get lost. And so John O'Keefe makes a phone call, has a phone call with one of his friends, Jen McCabe. And during that phone call, which the defendant listens to because she recounts it, and trying to get directions, Jen McCabe tells John O'Keefe, it's near Bella's mom's house. You'll learn that Bella, or her mom, was somebody that John had dated before this week. And so as they make their way to Fairview, you will see there's a road that comes down like a loop and that leads to Fairview. They take a wrong turn on the loop, and then they do a three-point turn in the driveway. You'll see the exact precise driveway they turn into because some type of acceleration movement triggered that black box in the Lexus. And that's important because that's 7 minutes before the collision. And you'll see from the waves exactly where the car was. You'll see from the black box the event of the three-point turn in the driveway, and then a return down to Fairview. But before they get there, at 12:23, a truck is coming the other way. And the witnesses in that truck will say they blinked the lights, one of them saw a man and woman in the car, John and the defendant, and then they followed the Lexus because they were going to the same house. The truck stopped at the driveway, and the Lexus, the defendant's car, you will hear, because of the waves, can be counted second to second, never stops. It rolls very slowly all the way to the end of the yard, in the corner where there's a tree line and a flagpole. And they reach that location at 12:34:33. And they're in the car and they stay there. The truck waits, they speak to somebody in the house who comes out, the person goes back in the house and they're there for about 5 minutes. We're now down to 2 minutes before the collision. The truck leaves, and now it's just the defendant and John. And while they're waiting outside at 12:27, John gets a text from Jen McCabe. Park behind us in the driveway. 12:29, she texts again. Are you coming in? You'll hear that Jen McCabe and others look out the window and see the defendant's Lexus in front of the flagpole at the far end. It's snowy, it's dark, it's windy, they're waiting. You will know that John O'Keefe was in that car, that Lexus, and didn't move because his healthcare data is not moving. It's not moving until 12:31:56. At 12:31:56, he begins to move. You will have 20 seconds before he falls. 20 seconds. He gets out of the car, the Lexus, and in that 20 seconds, you'll hear that user initiated. He looks at the phone, at the text message from Jen McCabe. It's now 12:32:09. He closes the phone the last time. It will be the last time he uses that phone. From the waterfall bar, you'll see that he keeps it in his back pocket. And at that time, 12:32:09, last user, he has 7 more seconds he will move before he lies dormant the rest of the night. We'll also have the information from the defendant's Lexus black box. Now, the clocks run differently. There's a 30-second difference, but it's right in the heart of that time. And you will see in the data at that time, when he makes his last movements with the phone, is when her car leaves 34 feet at least, stops, neutral, and then shoots into reverse with the tires spinning right towards him. Right when he got out. You'll know they're arguing because the next morning she tells the firefighter, I'm sad because our last moments were fighting. She drives away. And they said she's made later statements that when she left, he didn't look mortally wounded. He lied on the ground on top of his phone, light dusting of snow, the snow now picking up. And he's just there. It's 12:37. Now, when he's in the car, before he gets to Fairview, the battery temperature of that phone is 77 degrees. 77 degrees in the warm car. Now that he's been outside the car for 5 minutes, drops. She calls again at 12:36:33 and leaves a message. You'll hear it. And you will hear the anger and rage in her voice. She leaves a message. John, I fucking The evidence will make clear that she knew who was there. She did not call 911. She did not go back to him. She did not leave an anonymous statement. She left him. The night wears on. It's now 1:07. Cell phone drops. It's almost 60 degrees. 12:59, the defendant leaves another message. 53, battery temperature, 60 degrees. The defendant has healthcare data on her phone as well, and you'll hear that it stops around that time. You'll later learn that she admits to falling asleep or passing out. Then she wakes. 5 o'clock, she is frantic. She wakes up John's knee. She did not leave. She is yelling, she's screaming, she asks for the niece to call Jen McCabe. She calls Jen McCabe, and you'll hear Jen McCabe recount out of a deep sleep. She wakes up and she hears, Jen, Jen. Screaming Jen's name. John's dead. Hangs up the phone. Jen McCabe calls back. And then she says, what's going on? And she said, well, I left him at the water. But then she wakes. 5 o'clock, she is frantic. She wakes up John's niece, and she is unintelligible. She is yelling, she's screaming, she asks for the niece to call Jen McCabe. She calls Jen McCabe, and you'll hear Jen McCabe recount out of a deep sleep. She wakes up and she hears, Jen, Jen, Jen. Screaming Jen's name. John's dead. Hangs up the phone. Jen McCabe. Down. And then she said, what's going on? And she told, well, I left him at the waterfall. At the beginning of the cover. She tells Jen McCabe, I left him at the waterfall. Jen calls back and says, he saw you up front. You did leave him at the waterfall. She hangs up. She then minutes later calls another person, Terry Roberts, a friend of John O'Keefe. Someone who's not friends with the defendant, but they know because they helped raise the kids and they interacted. She had nothing to do with the night before, wasn't at the bars, was home with her family. She calls her and says, I think John got hit by a plow. I think he's dead. Now Terry, with that information, calls 911. She calls hospitals, you can hear her voice. She's concerned, not panicking. And then she gets another call from the defendant. And she tells the defendant, come to my house. I will help you look for him. And the defendant says, I was so drunk last night, I don't remember anything. Waiting for her to arrive, she learns she doesn't arrive. Instead, the defendant goes to Jen McCabe's house. Terry Roberts, the other friend, then goes to Jen McCabe's house, pulls behind the car. And when she does, she's on Bluetooth, and she can hear the defendant say, my taillight's broken, my taillight's broken. And she looks, and the snow packed in the right taillight, she can see a piece of the taillight missing. The defendant desperately wants to go to 34 Fairview Road, but Terry Roberts takes over and says, we're going to go back to John's house. He's in the house and you didn't see him. So both cars, driven by Terry Roberts and then Jen McCabe, with the defendant, go back to John O'Keefe's house. You'll see a ring video where you see them go into the house and they look around, and you'll hear about the woman, Jen and Terry, enlisted into this task. Look for John O'Keefe. They cannot find him. And then when Terry Roberts comes into a room, she sees, rather than looking, the defendant simply standing there, staring at the wall. At that point, the defendant insists they got to go back to Fairview Road. They decide to take one car. Terry Roberts is taking charge. She's going to drive. They leave Miss Reed's Lexus and John O'Keefe's driveway, and they drive back towards 34 Fairview Road. It is blizzard-like conditions. It is dark. They can barely see a thing. And when they get close to the edge of 34 Fairview, you hear the defendant start to scream, there he is. Both women look and they can't see anything. She starts kicking the door. The defendant's kicking the door, let me out. Terry Roberts stops the car and lets her out, and she sees the defendant run exactly to where John O'Keefe is in the darkness, just where she left him. Terry gets out of the car, starts to walk towards where the defendant is, and she sees the defendant lying on a body. She can't tell who it is because the face is still covered with snow. And she comes over and looks, and she wipes off the snow from John O'Keefe's face. She realizes he's one of her best friends in the world is John O'Keefe. And she starts to try to do first aid. They start to move him, and coincidentally at 6:06 when they start to move him, the cold air hits that cell phone battery, it drops from 50 to 43 degrees. And they try, Jen McCabe calls 911. And that's when a police officer arrives, firefighter Nuttall and his crew. And when they lift him, that cell phone battery that is shut down to 37 degrees, Kerry Roberts picks it up and puts it in her pocket, and it immediately starts to warm as she moves to help get a data showing movement starts again. At that point, nobody knows what happened. The Canton Police Department come. You can see the police cars and cruisers. They're not sure, so they look in the area where John's body is and find a glass from the bar near his body. They find blood spots. They try to put the blood spots in plastic containers. They don't know what they're looking for at this point. There's no information. They don't believe or know that there's a crime. They just know that John O'Keefe somehow ended up here with the broken glass and the blood. And so that morning, you can see the work. Also the news, and they go to the hospital. They go to the Good Samaritan Hospital, and Kerry Roberts is walking, and Peggy O'Keefe is going to go see her son, from her husband. And as she walks down the hall, Karen Reed is also at the hospital. See, there was some reports of maybe she was upset or suicidal, so they sectioned her. They put her in for evaluation to make sure she was safe. You'll hear Peggy O'Keefe tell her she walked. Make sure the children are safe because they're alone at their home. And when the officer pulls in, he doesn't notice anything. As she walked by Karen Reed, she stopped and she said, "Karen, what happened?" And you'll hear that Karen was excited and yelling, "He could be dead." She stops her excitement. What's stolen? Doesn't say a word. Peggy pays respects to her son, and then she has to go back home because she has to tell the children. Now, while she's out, the Canton Police Department sent an officer to the house to make sure the children are safe because they're alone at their home. And when the officer pulls in, he doesn't notice anything, but you'll see in the dash cam video notices something. That tail light has a big missing piece to it. They can't find the children. Ultimately, Peggy comes home, a friend can take it down, and they bring the nephew home, and he is distraught. And then Peggy hears a knock on the door. It is the defendant and her father. They want to come in. They come in, no condolences to Peggy, and they ask, "Can we go upstairs to John's room?" And she's busy consoling her grandson. They go upstairs. They're upstairs for about 15 minutes. They come down, and quickly they leave. Now they got there from the defendant's father, drove his wife and the father to that house. But when they leave, they take two cars. They take the Lexus with the broken taillight with them back to the defendant's father's house. And you will learn that when police start getting some of the information, they learn about the broken taillight, they learn information that she had told people that she had hit him. They went down to see her, and on their way down, they decided they would get a warrant to take the Lexus. When they get down, you learn days later here from Trooper Buchanan, who took a look and you could see the missing taillight. They went in and spoke briefly to the defendant. They took the car, they brought it back to Canton. And so, what you'll learn from the forensic evidence that will help with the science and data is that not only was the cell phone left behind, but also around that area, broken taillight was littered around John O'Keefe's body. Littered around that area. When they got into the hospital, they noticed there was a shoe missing. As time went by, snow melted, they dug with excavations, they found the shoe. DNA on the border between the street and the grass. You'll learn days later when they did a plant excavation, they found his hat frozen to the ground. John O'Keefe fell backwards over the course by a car. And you're going to hear that broken tail light in that area. His hat, the sneaker, the glass. When the defendant left Mr. O'Keefe behind, took with her something that Mr. O'Keefe called Gray's evidence. You'll learn on the back of her Lexus, around the taillight area, was John's DNA, and stuck to the side, grasping one last piece of John O'Keefe's head. Now, John O'Keefe fell backwards, hit his head after he was clipped by a car. And you're going to hear from a very renowned doctor, a neurosurgeon, who has treated thousands and thousands of head injuries. And the wound on the back of the head, when he fell backwards, not the cracked skull, it's called a basal fracture, to create an injury called counter coup. After he was put by a car and fell backwards and hit his head on that hard rock ground, remember there's no snow, it's just a dusting at this point, the back of his brain hits the back of his skull and bounces up. When it bounces up, it leaves marks showing that impact. And this neurosurgeon will tell you, treated thousands of patients, that this injury, to a reasonable degree of medical certainty, is counter coup caused by falling backwards and hitting your head. When the medical examiner for the state looked at it, they generally said blunt force trauma. They had it undetermined. So we brought it to the renowned neurosurgeon who does exactly this. You're also going to hear from an active reconstruction. He'll come in and explain to you exactly what I talked about, how the data from that black box coincides with the cell phone and the movements of the car, the moments before, during, and after the defendant's. He had just gotten out of her Lexus. She intended that act would cause. There are 3 charges against the defendant in this case. The first one, second-degree murder. When most people hear murder, they instantly think shooting somebody, stabbing somebody, bringing deliberate premeditation. Or I will start doing the law. I'm not going to trample in that area, but I can tell you clearly, we are not going to try to prove that Karen Reed tried to kill John O'Keefe. We're not going to try to prove to you that she intended or wanted him dead. That's not second-degree murder. What we'll prove to you is she engaged in an intentional act, driving back at him at that speed, in the storm, in the darkness, knowing that he had just gotten out of her Lexus. She intended that act would cause a plain and strong likelihood of death. That's what will prove to you second-degree murder. Also, operating under the influence of alcohol, manslaughter will prove to you that she drove her Lexus recklessly. She hit John O'Keefe, and because she hit him and he fell back, she caused his death. The third charge is leaving the scene after knowingly causing death. Again, she hit Mr. O'Keefe with a car. She knew he was injured. She left him behind. And he died. That's the whole group. This case will come down to the science and the data. The science and the data that cell phone is the best of historians. It doesn't suffer from intoxication. It doesn't suffer from memory loss. It doesn't suffer from emotion, pride, or prejudice. It is facts. It is data. And that facts and data will lead you to the truth in this case. But after Ms. Reed was charged, she began what you'll learn as a campaign. A campaign to make public statements. 2020, Nightline, Fox 25, a documentary. And we've had an opportunity to get many of her statements in the footage, and we're going to show much of it to you. And her statements to you will confirm what you already know from the science and the data, what you will already conclude from the facts independent about what she did that night. Her word simply confirmed. many of her statements, her admissions to extraordinary intoxications, her admissions to driving the Alexis, her admissions to being angry at dawn that night, and I dare say her admissions that she told the statement. Like to play for you clip one. You're going to hear the first of the statements that she made after she was charged.
I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
Ladies and gentlemen, I simply ask you to follow the evidence, follow the science, follow the data. Ignore speculation, surmise, conjecture. Stay true to the evidence. It will lead you to the truth. That on January 29, 2022, a very intoxicated defendant was angry and arguing about the relationship with John O'Keefe. And after the fight was over, she left, but she brought the fight back to him in the form of her SUV. She clipped him, he fell backwards, he broke his head, and then this man who helped, a lifetime of help, was left at the corner of that yard, left to die with no help. The facts, the data, and the evidence will bring you to the truth, and the defendant's own words will confirm everything you've already concluded.
All right, thank you, Mr. Jackson.
Could I have just a moment to readjust?
Sure, the court officers will be kind enough to help you.
May I, Your Honor? The evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision. John O'Keefe did not die from being hit by a vehicle. Period. The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe. So how did we end up here? How does Karen Reed end up sitting in that chair on trial for an event that literally never happened? Well, the evidence is going to explain it. And it can be summed up in the following text message at the very beginning of this investigation. A text message of a now fired Massachusetts State Police officer named Michael Proctor. He was the lead investigator on this case, and he was talking about a fellow officer, a fellow cop, who owned the property where John O'Keefe's body was found. Text message with a buddy. Question: is the homeowner going to catch any shit? Answer: nope. He's a Boston cop too. That quote defines the lack of integrity of the Commonwealth's entire case, its entire investigation, and this prosecution. During the course of this trial, you'll learn much more about Mr. Proctor, why he said that, and what it really means. What you'll see and hear in this courtroom in the coming weeks is not just a story of a tragic loss. And make no mistake, John O'Keefe's death is and was a tragic and tragic loss. But the story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted and corrupted from the start. Corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking. You'll find when you hear the evidence that the Commonwealth's case is the literal definition of reasonable doubt. They won't be able to talk their way out of it. They won't be able to explain their way out of it. They won't be able to excuse their way out of it. And they can't meet their extreme burden of proof, which the court will tell you is beyond any and all reasonable doubt and to a moral certainty. Members of the jury, Karen Reed found John O'Keefe dead on the front lawn of a Boston police officer, Brian Albert, at 6 a.m. on January 29th, 2022. Picture the scene. Blood-curdling screams, ambulances, emergency lights on, fire engines, ladder trucks, paramedics, patrol users, police officers, first responders, firefighters, all swarming all over Brian Albert's lawn. Literally feet under his bedroom window. Yet Brian Albert, a sworn peace officer, a first responder himself, never came outside. Never went outside to see what the chaos was about, never went outside to see if he could assist a man in need, never walked outside his house to see if he could help a fallen fellow officer on his own front lawn. More shockingly, you'll learn that lead investigator for the Massachusetts police, Michael Proctor, never set foot inside Brian Albert's house that day. Never engaged in any investigation inside that house that day, even though a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door on that lawn. He never secured the crime scene, never separated and secured witnesses, he never properly collected evidence, he never secured the evidence, he never searched for signs of a struggle inside or outside the home, he never properly canvassed the neighborhood. Michael Proctor never did any of these things, even though fellow officers of Michael Proctor's actually mentioned, in their words, not mine, that it looked like John O'Keefe may have been, quote, in a fight. You'll have questions about that conduct. During the course of this trial, you'll find that the Commonwealth will not have answers. You'll see from the evidence in this case that this case carries a malignancy, one that is spread through the investigation, it's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. And his name is Michael Proctor. Now, you didn't hear his name in the prosecution's opening statement. Not once. And I suspect that was probably by design. But make no mistake about it. The evidence will show in this case that Michael Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel. He was the lead investigator on the case officer, the architect of the entire prosecution. You'll learn there's not a single part of this case, folks, not a single part that he didn't touch, that he didn't direct, that he didn't orchestrate personally. Every single bit of it has his fingerprints on it. You'll learn that Michael Proctor was a longtime family friend of the Alberts. And he's been disgraced by his own agency, not by us, by the Massachusetts State Police. Investigated, suspended, and fired. The evidence will show that Massachusetts State Police found him guilty, found Michael Proctor guilty of bringing dishonor to the department for his conduct, not in some other case, not in some tangential case, in this case. The investigation of Karen Reed. Conduct that included bias in favor of his friends, the all-powerful Albert family, and bias against my client, Miss Reed, the outsider. You have any idea how hard it is for a state trooper to get fired? Well, the evidence is going to show that Michael Proctor earned it. Every bit of it. You'll hear that within hours of a Boston police officer being found dead on Brian Albert's lawn, Michael Proctor, the lead investigator, who had investigated exactly nothing up to this point, right at the beginning, made an early pronouncement that Brian Albert himself was not going to, quote, catch any shit, end quote. And that was for one reason, and one reason only. He's a Boston cop. The evidence will show that Michael Proctor made this statement in a text conversation with his high school buddies. A text he never thought would see the light of day, certainly never thought we would get a hold of. And when he thought no one was looking, he actually said the quiet part out loud. He's a cop too. We'll give him a pass. You'll learn that in Michael Proctor's world, rank has its privileges. And the evidence will show that's privileges that you don't get and I don't get. But apparently a Boston police officer, Brian Albert, and his friends, they do get. You'll learn that in Michael Proctor's world, he didn't care about finding the truth. In his world, his priority was to protect the brotherhood, to protect that blue wall, to protect his friends who were at the Albert's house that night. I want to take a step back, if I could, and spend the next few minutes talking a little bit more detail about what the actual facts in this case will show, not based on speculation, not based on surmise, not based on guesswork or conjecture, but the actual true facts that you will learn through the course of this trial. On January 28th, 2022, it was a Friday night. John and Karen had made plans to meet up with friends for drinks. It was a happy and normal night for them. They were affectionate, they were loving, they were in good spirits, nothing out of the ordinary. They started at a local watering hole called C.F. McCarthy's. You've heard that name before and you'll hear it again. And eventually they made their way over to the Waterfall Bar and Grill, another bar where they ended up. When they got to the Waterfall Bar and Grill, the Albert family was already there, already heavily drinking. You'll learn that this was no ordinary family, the Alberts. The Albert family was a well-known Canton family. Some might even describe them as a very powerful Canton family. Brian Albert was there at the waterfall. You'll hear that he's a longtime Boston police officer. His wife, Nicole Albert, was there with him. His brother, Chris Albert, a powerful Canton politician. He sits on the select board. The select board actually governs the police department, the Canton PD. He was there. His wife, Julie Albert, was there. Their daughter, Caitlin Albert, was there. His sister-in-law, Jennifer McCabe, was there. Her husband, Matt McCabe, was also there. They were all there drinking before John and before Karen ever arrived. You'll learn that a man by the name of Brian Higgins, also a law enforcement officer, and longtime friend, longtime pal of Brian Albert, he was also there. And the two of them, the two Bryans, had been drinking most of the night together. You'll see video footage from the waterfall, which will show you that Karen and John were happy. They were affectionate. They were caring. They were loving. Just business as usual, out on a date on a Friday night. But that exact same video footage which lead investigator Michael Proctor plainly chose to ignore that video footage. It paints a very different picture of Brian Higgins. You'll learn that Higgins had romantic designs for Karen. That becomes important. Brian Higgins had engaged Karen in flirtatious texts, but days earlier she had put a stop to it. She had ghosted him, in common parlance. In other words, just ignored him. The evidence will show that the first time he saw her and was in her presence after being rejected by her was when she walked into the Waterfall Bar and Grill along with her boyfriend, John O'Keefe. At 11:58 p.m., just minutes before John ultimately arrived at the Albert residence, you'll see a video at the Waterfall of an unsettling interaction, troubling interaction between Brian Higgins and John O'Keefe. And unlike the lead investigator, Michael Proctor, in this case, you won't ignore that evidence. As the bar was closing around 12 midnight, the Alberts invited everybody back to their house for a get-together to just keep the night going. And you'll learn that Karen and John ultimately pulled up to the house. They got out of the SUV to make sure they had the right address. You see, neither John nor Karen had ever been to 34 Fairview. They weren't even sure they were at the right address. And the evidence will establish that John got out of the SUV and went into the house. Let me say that again. The facts unequivocally, the data, the science, the witnesses will all unequivocally establish that John O'Keefe went into the Albert home that night. Eyewitnesses and forensic data will establish that fact. When he didn't come back out, you'll learn that Karen grew increasingly frustrated. She got upset. She was left alone in a car, in the cold, in the middle of the night, with the car idling. John had gone into the house. She expected him to come right back out, and when he didn't, seconds turned into minutes, and minutes started to clock away. She left John a voicemail, then another voicemail, voicemail after voicemail after voicemail, text messages. But he was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. The Commonwealth will intimate, as they already have in their opening statement, that these voicemails are evidence that the two were fighting. The actual evidence in this case, however, will show the exact opposite. You'll hear that Karen was very agitated. You'll hear some voicemails where she's swearing. You'll hear voicemails where she calls him names. There's name calling. But you'll also hear the context of those voicemails. And every single one of them, every single one of those voicemails was left for John after he failed to come back out of the house, after he failed to respond to her voicemails and to her texts. Karen believed John had just left her sitting there, grabbed a beer, was partying with his friends. The evidence will actually show that John and Karen never had a crossword, not a single crossword that entire evening before he left that SUV and went inside the house. And you will learn what Karen had absolutely no way of knowing at the time. It wasn't that he wouldn't respond to her. It's that he couldn't respond to her. And the evidence will show you why. Let's talk about that. We'll introduce you to a doctor named Elizabeth Lopesada, a renowned forensic pathologist, a medical examiner, and a professor at Brown University. She will tell you that the injury to the back of John's head, first of all, was immediately incapacitating. And that has meaning. At the moment he suffered that fatal head injury, he couldn't walk, talk, grab his phone, cry for help, nothing. He was completely incapacitated, completely unconscious from the moment he suffered that injury. He was completely still and incapable of interacting with anyone or anything. But the doctor will tell you something more, and just as important. She'll tell you that John O'Keefe did not suffer from hypothermia, as the Commonwealth will undoubtedly allege. His body showed no signs of it. No frostbite, no cold-induced injuries to his organs, no damage based on cold or frost. Ladies and gentlemen, the scientific evidence and the medical evidence will establish that John O'Keefe had to be injured somewhere else, somewhere warmer, and his body had to have been moved out into the cold. And that's where, ultimately at 6 a.m., Karen found him the next morning. You will learn that John did not have a single injury consistent with being hit by a car. Let me say that again. The evidence will establish that John did not suffer a single injury on his body consistent with having been hit by a car. Not one. You'll learn that John's torso, his ribs, his chest, his arms, his hips, his legs, his knees, his ankles, his feet, all of them, no broken bones, no fractures, no contusions, no torn ligaments, no internal injuries, not even a bruise. Nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV. Not a bruise. Dr. LaPosada will tell you with medical certainty that, in fact, John was not struck by a vehicle. Medically and scientifically, he could not have been struck by a vehicle. Therefore, as I said, there was no collision. She will tell you that the patterned abrasions on John's right arm, the patterned abrasions you see over my left shoulder, they're not the result of being struck by a car or a taillight. You'll take one look at these injuries and you'll agree with Dr. LaPosada. The evidence will show that these injuries are from an animal, like a large dog, like the large dog that was inside the Albert house that night. You'll learn that Brian Albert has actually admitted that his large dog, the family dog, is, quote, not good with strangers. And of course, John, never having been to the house before, was a stranger that night. You'll also learn that oddly, very oddly, after having their family pet for 7 years, a short time after this incident, the Alberts got rid of that dog. They called it rehoming her. But she was gone. Dr. LaPosada will also tell you that the injury to John's head was not the result of falling backward onto a flat lawn, cold or otherwise. Rather, Dr. LaPosada will tell you with medical certainty that the injury pattern to his scalp was produced by an impact from a raised or ledged surface, a surface that does not exist on Brian Albert's front lawn where John was found. The medical evidence will establish no hypothermia, no injuries from a car strike, no collision with a motor vehicle. And forensic analysis of John's cell phone, Mr. Brennan mentioned that in his opening statement. The Commonwealth's own expert will ultimately support the exact facts that I just told you, including the temperature data. John O'Keefe was injured someplace warmer, and he was moved. That alone is reasonable doubt, but there's much more. You'll also learn that there were many people at that after-hours gathering at Brian Albert's house who would have left by the front door just feet from where John O'Keefe's body would have ultimately been, had he actually been there, right after 12:30 a.m., which is what the Commonwealth's claim is. There were nearly a dozen people who walked out that front door directly adjacent to the precise spot where John O'Keefe would have been lying. Not a single person, not one, not a single person, saw a 6'2", 216-pound man laying sprawled in the front lawn in dark clothing on a light white dusting of snow. Not one. Then the evidence will also show that every one of those same people drove by that same spot, not walked by it, drove by it to leave the house, and still not one of them saw John laying in the yard when they left between 1 a.m. and 2 a.m. in the morning. But you know who else you'll find never saw a body on that lawn? The snowplow driver, a completely independent witness charged with plowing the streets in Canton that night. You'll hear that Michael Proctor, oh, he's not done yet, Mr. Proctor. You'll hear that Michael Proctor wrote a report where he claimed that Fairview had not been plowed that night. You'll learn that that was completely false. That was a lie. Michael Proctor did not want any more witnesses. He didn't want the truth, and he falsely claimed that the road was never plowed. You'll learn that he wouldn't look for the plow driver, but we did, and we found, and we'll introduce you to, Brian Loughran. He plowed Fairview that night, and what he's going to tell you is that there was no body on that lawn at 2:30 in the morning. You'll learn that Brian Laughlin passed by 34 Fairview, traveling right next to Brian Albert's front yard, and at 2:30 a.m., John O'Keefe was not there. But you'll see that the plow driver also provides some other troubling information, troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 a.m., he showed up with his plow an hour later. He stopped at the entrance of Fairview. He was looking up Fairview to decide whether or not to plow it, but he saw an obstruction. At 3:30 a.m., he looked down the street, and in the very spot precisely where Karen would later find John's body laying at 6 a.m., there was a car parked in front of it, a Ford Edge. You're going to ask yourself, who's moving a car at 3:30 in the morning into a blizzard on the side of the road? You'll learn that Michael Proctor, the lead investigator, intentionally ignored this fact as well. He did no investigation to find out who owned a Ford Edge, but again, we did. And the evidence will establish that Ford Edge happens to be a favorite model of the Albert family. More than one Albert owned a Ford Edge at the time. You'll learn that those facts will add to the mounting and the overwhelming evidence that there was no collision and John O'Keefe's body was moved onto that lawn. You'll find that this is yet additional reasonable doubt in the case. You'll be introduced to science and physics, even from the Commonwealth's own experts. That science will establish that Karen Reed's SUV was not damaged by hitting a pedestrian, and conversely, John O'Keefe's injuries did not come from being struck by a vehicle. The Commonwealth mentioned triggering events, but what you'll actually learn from the experts, some of them the Commonwealth's own experts, is that a triggering event is not evidence of an accident. It does not evidence a collision. That's why we're here. A collision. And there's no evidence of one. Zero. You'll also find that those exact sort of triggering events that the Commonwealth will rely on are relatively commonplace on Karen's SUV, and none of them are associated with a claim of a collision. Folks, the science will not lie, and the physics cannot lie. And that science will tell you with certainty there was no collision with John O'Keefe. You'll add that to that rising mountain of reasonable doubt. I want to take you back to the night in question, January 29th, for just a few minutes. Remember, Karen had gone home after dropping off John and John walking to the house. While Karen was asleep at home with John's 13-year-old niece, what were the people who had been at Brian Albert's house that night? What were they doing? While she slept, what you'll find and what the evidence will show is that they were extremely busy. You'll learn that after a long night of heavy drinking, Brian Higgins left the Albert residence, but he didn't drive home. Rather, he drove over to the Canton Police Department, where he kept an office at about 1:25 a.m. Not a Canton police officer, but he kept an office there. Why go back to his office at 1:25 a.m.? Why go back to the Canton Police Department at 1:25 in the morning on the night of a blizzard? You'll learn that while there, Higgins made a call at 1:30 a.m. Higgins will later deny that he made that call. You'll find that curious. And his explanation for that late night visit to Canton PD, you'll find that it changes nearly every time he's asked about it. You'll learn that after everyone left Brian Albert's house, Brian Albert actually claimed he had no contact with anybody else except his wife. No contact. Until he woke up the next morning. So he says. Then you'll learn that that, too, is a complete lie. His phone records establish that he placed a call to none other than Brian Higgins at 2:22 a.m. shortly after Higgins completed that late night visit over to Canton PD. You'll wonder, what did they possibly need to talk about at 2:22 a.m. that night? The evidence will establish that Brian Albert called Brian Higgins first. Brian Albert then disconnected that call when Higgins didn't answer it. Seconds later, Brian Higgins returned the call. Brian Albert then did answer that call. They spoke for 22 full seconds, had a conversation, then they both hung up their respective phones. You'll learn that when they were asked about these calls and conversations, both Brian Albert and Brian Higgins lied about it. Both of them. They said they never had a call with each other. But then ultimately, when they were confronted with their own cell phone records and they could no longer deny the calls, they were asked independently, explain yourself. And they both came up with the exact same explanation. A butt dial. The evidence will make you question, why did Albert and Higgins speak at 2:22 a.m.? And why did they both try to cover up that phone call? You'll also learn after this incident and within days of one another, both Brian Higgins and Brian Albert, both police officers, both trained investigators, got rid of their phones. Both of them. And what else you'll learn, Brian Albert got rid of? Shortly after this incident, Brian Albert got rid of his house, the whole thing. Just sold it. His childhood home, a home that had been in the Albert family for generations, he literally sold it mere months after this incident. Dog rehomed, phones destroyed, house sold. You'll learn that all these things happened shortly after the incident where John O'Keefe was found unresponsive and dying in Brian Albert's front lawn. And you'll also learn that Michael Proctor looked the other way. He did not investigate any of what I'm telling you. He pre-selected Karen Reed from the start. And he ignored everything and everyone else. Let's get back to what was happening with the others while Karen slept. What you'll learn during this trial is that Brian Albert's sister-in-law, you've heard her name before, Jennifer McCabe, she was at the waterfall that night and she was over at the Alberts' house that evening as well. She left the after-hours gathering about 2 a.m., a little before 2 a.m., got home around 2 a.m. And you'll learn that according to the Commonwealth's own evidence from a forensic software program called Physical Analyzer made by Celebrite, it's considered the gold standard for forensic tools. You'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us, but we found anyway. A Google search that was time-stamped, according to their own data, at 2:27 a.m. 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, "Hoslong to die in cold." Hoslong to die in cold. Now she misspelled the first word. Hos is supposed to be how, but the meaning's the same. How long does it take to die in the cold? Time-stamped 2:27. And then that search was also noted by the same Celebrite program as having been deleted. The evidence will force you to ask, why is there a search on her phone? Why is it logged at 2:27 a.m.? When the Commonwealth claims that she first learned of John's death and where his body was hours later at 6 a.m. So what you'll learn is that while Karen slept, here's what was actually happening by some other very busy bees. 1:25 a.m., Brian Higgins makes an unexpected visit to Canton PD. 1:30 a.m., he makes a phone call that he later denies ever making. At 2:22 a.m., Brian Higgins and Brian Albert talk. They both deny and lie about having made that phone call. 2:27 a.m., 5 minutes later, a Google search appears on Jennifer McCabe's phone, Hoslong to die in cold, hours before John's body was ever discovered. A Google search she denies making, and that she later, or at least it was later logged as deleted. Meanwhile, at 2:30 a.m., the plow driver confirms that O'Keefe's body was not on the lawn of Brian Albert's house, not at 2:30 in the morning. And at 3:30 in the morning, that area was obstructed by a Ford Edge like the one the Albert family liked to own. The evidence will show in the meantime, Karen dozed in and out of a fitful sleep for the rest of the night, only to awaken just before 5 a.m., and that's when she realized, in a panic, John had never come home. And you'll see, it wasn't like John to not come home. That morning, you'll see and hear evidence that Karen's emotions had morphed. It'd gone from frustration and anger, which you'll hear in the voicemails, to abject fear. Fear that something bad had happened. The evidence will establish by this time Karen was panic-stricken. She had a feeling something was very, very wrong. She was unable to get a hold of John. Karen went to go look for him. She got in her Lexus and she backed up to leave her garage at One Meadows. You'll hear a lot about that address, One Meadows. That was John's house where Karen was staying. She backed out of the garage, and during the course of the trial, you'll hear that she actually struck another car with that right rear taillight. During the course of this trial, the Commonwealth is going to desperately claim that Karen Reed's taillight was actually damaged by hitting John O'Keefe. They'll have no evidence of it, mind you, none, but they'll make the claim. We'll show you a video of exactly how that taillight was originally damaged, or exactly what happened at 5:07 in the morning. The facts will show that it was damaged in John's own driveway at 5:07 when Karen backed up and made contact with another car in the driveway. This is 5 hours after she dropped John off and he went into the Albert residence. As a result, the taillight was minimally cracked, but it wasn't completely shattered or damaged or broken. And that's the condition of the SUV when Michael Proctor got a hold of it. That becomes important. You'll hear from an independent police officer, an eyewitness to the damage on that SUV, someone not connected to Michael Proctor or under his control. And he'll tell you that he saw the taillight damaged before it was in Michael Proctor's possession, but it was not completely shattered. And you won't have to speculate how that taillight got cracked originally. You'll see it for yourself. It's on video. You'll learn that part of the reason that Karen's Lexus hit that car at One Meadows is because she backed out looking for him at a time when she was absolutely panic-stricken and grief-stricken. Where was John? Why hadn't he come home? What had happened to him? Is he hurt? Is he passed out somewhere? Her mind was reeling. The evidence will establish she wasn't giving anything away. Everything was on the table. What could have happened to John? You'll learn that when she woke up and he still wasn't home, she was just racking her brain for what could have happened to him, and she was worried about possibly the worst. He had gotten out of the car, he'd walked to the house, she was confused, and later, when she found him at 6 a.m. on the lawn, where she last saw him going toward the house, her mind started reeling, oh my God, did a plow hit him? Did I hit him? Could I have hit him? What could have happened to him? And that video clip that you saw, out of context, when she said the words, he did not look like he was mortally wounded, she's not talking about at midnight. She's talking about at 6 a.m. when she found him. That's what she was talking about. Your job will be to make sure that the evidence isn't presented to you too cute by half. She was saying all those things. Did a plow hit him? Could I have hit him? Did I hit him? She was saying that to herself and to other people. And the Commonwealth, very obviously, will try to seize on that panic and twist this into some admission. But here's the actual truth. That's not a confession. Could I have hit him? Did I hit him? Could a plow have hit him? That's a person trying to make sense of an unexplainable circumstance, a natural concern of a bereaved significant other. A woman desperately trying to piece together what could have happened on this tragic night. John didn't come home. And the evidence will show that Karen Reed never said, I hit him. Never. Not in the background of the 911 recording, not on any dash cam video, not on any audio, not on any police body cam, not to a first responder. It's never mentioned in a single report. It's never reported in a single report from January 29th, not by one person, because it never happened. The evidence will show that there were at least 13 members of law enforcement or first responders and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen. Officer Sarath, Mullaney, Good, Lank, EMT Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Robery, McLaughlin, Carrie Roberts, Jennifer McCabe. They were all there, watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, "I hit him." Not one. Not one civilian reported having heard Karen Reed say, "I hit him." The facts will show that the first time this improved statement was ever claimed to have been made was some 24 hours later by a single EMT in an interview. Now listen to this. In an interview coordinated by a Canton police detective named Kevin Albert. Brian Albert's brother. And remember, Chris Albert, the other brother, is a board selectman to whom the Canton Police Department reports. And what's more, you'll learn that Katie McLaughlin, that's the EMT, that's the single EMT, the first person to have claimed to have heard this unrecorded and unreported statement, is years-long close personal friends with a young woman named Caitlin Albert. You heard that right. It's Brian Albert's daughter. During the course of this trial, you'll become familiar with and you'll realize that the Alberts are indeed a powerful and indeed an influential family. And that will mean something. You'll learn that there are other major problems with the prosecution's case. The evidence will establish that Michael Proctor himself, the lead investigator and architect of this entire case, has a long-standing and personal relationship with the Albert family. Yes, that same Albert family. His sister was close friends with Julie Albert. He personally sat at head tables at weddings, or at a head table at weddings with the Albert family. He entrusted the Alberts with babysitting his own children. You heard that correctly. And yet he was the lead detective assigned to investigate the circumstances of a Boston police officer laying dead on the Alberts' front lawn. That's not just bias, you'll learn. That's not just coincidence. That, folks, is corruption. And you'll see how far it went. Michael Proctor was alone with all the critical evidence in this case, alone with Karen Reed's phone, alone with John's phone, alone with video footage, alone with the taillight material, alone when he claimed to recover evidence from 34 Fairview. He wrote the search warrants, he transported the evidence, he secured it, he submitted it, he did it all. That's Michael Proctor. And he did it without any reasonable oversight. You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation. He lied in reports, warrants, he lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie about that? The evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight before any taillight fragments were found at 34 Fairview. Appreciate that. He had access to the vehicle before a single piece of taillight material was ever found at the scene. You'll find that there were two searches. The first and second search found zero. Nothing. Nothing around John's body. Nothing in the street. Not one piece of taillight fragment. But once Michael Proctor had that SUV and had the taillight in his custody and control, suddenly items started magically showing up. And not just a few items. 46 pieces of bright red taillight laying in the snow. Supposedly found in the exact same spot that was searched not once, but twice by independent officers. It came up with zero. To be clear, you'll learn that before Michael Proctor had access to that taillight, not a single piece was ever recovered at 34 Fairview. That will become vitally, vitally important. And what about those shards of plastic, by the way? What about this DNA that the Commonwealth mentioned? They're going to try to dazzle you with talk of DNA because it sounds so scientific. The DNA was on the taillight. But you'll learn that there was no DNA on the actual shards that they claim came in contact with John's arm. None. There was no blood, no tissue, no skin, no DNA on a single shard of plastic that they claim cut deep abrasions into John's arm, the arm that you saw overhead. The DNA that was actually found, the actual science will show it was found outside of the taillight housing where anyone with access to that vehicle would have touched. And it wasn't just one male's DNA. In that exact same sample, there were 3 men found, John and 2 unidentified males. So unless the Commonwealth is going to shift their theory that that SUV hit 3 men that night, their entire theory falls apart. And speaking of DNA, the evidence will further establish that John O'Keefe's shoe, the one that he was wearing when he was found, was sampled. And that DNA revealed 5, count them, 5 unidentified males. Recall that the evidence will establish independently that John was injured someplace warmer and had to be moved onto that lawn. 5 unidentified males touching that shoe. You'll also learn that you are not the first person, not the first to hear about the Commonwealth's theory of this case, that John was hit by an SUV. That's their theory. The Commonwealth presented this exact same claim to their own medical examiner, a woman by the name of Dr. Irini Scorti-Bello. And you'll learn that after reviewing what's called a law enforcement accident notifier, with law enforcement's theory of the collision written in it, defined in it, after conducting the autopsy herself, after examining John's injuries in detail, she refused to conclude that John's death was a homicide based on the Commonwealth's presentation and their theory. That's right. The Commonwealth's own medical examiner will not deem the manner of death in this case, a homicide. She won't do it. But they're nonetheless back again trying to present the exact same theory to you in this trial. Again, the evidence will show that that is reasonable doubt. Throughout this trial, the Commonwealth will try to convince you of paranormal events, phones calling themselves, messages deleting themselves, Google searches made and then unmade, evidence magically appearing and evidence magically disappearing. But all that smoke and all those mirrors will not ever reach their burden. Because that's what this case is ultimately about. It's about the Commonwealth's burden of proof. You'll learn that during the trial, the Commonwealth bears the highest burden known to our justice system. They must prove every element of every charge beyond a reasonable doubt and to a moral certainty. And you'll learn that moral certainty means the highest level of certainty known in human affairs. It's not a small thing. They're not going to be able to do that. Not when every piece of this case was handled by a disgraced investigator with a motive to protect his friends, not when the physical evidence contradicts their very theory, not when their own medical examiner won't call this case a homicide based on the exact theory that they're presenting to you, not when the conduct of those in the house and the utter lack of investigation speaks volumes about those who actually have something to hide. By the end of this trial, you'll conclude that Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the only verdicts, all 3 of them, that are consistent with the evidence, the science, the truth, and justice. Not guilty, not guilty, not guilty. Thank you.
Thank you, Mr. Jackson. Folks, why don't we take our morning recess? About 15 minutes.
All right, folks, I am a towel. I'm going to stop that fan from spinning so you don't have to watch it. I apologize for the fan. We are going to bring the Zoom up instead, and I'm going to pop up and say hello. Well, that was quite interesting. We're going to take a short recess now. Normally these morning recesses are somewhere in the 15 to 20-minute mark. Could be as short as 10 minutes, and then we will get into the first witnesses, and I expect those witnesses to take us right up until lunch at 1 o'clock. Well, that was very interesting, folks. Very interesting in a number of different ways. Very interesting for a number of different reasons. And I, your little towel, there I am, prepared to come up and say hello. As you can see, we do not have to watch the fan. Little Towel might have to watch the fan, but you don't have to watch the fan. It is agonizing. It is disorientating. It is nauseating. It is overwhelming. Towel does not like watching it. Sorry. And of course, as I say that, I reflect all of the reasons why I don't like watching that fan drink. But concerning, I'm very interested to go back now and watch my opening statement in light of how Hank Brennan delivered his opening statement, because I obviously mine was a condensed, truncated 6-minute overview of the case, but there's going to be a little bit of buffering for a second. Hold on, folks. A very interesting series of events. You all, I think I'm actually a little bit ahead of you all in terms of the chat. You all are certainly chatting a lot about this case, but I do think Hank Brennan's opening was very strong. He had as I said in my Twitter overview, he had the case absolutely memorized by heart. I thought that was very, very, very well done. I thought that Hank Brennan's overall presentation was much better than Alan Jackson's, because Hank Brennan presented the defense with an entirely new set of challenges as to how he was going to argue and demonstrate via the evidence that Karen Reed hit John O'Keefe, and then John O'Keefe never moved from that spot on the lawn, and that's devastating, and Karen couldn't really counter it. And Karen just retooled a lot of this evidence, and she made Jackson made a lot of weighty claims that are going to overall by far and away the state started way stronger and may have even been able to adequately present to the information to even explain the nuanced distinction between malice second-degree murder and involuntary manslaughter, which is very bad for Karen. So yes, it looks like we're looking at about a 20-minute recess. I think I'm not sure bad for Karen. So yes, it looks like we're looking at about a 20-minute recess. I think I'm not sure if you all are in sync with me yet. Obviously, there was a lot of information going on there simultaneously. So some of what you're seeing is maybe, I don't know, about 30 seconds to a minute behind where we are, but you're eventually going to catch up with me. And then thankfully, as we all get caught up, by that time we will go right into witness presentation. So. But yes, I'm seeing some comments from Courtney Meyer that it was very difficult for Jackson to go after the brilliant Brennan, which is true. And now Ed joined and said that it was helping you all see these clips, and then I'm uploading some of these clips to unable to watch live. Jump forward as soon as some of these clips get uploaded. I think Hank Brennan's opening argument was 38 minutes, and so that one definitely took a second to upload, but I think it's at its very, very end here. So, but yes, I'm doing my best to get caught up with your comments. You can see now, you guys are just getting, if you're watching on the stream, you're just getting caught up as I'm saying this to when Hank Brennan or Alan Jackson finished and we went to recess. So give it about, I don't know, 2 minutes or so. Yes, I know, being Chance, there's some buffering going on because I'm uploading simultaneous clips to other websites. So give it, I don't know, 2 or 3 seconds, and you will see me back up on the screen. And then the other thing I mentioned is the reason why some of this buffering occurs is that I'm simultaneously uploading the openings for other folks, and then I'm trying to get you all coverage as well. So, but yes, that was a very interesting series of events, folks. Very interesting series of events. The opening, I thought, definitely went in the favor of Hank Brennan. I thought that it was very well done by Hank Brennan, and I thought it spoke to his command and knowledge of the facts and the law. Mr. Brennan clearly knew exactly what he wanted to relay to that jury. He relayed that information in a cogent manner, in an erudite manner, in a rapid manner, in a way that I don't think too many other people can do. Oh, I see I am buffering a little bit. Well, it makes me want to, I simultaneously want to keep this upload going and stop. So hold on one second. Yeah, no, it's not your Wi-Fi. I'm buffering a little bit because I'm trying to get these posts out, and not everyone, unfortunately, is able to follow in real time. I'd say it has like 25% or so left, so just beg your patience. And by the way, although the stream is a little bit lagged, I am actively monitoring the Zoom, and as soon as we come back into session, I will jump the bandwidth a little bit. I'll switch it over back to the stream. I just need to dedicate a little bit of my bandwidth to do this upload. But that said, as I mentioned, you are not missing anything. If you're wondering why it's going in and out or hearing audio only, I'm just uploading a clip of Hank Brennan's amazing opening, and I want to make sure that that clip gets out. So it is a little frustrating, especially on my end, because it's not really a bandwidth problem. It's just streaming to two platforms at the same time and then trying to upload a video at the same time causes a little lag. But I'm still digesting those openings. As a juror, I would understand Hank Brennan's opening a lot more than I would understand Alan Jackson's opening. Alan Jackson's opening to me was very perplexing. It was very strange, I guess I would say. I didn't really understand why he was presenting Alan Jackson, presenting such disparate information in chunks. He wasn't telling a cohesive story. Hank Brennan told, and yes, the burden's on Hank Brennan, but Hank Brennan told a cohesive story. As a juror, you could walk away from that saying, okay, it was a series of events. It led up to this moment, and then Karen crashed her car into John. The one thing I think Brennan should have focused a little bit more on was the breakdown in the relationship, because that Alan Jackson stood up there and said Karen and John were having a cordial evening. That was clearly not the case. The evidence shows that that's not the case. Brennan's going to introduce that evidence. A little bit more focus from Brennan on that would have been good, but otherwise Brennan was telling a story, a cohesive story with an explanation, and Alan Jackson was just up there kind of pontificating without really a cohesive theme. It was very disparate, not really strong evidence presented in a way that I don't think was very effective. Now, please, if you are just getting caught up, all that buffering should have stopped. So let me give you one. Let me just say this. Buffering should be all set. And please forgive me, by the way, the only reason that I allowed that buffering to occur was because we're on a recess. So if you're just tuning in, if you're just getting caught up, should have jumped forward in the stream. Now you might have missed my last, I don't know, however long segment of commentary. It was just me explaining my thoughts on the opening. But the reason why there was buffering is it took me a little bit of time to actually upload a clip of Hank Brennan's opening. So forgive Little Towel. Please be patient with Little Towel. I'm a one-towel operation here. I'm not a large network. But needless to say, we're in a break, and you haven't missed anything. The reason I know you haven't missed anything is because up on your screen is an empty chair. And the second that chair has Judge Canoni in it, we are going to have about a 1-minute warning ahead of all the other streams, knowing that we are going to be back in session. So thanks very much. Yes, I'm glad there's no more buffering. Sorry about that to all you who had to go through that buffering. I tried to delicately balance two important things. One was the stream I was providing to you all, and two was my upload of Hank Brennan's opening statement, which was 38 minutes and 1 second, for any of you wondering. And I decided that because we were in a court recess and we weren't missing any substance or anything of substance, I was going to allow that upload to occur. But I'm interested in your thoughts. I could not read the whole chat as Hank Brennan was giving his opening. You all had a lot going on. No, Cookie Bramlaw, I'm seeing a lot of you now weighing in chat, getting caught up. It wasn't actually anything any of you all were doing. It was... I think you're just getting caught up now. It was an upload on my end that was slowing down my stream, but I made a conscious choice, and I hope you all will forgive Little Towel for making that choice. I made a conscious choice to continue uploading Hank Brennan's opening because it was really good, and I spent some time writing it up, so I wanted to actually take the time to share it, so that's what I did. And if you're wondering, this is not, I think a lot of people would do one of these things. I think a lot of people would do one of these things. They would either clip the stream or they would broadcast it. What makes my efforts a little unique is I'm both broadcasting it to X and YouTube, and then I'm also clipping stuff in real time and uploading it. So that's why if it's like a really long video, it might slow the actual stream down, but I will try to not upload long videos when any testimony or anything substantive is occurring. If you're seeing any of that lagging, I'll try to only do it when I'm speaking during a recess. But yes, no, don't worry about that. The reason it's important to me is I'm trying to create a record. So if you are all telling me that certain things are buffering, I have to take that into consideration, because I don't mind if it buffers while I'm talking, because you all can just come back in and I'll talk and you can maybe miss a few seconds or whatever. But I don't want to have it buffer while anything in the trial is occurring. So this real-time feedback is very helpful. Dewdrops, I think, I'm not sure, let me double check. I think if you jump forward, it should be caught up. There was a little bit of buffering going on, but as far as I'm aware right now, it should be caught up. I stopped uploading other things. Oh, I see what the problem was. I'm sorry about that, friends. That actually was my fault. It wasn't that I was uploading one thing, it was I was trying to upload two things at once. Okay. Sorry about that. I have fixed that. And I also want to say, when you saw the pausing earlier, but you noticed the lawn crime stream kept running, the words on the stream, that was the actual court pool feed buffering, which was exceptionally frustrating. So, but yes, I think it should be all back now. And just so folks are wondering, as I mentioned earlier, you're not actually missing anything, because we are still on recess and I am monitoring the Zoom in real time. And if you missed the opening, they were certainly very interesting. But yes, when you do get caught up, in the chat, what should eventually happen is you'll jump forward, and then you'll hear me reading your comments from 5 or so minutes ago. So, and then the other thing is, I think you all should be at about 11:42 as you're hearing this. Excuse me, you're about 2 minutes behind. So as everything gets caught up, you'll notice you quickly jump forward. As of 11:45, we are not yet back from recess. So, yeah, Brady Goat, very good to see you. Yeah, I am trying to do a lot of things at once, but as I mentioned, you all are kind of, I don't have someone like a technical producer or anything. It's just Little Towel. So if you all are giving me real-time feedback, I have to look into things like I have to look into what was causing, because most stream, that doesn't happen most of the time. So I have to look into what series of things caused that buffering to occur. And it was trying to upload Jackson's opening to point out how he used the word cancer in an entirely inappropriate manner while uploading Brennan's opening. So I've now learned an important lesson that I cannot upload that much at once. Ems, Hank didn't mention Karen returning to the scene a second time. Do they not have that information, or maybe she never did? That's a very good question, because to me, Aperture's whole point in testifying was the GPS location information. Now, there was a lot of things I want to point out, Ems, that were not in Hank Brennan's opening. Okay, so there was not anything about the breakdown in the relationship. There was not anything about cheating with Higgins. But we know that evidence is coming in. So the Aperture evidence, I'm very interested about. Maybe Hank Brennan wants to keep it close to the vest. To me, I'm very firm. Oh, actually, Ems, let me say something else. We know that there is video evidence of Karen at 5:07 a.m. leaving John's, or 5:08, at 5:11 a.m. near the Temple, in Canton Center heading towards the Waterfall and CF McCarthy's, and 5:18 a.m. over by the train tracks, I think it's the Purple Line, heading over towards Fairview, okay? You know what I'm saying? If you follow that route, okay, there's video evidence, 5:08, 5:11, 5:18. That's coming in. We know that's coming in. It came in last time. It's time-stamped. I can give you the specific elements of the of those time stamps, the exhibit numbers. Hank Brennan didn't mention that. So I'm wondering, is he keeping, he doesn't have to say everything he's going to present in opening, but it's certainly very interesting. If you can't hear the microphone, just let me know. I think for some people the audio is better than others. As I mentioned, I'm doing my best as a single towel operation. I'll tell you though, I really do need to go down there. I can, with the right sort of setup, and I think I can figure it out, I can send somebody down there. They're allowed to plug into the actual board that transmits the feed. I can put a dedicated battery and uplink down there, and I can pull the raw feed. The reason I want to do this is that was the pool feed freezing, and I want to see if I can avoid that. In the first issue, if you were watching Hank Brennan's opening, there were some times where the picture on the Law and Crime feed would freeze. That's the pool feed freezing. I have to fix that, I have to actually hook network equipment up to the raw drop, and I can do that. I know what it requires, but I can't do that today. The second thing is, if you're getting buffering on the actual YouTube or you can't hear the sound, just let me know in real time during these breaks. By the way, we're in morning recess. Court is not in session. You haven't missed anything. Absolutely nothing has happened. If that happens, let me know and I can try to fix it on mine. I don't know, but he just showed mortally wounded already. Yes, if you take a look at some of the clips from Hank Brennan's opening, Hank Brennan showing that clip of Karen saying that John looked mortally wounded was devastating. Absolutely devastating. For Karen, for the defense, it was tactical brilliance. And Hank Brennan didn't just deploy a clip of Karen Reed's own words. And remember, we're going to see way more clips. This is opening statements. You don't want to overwhelm the jury. You have a theme and you want them to come away. So Hank Brennan's theme was that Karen Reed hit John O'Keefe and left him to die in the snow. His whole theme was centered around that. You need to reinforce your theme through the different elements and go over the components of the statute, all of which he did, Hank Brennan. But you don't need to go into every granular detail. First, that would make your opening more than 45 minutes, which you only have 45 minutes. Second of all, you don't want to overwhelm the jury, because then the jury is thinking about all these different things. You don't have to prove all these, the breakdown in the relationship and all this stuff. You just have to show the jury that. So very interesting from Hank Brennan, starting at 6:04 or whatever it was when firefighter Flamati arrived on the scene, bringing the jury into the moment, the chaos. You're the juror. You arrive like a first responder. What is all this chaos? Then you start piecing it together. The moment of the impact, the vehicle data, the statements, Karen's words on TV. It was so tactical. And Hank Brennan's crescendo, my word, Hank Brennan's crescendo up to those final moments of his opening was just stunning. Now, I'll see if I can bring it up for you here now that we're actually back to a reasonable pace in our stream together. It took Little Towel, I don't know, 10 minutes to actually get us fully caught up. But let's take a look at the clip that I really want to watch here. Give me 1 second. Where is it? All right, hold on. Why are you bothering me? It's actually my mouse that's being uncooperative. Okay, here's the clip that I want to watch. Not Hank Brennan's full opening, but the clip of Karen. So let me bring it up. Well, by the way, we're in a recess, so as soon as we get out of recess, I'll take us back to the hearing. But if you're just joining in now, we're going to watch what I thought was the most impressive moments of Hank Brennan's opening. So let's take a look at that. We're going to keep court up in the bottom of your screen. So the second court comes back, we'll see it. But let's listen together. Oh, actually, hold on 1 second. Let me make sure that's unmuted. All right, let's watch, folks. Let's watch.
Against the defendant in this case, the first one, second-degree murder. When most people hear murder, they instantly think shooting somebody, stabbing somebody, things, deliberate premeditation. I will start doing the law. I'm not going to trample in that area, but I can tell you clearly, we are not going to try to prove that Karen Reed tried to kill John O'Keefe. We're not going to try to prove to you that she intended or wanted him dead. That's not second-degree murder. What we'll prove to you is she engaged in an intentional act, driving back at him at that speed, in the storm, in the darkness, knowing that he had just gotten out of her Lexus. She intended that act would cause a plain, strong likelihood of death. That's what we'll prove to you for second-degree murder. Also, operating under the influence of alcohol, manslaughter will prove to you that she drove her Lexus recklessly. She hit John O'Keefe and because she hit him and he fell back, she caused his death. The third charge is leaving the scene after knowingly causing death. Again, she hit Mr. Opie with a car. She knew he was injured. She left him behind. And he died. That's the whole group. This case will come down to the science and the data. The science and the data, the cell phone, it is the best of historians. It doesn't suffer from intoxication. It doesn't suffer from memory loss. It doesn't suffer from emotion, pride, or prejudice. It is facts. It is data. And that facts and data will lead you to the truth in this case. But after Ms. Reed was charged, she began what you'll learn as a campaign. A campaign to make public statements. 2020, Nightline, Fox 25, a documentary. And we've had an opportunity to get many of her statements in the footage, and we're going to show much of it. And her statements to you will confirm what you already know from the science and the data, what you will already conclude from the facts independent about what she did that night. Her word is simply confirmed. And many of her statements, her admissions to extraordinary intoxications, her admissions to driving the Alexis, her admissions to being angry at dawn that night, and I dare say her admissions that she told shit to me. But to play for you clip one, you're going to hear the first of the statements that she made after she was charged.
I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
Ladies and gentlemen, I simply ask you to follow the evidence, follow the science, follow the data. Ignore speculation, surmise, conjecture. Stay true to the evidence. It will lead you to the truth.
All right, folks, we're about to come back into session. That was wonderful, though. All right, I'm going to bring up the Law and Crime feed for you here. It is still showing a very annoying fan, but that's all right. We're going to jump forward. I'm going to unmute it. As soon as this comes into session, I'm going to switch over to our main feed here. All right, here we go, folks.
Two men standing. Court is back in session. You may be seated.
All right, Mr. Brennan, your first witness, please.
Thank you, Your Honor. The Commonwealth calls Timothy Nuttall.
Watch your step. And stand and face the clerk.
Raise your right hand. You solemnly swear the evidence given to the court and jury in the case now and herein should be the truth, the whole truth, and nothing but the truth, so help you God.
Sir.
Thank you. You can take a seat.
Sir, could you pull the microphone down a little bit closer to you, please?
Yes, sir. Yes, ma'am. Excuse me.
All right, whenever you're ready, Mr. Brennan.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury?
So my name is Timothy Nuttall. I'm 28 years old. I've been a firefighter paramedic ever since I graduated high school. I graduated in 2015. I took my EMT class and got my certification while I was actually still in high school. From there, I moved on to the BLS transfer side of EMS. There's 911 EMS, and then there's transfer, which is basically back and forth from hospital to hospital. I was brand new and very young, so I started on the transfer side, kind of learning the job. I started primarily in the city of Chelsea, Everett, Malden, Somerville, up there. And then after a little while, I got my feet wet in the 911 side. So I was running BLS 911 in those cities as well. And then I progressed on to become a paramedic. So
why do you have such an interest in being a first responder at a young age?
I kind of grew up in a first responder household. My father was a firefighter in a local town, so we spent kind of a significant amount of time at the station when he was on shift. It's just kind of how I grew up, kind of learning the ins and outs of public safety. That's just kind of how I came to be interested in the profession, and then I took it from there. So
I want to take us back just a little bit. When you first became interested in training to be a first responder, did you share with us your first training was as an EMT?
Yes, sir.
Can you share a little bit with the jury what that entails?
So to become an EMT, there are two sides of EMS, and then there are two sides of providers. There's EMT basic, and then there's paramedic. To answer your question, sir, to start as an EMT, it's about a 4-month process. You take classes. I believe mine was Tuesday, Thursday, every other Saturday. Learning just anatomy and physiology, basic pharmacology, and kind of how medications interact with the body and different disease processes. From there, you start learning basic interventions, backboarding, C-collars.
As part of your work in learning to be an EMT, are you active in the field?
The initial training is, that's mostly classroom-based, but once you sit your national written tests and you're able to pass all that and pass practical, then you're able to progress into the field.
And did you succeed through the EMT training?
Yes, sir.
At that point, did you decide you wanted more training? You want to proceed through the profession?
Yes, sir. So after a little while, I worked for about 1.5 years in the field and decided that I genuinely enjoyed the work that I was doing. I then made the decision to progress to the paramedic level. That's a significantly more challenging academic portion. And
can you briefly share with us a little bit of the training that you needed to complete to be a paramedic?
Yes, paramedic training is about, I would say, generally takes people about 2 years to complete. There's about 1 year of classroom. It delves far deeper into not only diseases, but how they interact with multiple body systems, multiple different treatment modalities that we can pursue, multiple different interventions, a whole host of medications, far more medications than a BLS. As a paramedic, I have a much wider range of drugs that I would be able to select to treat different patients.
As you worked through your training and got this experience, did you ultimately become employed by the Canton Fire Department?
Yes, sir.
What did they hire you as?
They hired me as a firefighter paramedic.
And so you were both a firefighter and a paramedic?
Yes, sir.
Does the Canton Police Department, in their units, do they include paramedics and firefighters in the same division?
The Canton Police Department or the Canton Fire?
I'm sorry, the Canton Fire Department.
Canton Fire Department, the vast majority of the employees of the Canton Fire Department are paramedics. I believe there are I want to say 5 EMTs, but now as a requirement to remain employed by the Canton Fire Department, you have to become and maintain a paramedic certification.
So when you would go to work as a firefighter or paramedic, was it always the same, or did you get assigned as a firefighter one night and a paramedic a different night?
So we would cross-man trucks. We were always fire suppression personnel, but we were also cross-trained as paramedics. So, for example, if a fire call were to come in the town of Canton, and I was assigned to Ambulance 1 for the day, I would take all my equipment off Ambulance 1, and I would transfer it to Ladder 1, and then we would take Ladder 1 to the fire call. and operate as fire suppression personnel. If a medical call were to come in, I'm assigned again to Ambulance 1, then we take on the role as EMS. I take my paramedic skills and put them to work in the town on Ambulance 1.
Let me ask you one more background question about how the Canton Fire Department works. When there's a call, an emergency call, is an ambulance sent with other vehicles or alone to the call?
Yes, sir. It's typically the engine of that district and the ambulance of that district. Depending on call volume, that can change. But if all is not to use the word quiet, it's kind of a taboo word, but if all is everybody's in quarters and there's a dispatch in District 1, it'll be Canton Engine 3 and Canton Ambulance 1, and they go as a unit together.
Mr. Nuttall, I want you to take us back, if you would, to the early morning hours of January 22nd, 2022. I want you to bring us a little bit before 6 a.m. Do you remember what you were doing?
Yes, sir. So that particular morning, I arrived at work earlier than I normally do. There was inclement weather that morning, so I left earlier than normal just to get in before the roadways got particularly difficult to travel and to relieve anybody that may need to get out if they needed to get home before the roads got particularly bad. I arrived just before 6 a.m. I was walking in. I was assigned to Ambulance 1 for that oncoming 24. I was scheduled to be there at 8 a.m.
Could you share with us a little bit about how the weather was as you arrived around 6 a.m.?
It wasn't great. I was driving. It's about a 35-minute ride for me to get to Canton. The roads were starting to get. They weren't great. They had been treated, but they weren't pristine. The wind was starting to pick up. The snow was starting to come down a little heavier, which is the reason that I left at the time I did.
And so I may have misspoke. January 29th, 2022, that morning, around 6:04, did you hear a tone or did you hear an alarm?
So the tones went off right as I entered the building.
Tell us what a tone is.
So the tone is the emergency alert tone. In the town of Canton, we have three. We have one for fire, we have one for investigation, and we have one for EMS. The EMS tones went off and the lights came on. Whenever there's the tones go off, the lights come on as well. I was just walking into the building when the tones went off and the lights came on.
And is there information that accompanies the tone, information about the call that needs response?
Yes. So after the tones had cleared, there's an overhead dispatch, which is our dispatch center, communicates to us before we get in the trucks and on the air responding. Basic nature of the call. In that particular instance, we were dispatched to an unresponsive male in a snowbank with no real further information to follow up on.
So what do you do?
So as I said, I arrived pretty early that morning. But hearing that dispatch and that nature of the call, those typically tend to be more involved, both personnel-wise and work-wise. The crew that was working that morning was getting on the truck, and it was firefighter paramedic Anthony Flamati and firefighter EMT Matt Kelly. Matt Kelly has since become a paramedic, but at the time he was an EMT. So off the bat, that crew, not to say that they were at a disadvantage, but paramedic Flamati was the only paramedic on that ambulance.
What did you do?
So I made the decision. I checked with the shift commander, and I jumped on Ambulance 1 to just give a second set of hands as being a paramedic myself, just being able to hopefully help if there was any advanced interventions that needed to be done or needed to be performed.
What
and
happened?
just a second set of hands.
What happens next?
So I got in the back of the truck. I was actually still in civilian clothing at the time because I had just walked in the door. So I got in the back of Ambulance 1 in the patient compartment. The other two gentlemen were up front driving to the scene. I actually had to don my turnout gear because, again, I was in civilian clothing. I wasn't quite ready to go, so I had to put all my structural turnout gear on and then my Canton Fire jacket. Once I was sufficiently dressed for the call, I started prepping all the gear that we might need for a call such as that, for an unresponsive male in the snow. In this case, it was our first in bag, our airway bag, and our cardiac monitor. Everything was all together. They were all in 3 separate bags. But on the way there, I just got in. I didn't know how their night had gone, so I just took a real quick look at everything just to make sure everything was there, and everything was exactly how it needed to be. So I was able to just grab all 3 bags, put them on my person, and get ready to, so as soon as the ambulance was on scene, just step off and go to work.
Not knowing much information about what you're going to confront, what goes through your mind as you prepare before you get off the ambulance?
Just basic scenarios. I mean, again, unresponsive male in the snow could mean several things. Not having much to go off on the dispatch was, it left much to be desired in terms of what we might need. So in gathering all the equipment together, that can kind of cover all the major bases, if you will, in terms of what we were expecting to meet once we got on scene.
How was your focus before you get off the ambulance?
I was ready to go. A dispatch like that, any unresponsive male in the snow, it can kind of up the level, because you just don't know what you're walking into. You know, it could be anything.
In the back of the ambulance, you can't see outside. Could you tell anything about the weather conditions based on the way the ambulance was moving?
Again, being in the back, as you noted, it just seemed to be taking a little bit longer than normal. I really had no visibility at all. Like I said, I was in the patient compartment. It's very limited visibility in the back, and it's limited visibility. There's like a peephole that's maybe 1.5 feet by 1.5 feet to kind of peek up front. But again, I was so busy getting everything together, I really didn't notice. But I did note it took a little bit longer. We were going not slow, but we were going cautiously.
When the ambulance finally stopped and the doors open, tell the jury what you see.
So as I mentioned, I had the 2 bags and the cardiac monitor, so 3 pieces of equipment with me, and I stepped out of the back or the side of the truck. There's a back compartment, or a back door, and a side door. I stepped out of the side door, and I immediately noted the wind had picked up and the snow seemed to be heavier, and I could hear like a distant screaming off in the distance. Wasn't exactly sure where it was coming from.
What was the visibility like?
It wasn't great. It was still dark out. The sun had not come up yet. The snow was coming down, as I said, heavily, and it wasn't great all around.
Was it cold?
It was cold, yes, sir.
And so when you hear the screams, what do you do next?
I started making my way kind of towards the sound, following the sounds. I couldn't see anybody yet, so I just kind of followed the sounds, and then once I was able to get around the side of the truck, that's when I was able to see a group of 3 individuals with Canton police, and I started making my way over to them to see where the patient might be located and what was going on.
As you get closer, tell us what you see.
So as we approached the scene, as I said, there were 3 individuals, and Canton police were on scene as well, and then there was what appeared to be a human figure laying supine in the snow. I'd say about 6 to 8 feet, kind of where the sidewalk met the front lawn of a residence.
What does supine mean?
So that he was laying on his back. Okay. From there, I made my way directly over to that individual and started checking for signs of life.
How do you check? Do you get close? Do you get down on the ground?
Yep, so I knelt right at his head. Typically, to check for any signs of life, it's just as you see in TV or anything like that. You check the carotid pulse, and you check for any signs of breathing or anything like that.
Where's the carotid pulse?
So the carotid pulse would be right in the neck. Like and just real quick, 2 seconds, you can check either side. They're on both sides. Those are the strongest pulses that you can grab quickly. So I just real quick went right to that gentleman. Like I said, I looked for any signs of breathing. I found none. I checked a carotid pulse, and I found none.
How was his skin to the touch?
He was very cold to the touch.
He wasn't warm?
No.
And so after you touched his cold skin and you felt the carotid artery? Is that how you
Yes, sir, carotid artery.
Did you come to any initial quick assessments or conclusions in your mind?
So I found, like I said, I checked for signs of life, the carotid, the signs of breathing. I found none. From there, we had ascertained that there is no signs of life. As I was checking that, the other two individuals on the ambulance came and met me, and they began doing the same thing, just to check. I mean, sometimes you can look and you can miss. So the other paramedic, Anthony Flamati, started checking my work, and then we kind of went from there. But I found no signs of life in my initial.
So firefighter paramedic Flamati arrived to this person after you did?
Yes, sir. I was the first one to actually put hands on the individual and check for signs of life.
Did you later learn the name of this man?
I did.
And what was that?
John O'Keefe.
After you found no signs of life for John O'Keefe, did you get up and go to speak to anybody?
I did. So as being a second set of hands on the call, it's really not my call, like in terms of treatment modalities and how we want to progress. So after I found no signs of life, I kind of got up to kind of look around real quick. I went over to the individuals, the three individuals that were there, and just said, hey, I just have found no signs of life. We're gonna see the next steps. And as I was saying that, that was when Anthony Flamati, who is the lead paramedic on this, made the decision this is a workable cardiac arrest.
Let me ask you two questions. The first is, as a paramedic firefighter, are there times when you're the lead paramedic on a call?
Yes, sir.
And so it changes call by call, but this one was firefighter or paramedic Flamati's lead?
Correct. He was the lead paramedic on this call.
There are other times when you're the lead and firefighter or paramedic Flamati is on your crew and you lead?
Yes, sir. So we typically switch off. We'll do one, and then once my rotation is complete, we'll do the next one. So it's patient for patient, typically.
When firefighter paramedic Flamati called you back and said it was a workable situation, can you explain to the jury what that means?
Yes. So in medicine, there is a term that is, you're not dead until you're warm and dead. Meaning your core temperature, your core body temperature has to be within normal limits for it to be considered a futile attempt at resuscitation. Noting that, Tony, the other paramedic, Tony Flamati, realized that this gentleman was very cold to the touch and that this was now a hypothermic cardiac arrest, or a cardiac arrest in a hypothermic setting, which means as providers, we have a duty to initiate life-saving measures, CPR, ventilation, and continue those efforts until we get him to a hospital and a physician is able to take over and they are able to monitor his core body temperature for a certain amount of time.
I want to ask you about a term you used. You said a hypothermic situation. As a firefighter paramedic treating a patient at the scene, you're not diagnosing hypothermia, are you?
No, sir.
So you're not making a medical diagnosis, you're just saying it's a hypothermic situation because of why?
Just because of the conditions. He was extremely cold to the touch, and he was in the elements. We didn't know how long, so taking the fact that he is extremely cold to the touch and he had been outside for an unknown amount of time, that quantifies it to us as a hypothermic arrest or a cardiac arrest in a hypothermic setting.
But is there anything about Mr. O'Keefe's fingers or hands or his face that gave you any indication if he had been there just recently or had been there for a while?
His fingers were quite cold. They were not well perfused at all. They were very, very.
Mean? I don't know. What does not perfused mean?
Sorry, there did not appear to have been any blood flow at all. Just because he was, again, presumably being outside, his fingers were very, very white. They were very stiff, which can be signs of hypothermia and frostbite. And again, touching the neck. So typically, when you get cold, you kind of work back from your extremities in. So again, I noted his fingers were quite cold, but also when I checked his carotid, his neck felt quite cold as well. That just kind of tipped us back further down the road of a hypothermic cardiac arrest.
I see. When firefighter Flamati called you back,
yep,
where did you go exactly?
I went, so when I was told that this is what we're doing, I turned around and I went right back to where I previously knelt, which was right at Mr. O'Keefe's head. And then I took over the ventilation aspect of a cardiac arrest. So I was in charge of the airway. So I began giving him positive pressure ventilations with a bag valve mask, which is just a glorified balloon that you can push oxygen through and down into your respiratory tract to get oxygen moving. While I was doing that, I believe firefighter EMT Kelly had begun CPR.
So is this fair to say it's a team effort?
Yes, sir.
A coordinated effort?
Very much so.
And depending on where you're placed, whether in the back of the ambulance or driving or leading, does everybody have an important role to play?
Yes. Yeah, we work in conjunction with each other. Typically, the most well-defined roles in a cardiac arrest in EMS is your airway monitor, which was myself in this situation, and then your cardiac and medication administration, which is that would be Anthony Flamati, that would be Tony. Just because of my position at the head, I just took over the ventilation aspect, and that was where I remained throughout the call.
You said you went back to try to help Mr. O'Keefe, and you were helping at the airway. Do you have to actually get on the ground to do that?
Yes, sir. I was kneeling at his head.
While you were kneeling at his head, well, let me ask you more of a background question. Is it helpful to get information about the history of the person when you're trying to treat them when you happen upon a scene and you don't know the history?
Yes, sir, very much. Getting information on medications, history, and allergies is our top priorities in any call, not even this call, just really any your run-of-the-mill fall or chest pain. That's typically the first questions that we ask. What medications are you on? What medical history do you have? And do you have any allergies? The medical history is important because if you've had heart attacks in the past, or just using a generalized example, if you've had heart attacks in the past, does this feel like a previous heart attack? It kind of gives us something to go off of.
As you were kneeling, I want you to take us to that moment. As you're kneeling, trying to help Mr. O'Keefe, did you have a chance at any point to look up?
I did.
And when you looked up, when you were trying to help Mr. O'Keefe, can you tell us who you saw?
I saw a middle-aged middle-aged female with blood on her face. And real quick, as I was in the process of providing ventilations, I said, do you know this person?
The person that you looked up and saw that was standing over you with blood on her face, do you recognize that person in this courtroom?
Yes, sir.
With the court's permission, sir, could you point out that person that you looked up and saw?
In between Mr. Jackson or next to Mr. Jackson.
I see. And when you looked up and saw that person and asked about any background, what did she say to you?
I hit him, I hit him, I hit him.
How clearly do you remember her words saying to you, I hit him, I hit him, I hit him?
I remember it very distinctly.
You've been to a lot of calls over the years and since.
Yes, sir.
Would you say hundreds or thousands?
Thousands.
Do you remember all of them?
I remember aspects of various calls, but not all of them, no.
Do some stand out more than others?
Yes, sir.
Did this particular moment stand out more as compared to your typical or most calls that you've been to?
It did, just because of the setting. I mean, it was the weather, it was the unknown factors, and it was the attempting to try and get information and not really being able to glean anything from that.
After the defendant said to you, I hit him, I hit him, I hit him, did you ask any follow-up questions?
I really didn't get a chance to, because following that, the individual just kind of walked away, or just kind of went in a different direction. I wasn't able to ask any follow-up questions.
Have you ever received any police training?
No, sir.
Are you a police officer?
No, sir.
When you're helping a patient, do you have any interest in detective work?
No, sir.
Do you have any interest in investigating potential crimes?
At that time, in this particular instance, because I was at the airway, that is a pretty critical aspect of a cardiac arrest, I was stuck there. I couldn't get up and kind of follow up on that at all. I was there doing that ventilation.
Is it your job to investigate cases or simply to get information to help treatment?
Just the information.
When you go out as a firefighter paramedic, do you have a purposeful cause?
Yes, sir.
And what is that?
To save lives.
And is that your only focus?
In this instance, it was attempting to restore circulation and breathing.
At some point with your colleagues, did you lift Mr. O'Keefe from the ground?
We did.
When you lift him, what do you put him on?
So we put him on, it's called a scoop stretcher. It's basically just a hard plastic moving device with some seatbelts on it, just to get the patient up and onto the stretcher, and then from there we can move from the stretcher to the ambulance.
After you lift him to the stretcher, tell us what happens next.
So we put Mr. O'Keefe on the scoop stretcher, and we were able to get him onto the stretcher itself and then off to the ambulance. From there, I maintained my role as the airway individual on this call. So we made our way to the ambulance. I got in the tech seat, which is directly behind where the stretcher locks in, so I had access to the airway again. I was continuing to provide positive pressure ventilations to Mr. O'Keefe, and we had put in an OPA as well, which is just a plastic hook, if you will. It just keeps the tongue from falling back into the airway, so we can continue to provide positive pressure ventilations. Once we got him in the truck and we continued that effort, we set up a suction system, and we prepared to intubate Mr. O'Keefe. We prepared a suction system just because as I was ventilating outside of the ambulance, there were some secretions in the airway that I could see, and you could kind of hear it as you go to squeeze in breaths into the individual. You can kind of hear the secretions kind of getting like bubbly and stuff like that. So we knew we were going to need to suction him. So we got him in the truck, we really quickly suctioned him, and then we were able to intubate him successfully to definitively give him an advanced airway and give him better ventilations, get more oxygen into his system.
Now, you mentioned that he wasn't warm, he was very cold.
No, he was still very cold.
What does the team do to try to assist with that?
The most basic thing that we did, we turned the heat on as high as it would go. We also stripped all of his clothing off, just getting all of that wet clothing off of him. I didn't really have a role in that particular part of it, just because once you're on the airway, that is kind of yours. Nobody can breathe for him, so every time I squeeze that bag, he gets a breath. So I'm kind of tied to that airway for the duration of the call.
So when your colleagues are stripping the clothes off him, is your attention on the clothes or more on the airway in your job?
No, I'm maintaining the airway. If an endotracheal tube is dislodged for whatever reason, it is typically more difficult to get one in. So the integrity of that tube staying where it is and not being dislodged, that is another key aspect of airway management.
As you're doing that, do you notice what any of your colleagues are doing to help?
Like I said, they were working on clothing removal. I believe they were also getting intravenous and intraosseous access on this individual to begin medication administration. But again, I was quite focused on that airway, just making sure that it was maintained and we didn't lose any tube. We didn't lose any end-tidal CO2, which is just another monitoring device that we use to confirm that tube is in place.
How quickly do you get to leave the scene and start moving towards the hospital?
I honestly couldn't give you an accurate estimate. It didn't seem to be out of the ordinary realm, though. We were able to move within the flow.
In addition to Mr. Keefe being very cold, did you notice any other injuries on him?
So I noted that he had a hematoma right above his right eye.
Could you explain to us what that is?
Yep, it's just, for lack of a better term, it's just a big egg. He had a pretty good bump over his eye.
And you said his right eye?
Yes, sir.
Did you know how that hematoma was caused?
No, sir.
No idea?
No.
In addition to the hematoma above his right eye, what other injuries did you see?
There were also several scratches on his right arm, just below his shoulder, and traveling down his right humerus. They terminated right about his right elbow, just above it.
Those scratches, have you also described them as abrasions?
Yes, sir.
Is there any difference in your mind, difference between scratches and abrasions?
Nope. These were they were deep, and they were not bleeding, but they were notably deep.
Did you ever describe it as furrows?
I did.
And in describing those scratches, do you have any idea how they were caused?
No, sir.
Okay. And did you notice any other injuries on Mr. O'Keefe?
No, sir. Those were kind of the only ones that we noted. As I mentioned, we suctioned a little bit of blood out of the back of his airway as well. I believe it was blood, mucus, and saliva. But those were the extent of the injuries that I was able to note.
Did you notice anything about the back of his head?
Actually, yes, I did. I apologize. There seemed to be a little bit of matted blood around in his hair around there. Really didn't see anything too obvious at the time. He was also placed in a cervical collar as well, following intubation, and that was kind of there just to maintain his cervical spine. But there was, like I said, there was noted to be a little bit of dried blood on the back of his head.
At some point, did you finally make your way with Mr. O'Keefe to the Good Samaritan Hospital?
Yes, sir.
And just share with us what happens when you get there.
So after we got there, we handed off care to Good Samaritan Medical's physicians and ER nurses. We were able to give a report to the physician of just basic what we've done, what we've given for medications, in my case, what he was intubated with, and how he was being ventilated, how well he was being ventilated, and any other further pertinent information. Typically, we noted that Tony was the lead paramedic, so that is typically his. He kind of holds the room for a minute when we get in there and gives a big rundown, and then we back off and let Good Samaritan take over.
When the defendant told you that she hit him, did that have any significance to you?
No, sir.
Did it reconcile with the injuries that you saw before you that Mr. O'Keefe was suffering from?
No, sir.
And so at that point, was that information insignificant in perspective of your care?
Objection. Sustained.
Okay. What role did that information play in your care after the defendant told you she hit him? How did that contribute or not contribute to what you were doing?
It really didn't help at the time. Again, I wasn't able to chase anything down from that. I just kind of took it, noted it, and moved on with my aspect of the cardiac arrest.
Okay. Have you had an opportunity at any point to see any video of that morning taken from any source, a police car, dash cam?
Yes, sir.
Okay. All right, I'd like to introduce a video stream.
Okay. So this will be in evidence? There are agreements with some of the evidence already?
I believe there's no objection, but I don't want to speak for the defense.
There's no objection.
Okay, thank you. Yes, you can show it.
And for the record, if I may note, this is Cruiser 683 Stream 2.
I'm sorry, what?
I'm sorry. It is Cruiser 683 Stream 2. I'm going to ask to play a portion of it that's relevant to Mr. Nuttall. Ms. Gillum, if you would please move to 6:11 a.m. Please stop the video. Mr. Nuttall, do you see the red lights reflecting on the left?
Yes, sir.
Do you know what those red lights are?
Presumably those would be ambulance 1.
Yeah, so not what you presume. Do you know what they are, sir?
Those are the lights for ambulance 1.
Do you see the weather conditions as it's depicted on this video?
Yes, sir.
Oh, as you stood outside, was it same or different to how it appears in this video?
That is the same.
When you look to the left, you see a straight line about an inch or two from the left of the screen. Do you know what that item is?
Sorry, sir. Repeat the question.
If you look to the left of the screen, you'll see a straight item from the bottom halfway up the picture. Do you know what that item is?
I believe that's a flagpole, sir.
Okay. Do you see a little bit of movement of bodies near that flagpole?
At the present time, no.
Okay. Could we continue to play, please?
Yep, there they are.
Could you stop, please? Did you see the first person in line now behind the person with in front of the person with the blue hat?
I'm sorry, sir. Could you back it up like 10 seconds?
Certainly. Keep going, please. Do you know who that person is?
I believe that's me, sir.
Okay. Could you please continue? Is this your first assessment?
Yes, sir. This is ascertaining any signs of life or breathing.
Is that you approaching?
Yes, sir.
Could you stop, please? After informing you return, is that after firefighter Flamati called you?
So right after that, when I turned around, that was when Tony said, "Hey, we're working this."
Okay. Please continue. Stop, please. And do you see a person come over to where you are?
Yes, sir.
Is it at that point or another moment when the defendant said, "I hit him, I hit him, I hit him"?
It was right there, sir.
Could you continue, please? Could you stop for a moment? There's no voices or noises from people coming through that audio. When you were there that night, throughout the event, was it silent or were people speaking? Did you hear people speaking?
There was, as I noted when I got out of the truck, there was quite a bit of screaming. It was quite chaotic. The wind was also a factor, but there were people around. They were speaking within themselves too, but there was screaming, there was wind, and there was different side conversations as well.
And when you were working on Mr. O'Keefe, were you having conversations with your colleagues?
Yes, sir.
They're not picked up on the audio?
No, sir.
Please continue. Sir, are you still at the flagpole?
Yes, sir. I'm kneeling at the head of the patient.
Are you included in that group of first responders?
I am not, sir. I have actually exited to the side with the bags. I believe I'm entering the ambulance at this point.
Okay. Thank you. We can conclude the viewing. With the court's permission, I'd like to approach and show a few exhibits to Mr. Nuttall. They've been shown to the defense.
Yes.
Thank you. May I approach?
Yes.
Thank you. No objection. Okay. Can I show you a photograph?
Yes, sir.
Sir, do you recognize what's in that photograph?
Yes, sir. Those are the scratches on Mr. O'Keefe's arm.
Does that appear the same as when you saw his arm that morning, or is there any differences? And if there's any differences, can you share them with us?
That appears how they were to me at the time of the incident.
Okay. May I approach you, Dan Garland?
Yes.
I'd like to introduce this as an exhibit, please.
Okay.
Here also.
I'm going to hand you a...
Hold on.
I'm sorry.
Thank you.
Pardon me, all right. May we publish to the jury?
Yes.
Is that the photograph you just identified on the screen?
Yes, sir.
Showing you a second photograph, I'd like to ask you some questions about it.
Can we take that one down, Mr. Brennan?
Yes, of course.
Please, Ms. Gilman.
Thank you. Does that photograph, do you recognize that area?
Yes, sir.
Is that the same or substantially the same area where you helped try to treat John O'Keefe?
Yes, sir.
Does that look to be a fair and accurate representation of the area?
It does.
With the court's permission, I would introduce this as an exhibit, please.
Okay, and there's no objection to any of these three?
None.
Okay. Yes.
Thank you.
Exhibit 2.
Thank you.
With the court's permission, could I publish exhibit 2?
Yes.
And sir, that's what you recognize as the area where you were helping to treat John O'Keefe?
Yes, sir.
I've left one last photograph in front of you.
Yes, sir.
And do you recognize that?
I do.
Tell us about any differences between when you were there and what you see in that photograph.
The street appears to be plowed. There's bare pavement. The weather conditions are significantly better. It is also daytime.
Okay. If we could take down that exhibit 2, Ms. Gilman. May I approach, Your Honor?
Yes.
I would move to introduce this as exhibit 3.
All right.
Exhibit 3, so marked.
With the court's permission, I'd like to publish exhibit 3.
Sure.
Is that the photo you just identified?
Yes, sir.
Okay, we can take that down. Thank you. Thank you, sir. I have no further questions, Your Honor.
All right. Jackson?
Thank you, Your Honor. May I?
Yes, please.
Good morning, good afternoon, Firefighter Nuttall.
Good afternoon, sir.
Nice to see you again.
You as well.
Before your testimony this morning, how many conversations had you had with any member of the prosecution team in anticipation of your testimony today?
I believe it was 3, sir.
When were those?
I could not give you dates off the top of my head.
Give me a time frame. Within the last 3 weeks, within the last 3 months, last 3 days?
Within the last 3 weeks, I believe one the week after that, and then one last night.
One?
Last night.
Last night. What you did discuss, let's take them in order. First of all, who'd you meet with 3 weeks ago?
I met with Mr. Brennan and his staff.
And when you say his staff, who else?
I honestly couldn't tell you, sir.
Mr. Lally?
No. No, sir.
Male, female?
One female and one, I believe, state trooper.
Okay. Had you ever met State Trooper Tully previously?
Yes, sir. Actually, I believe that was him.
It was State Trooper Tully?
Yes, sir.
Whom you've met with several times, correct?
Prior to that, I believe only once or twice.
He was the one that he has formally interviewed you previously, correct?
I believe he arranged the meetings with Mr. Brennan.
Okay.
But, beyond that, I can't speak to.
What did y'all discuss 3 weeks ago?
The first meeting, going in order, it was mostly just kind of an introduction. I had not met Mr. Brennan yet. I really didn't know him. So it was mostly that, and then just kind of seeing where we were at with testimony, going over previous testimony and in that sort of realm.
Prior to today, how many times have you testified under oath concerning the incident on January 29th, 2022?
Once at a grand jury hearing and once last year.
All right. As a matter of fact, last year in this courtroom.
Yes, sir.
Okay. Did you look over your testimony at the grand jury 3 weeks ago during that meeting?
No, sir.
What about the testimony from last year?
We did go over the testimony from last year, yes, sir.
Were there any issues that Mr. Brennan or anybody else in that meeting brought up concerning any of your testimony?
There was just a question of how many times the I hit him came up. It was 3 times.
And were you advised that that's not what you said at your testimony last year?
No, sir.
2 times?
What was that?
You said it was 2 times last year?
I honestly can't recall, sir.
Okay, but you just saw that, or you just read that and went over that 3 weeks ago.
I believe so, sir, yeah.
But you can't remember, as you sit here today, just 3 weeks ago, what y'all discussed in terms of how many times you previously testified that you heard the phrase, I hit him.
So previously testified possibly to 2, but it was 3.
Okay, your memory is clearer now than it was, for instance, a year ago when you testified.
Repeat that?
Sure. Your memory is clearer now, as you sit here, that it was 3 times you heard that, than it was a year ago when you testified that it was 2 times.
Yes, sir.
Okay. Does your memory get better with time generally? Your memory. I'm not talking about the royal you. I'm talking about you.
In certain settings, I mean, there are certain things about different aspects that I recall better than others.
Okay. And does your memory tend to get better, or does it fade over time? That's my question.
It can fade over time, but it depends on the context.
But in this case, you're telling this jury that your memory is better now than it was a year ago when you testified about the exact same circumstance, correct?
Yes, sir.
Okay. You then met about a week after that, which would be 2 weeks ago.
Yes, sir.
Who'd you meet with then?
The same group.
And what did you discuss at that meeting?
Again, just prior testimony, and that was really the gist of it.
And tell me the specifics of the prior testimony that you...
Again, it was the how many times we had talked about saying I hit him. Again, it was 3 times. And then there was also the video that was just played for me.
If I'll take the video in just a second. If y'all had met 3 weeks ago and you indicated to Mr. Brennan that it was actually 3 times, not 2 times that you heard the I hit him, why did you need to discuss it again a week later to verify the 3 times versus 2 times?
I'm not sure, sir. That was just the way that the conversation went. And I just, again, repeated what I said and what I remember from that morning.
Well, tell me about that conversation. Did Mr. Brennan say anything like, well, are you really sure that she said it 3 times?
It was that morning what was said to you. And I said, I hit him. That was how it went that morning, and that was how I remember it.
Okay. And did Mr. Brennan say, well, that's not consistent with how you've testified previously concerning the number of times you heard the I hit him phrase?
Yes, sir.
He did say that.
He wanted to he acknowledged that I had said it twice. However, again, as I mentioned, it was said 3 times to me.
So now you do remember last year that you only said it, that you only said that it was repeated twice.
One more time, sir.
So now you do recall that last year when you testified, it was inconsistent with how you're testifying today. Let me put it that way, correct?
I believe I said I hit him twice on the stand last year.
Right. And if you're saying I hit him 3 times instead of twice, that firefighter Nuttall is inconsistent with your testimony today, correct? You
Yes,
agree
sir.
with that?
But that is how it went that morning, though, sir.
Okay, that's not my question. Let me see if I can do it again. So I'm asking you, if you testified last year,
Yes, sir.
that you heard the phrase twice, and now a year goes by and you're testifying in front of this jury this year that you heard it 3 times, those 2 statements are inconsistent with one another, correct?
Yes, sir.
Okay. Did you talk at the meeting 2 weeks ago about any other inconsistencies with your testimony?
Not to my knowledge, sir.
Well, you were there, and you
No.
say not to my knowledge, meaning...
No, sir, we did not.
Okay, so it was just about the number of times that you heard the phrase, I hit him, correct?
Yes, sir.
All right. You cleared that up in the 2 meetings, 3 weeks ago and 2 weeks ago. What did you talk about last night?
Mostly just making sure that everything was as it had been. I mean, and by that I mean it was 3 times, and that we were continuously making sure that everything was the way that it had happened that morning.
Everything was the way that Mr. Brennan wanted it to be.
No, sir. The way that it was in, I remember it, and I recall it happening.
Okay, so he asked you 3 weeks ago about how many times you heard that phrase.
Yes, sir.
You changed your testimony at that time and said it was 3 times instead of 2 times. We agree on that, correct?
Yes, sir.
Then he called you a week later, or met with you a week later, and again reiterated, making sure you stick with that testimony that it's 3 times, not 2 times, correct?
Yes, sir.
And then last night he called you just to make sure one more time you're going to stick with that testimony that it was 3 times, not 2 times, correct?
Yes, sir.
Hold on just a second. May I have just a moment, Your Honor?
Yes.
Okay. And when you talked last night, did you assure Mr. Brennan, nope, when we come in tomorrow, I'm certainly going to say it was 3 times, not 2 times?
No, sir. I told him I would tell my recollection of that morning.
Okay. And did you tell him that what my recollection is, I'm going to tell the jurors it was 3 times that I heard it?
That was what I heard.
Okay. Did you tell him that's what you were going to say today?
No, sir.
You didn't?
I told him I was going to tell him what I remembered from that morning.
Which was what?
I hit him, I hit him, I hit him.
Which is how many times?
3 times, sir.
And that's inconsistent with what?
I believe a year ago.
Okay. Now, you also talked about, I want to get back to the other thing that you talked about. You said that at some point, either in the meeting 3 weeks ago, the meeting 2 weeks ago, or the meeting last night, you were shown a video.
Yes, sir.
Which one of those meetings were you shown a video?
I believe the second one.
Okay. Were you shown the entire video?
No, sir.
Just the clip that we saw?
Yes, sir.
Okay. What did y'all talk about in relation to that video?
Mostly nailing down who was who in that video.
Okay.
Being the other personnel on scene, where I was, and that was about it.
He showed you the clip that you showed. He showed you the clip that you just seen on direct examination, correct?
Yes, sir.
Did you tell him where you were?
Yes, sir.
Did Mr. Brennan ask you to define exactly where it was that you supposedly heard this phrase, I hit him?
No, I was able to give that to him, sir.
Okay. And what you told him was that moment when you see my client walk over sort of to the left of the screen, correct?
Yes, sir.
And you defined, that's the point at which she said, I hit him, I hit him, I hit him.
Yes, sir.
And that's in response to your question. I want to make sure I'm clear about this. You asked, do you know him?
Yes, sir.
And she repeated the phrase 3 times, I hit him, I hit him, I hit him.
Correct.
Okay. We'll talk more about that in just a second. Did Mr. Brennan ask anything else about that specific video?
No, like I said, he kind of asked me to point out different individuals on the scene, and that was really the extent of it.
You saw that same video last year when you testified, correct?
No, sir.
You didn't see it last year?
Not to my knowledge, no.
In preparation for your testimony last year?
I did not.
Did you see it before your grand jury testimony?
No, sir.
Okay, so this is the first time that you've seen it?
Yes, sir.
All right. And you were able to establish for Mr. Brennan exactly when it was that you believe you heard the statement based on your view about 2 weeks ago of that video?
No, that was the way that I remember it.
Right, but not a trick question. My question is much more simple. You were able to establish after than 3.5 years now, exactly where you were and where Miss Reed was and who else was around at the time that you believe you heard those 3 statements in order. I hit him, I hit him, I hit him.
Yes, sir.
Okay. You testified last year as well that there is a normal protocol for removing clothing from a patient, and it's essential to just discard it and get it away from the patient so that you can concentrate on the life-saving measures that you're undertaking, correct?
Yes, sir.
That could be done you said in the ambulance, it could be done in the hospital, it could be done in situ, out there in the field, correct?
Yes, sir.
But the point is you want to get as much clothing off of the person as possible so that you can assess that person's physiology.
Yes, sir.
There's not really a lot of care taken to preserve the clothing from an evidentiary standpoint, in your view, correct?
And we're trained to try and, just to take example of a shooting, try not to cut through the entrance wound of the clothing.
Fair enough, fair enough. I mean, when you're literally trying to save someone's life, your job is to get the clothing off and get it out of the way.
Yes, sir.
You're not sticking it in an evidence bag and sealing the evidence bag, things of that nature.
No, sir.
So it might end up on the ground.
Yes.
Right? Might end up with some debris on it.
Yep.
Might end up on the floor of the ambulance.
Yes, sir.
Could end up in the floor of the hospital, or on the floor of the hospital. Is that right?
Yes, sir.
Okay. And if it's tossed in the floor of the ambulance, the clothing may well pick up debris from the ambulance.
Oh, yeah. Yes, sir.
Or the debris from the floor of the hospital or wherever. Is that yes?
Yes, sir.
Okay. You testified previously at the grand jury in April of 2022, correct?
Yes, sir. I believe so, sir.
Okay. So this happened in January of 2022, that same year in the springtime. You testified at a grand jury, April 20th, I think it was.
Yes, sir.
Does that sound right?
Yes.
Okay, I want to take you back to that testimony for a second. You testified at that hearing that Mr. O'Keefe was, quote, dressed appropriately for the weather. You remember that?
Yes, sir.
All right. It was obviously well below freezing at that time.
Yes.
That night that you responded?
It was.
We've just seen the video. It looks cold as hell, right?
It was chilly.
All right. The wind was howling.
Yep.
It was snowing. Is that right?
Yes, sir.
And you testified that John O'Keefe, quote, had a heavy coat on and possibly 2 other layers of clothing.
Yes, sir.
In April 2024, you reiterated your very specific memory of and you even called it a puffy heavy coat that he was wearing, which was then removed so that you could assess his injuries, correct?
Yes, sir.
All right. Not to get too colloquial, but a puffy coat is like got down and stuff in it, right?
Correct.
Looks kind of like Stay Puft Marshmallow Man, right?
Yes, sir.
Okay. Pretty distinctive article of clothing.
Yep.
And you testified last year that Mr. O'Keefe was wearing that clothing, which you had to remove, or somebody had to remove, in order for him to be properly assessed.
I did testify that way, yes, sir.
Okay. And you mentioned that your memory of that big, heavy winter coat was as clear as your memory of other specifics in this case, correct?
Yes, sir.
I asked you that exact question, didn't I?
You did.
And I said, your memory of him having that big, puffy coat on, which stood out in your mind, was just as clear as the other specifics that you've testified to about the case.
Yes, sir.
About that night. And turns out you were completely wrong about his clothing, correct?
Correct.
Matter of fact, he wasn't wearing a coat at all.
No, sir.
He wasn't wearing a winter coat, correct?
Nope.
He wasn't wearing a heavy winter coat, correct?
Correct.
And he wasn't wearing a puffy, heavy winter coat.
He was not.
Yet you testified that he was wearing all of that, and that was clear in your mind at the time.
Yes, sir.
Did Mr. Brennan bring that up during the meeting 3 weeks ago?
He asked about what I had meant when I said appropriately dressed.
So you did talk about something other than just the I hit him, correct?
Yes, sir.
When I asked what y'all talked about, why didn't you tell us that?
To be perfectly honest, sir, I did not remember until right now.
So your memory is fading even after 3 weeks.
Yes, sir.
Got it. The fact is, well, let me ask you a different question. Did Mr. Brennan tell you what Mr. O'Keefe was actually wearing?
No, sir. Actually, I believe you did.
Last year, didn't I?
Yes, you did.
It's a short sleeve t-shirt and a little thin wool hoodie, right?
Yes, sir.
Okay. Wasn't wearing a hat?
No, sir.
Wasn't wearing, as a matter of fact, didn't even have a shoe on, correct?
Not to my knowledge.
And obviously, goes without saying, but I'm going to ask it anyway, that's not being appropriately dressed for the winter.
No, sir.
Yeah. You indicated that you did notice certain injuries on Mr. O'Keefe's person.
Sir.
Once you got him back in the ambulance, obviously it's lighter, meaning brighter lights. You have more equipment in the back of the ambulance. You can better assess somebody's well-being, correct?
Yes, sir.
And you indicated you had a, quote, much better picture of what we were dealing with, correct?
Yes.
You noticed once in the back of the ambulance that he had trauma to the right side of his head.
Correct.
And as a matter of fact, when you were pointing at it, I'm doing that on purpose because you pointed to the right side of your sort of forehead above your right eyebrow, correct?
Yes, sir.
Okay. The majority, or the worst injury that Mr. O'Keefe suffered was actually to the back of his head, which you indicated, you noted, was quite matted with blood, correct?
Yes, sir.
I want to talk about the injury to the right side of his head as distinct from the back of the head injury for just a second. Before I get to that in detail, let me ask you, because I just sort of want to cover the bases. You noted the back of the head injury, correct? Is that yes?
Yes, sir.
You also noted the front right side of the head above the right eye, correct?
We did.
You noted some injury to his eyes. They looked blackened.
Yes, sir.
But primarily the right eye was blackened.
Yep.
And there was a golf ball size egg, I think you put it, over his right eye. Often called a hematoma.
Correct.
And you also noted when you got his shirt off that he had scratches along the right side of his arm. Is that right?
Sir.
You indicated on direct examination today that you believe those scratches ended where? Meaning from top to bottom? And I'm not using anatomically correct language. So from shoulder to wrist, where were the scratches that you noted?
There were several. As I noted, they were on his right humerus area.
Tell me what a humerus is.
The right arm.
Biceps.
Right about here.
Okay.
No, a little further, like between where your bicep and your tricep kind of meet.
Got it.
Right about in there.
Okay. And what did the scratches look like?
They were deep. They infamously referred to them as furrows. But they were quite deep. You could tell that there had been some material removed.
Okay. Material meaning skin and flesh?
Yes, sir.
Okay. Some biological material?
Mm-hmm.
Is that yes?
Yes, sir.
And were they parallel? Meaning they were going in the same direction?
Yes.
Were there any scratches below the elbow as well?
There were. Yes, there were. They were not as significant as the ones in the upper arm, but they were noted.
Okay. And those were parallel as well?
Yes, sir.
And they looked like scratches to you. That's how you described them?
They did.
Last year, when you described those scratches, you curled your fingers up, exposing sort of the nails, and drew it across your biceps. Is that what you were using to describe what the sort of scratches looked like?
I just kind of used that as a landmark, to be honest with you, sir. It was just kind of how I quantified it in my mind.
Okay, but what you did was you did this motion.
Yes, sir.
As you said, there were furrows, and remember there was an embarrassing moment for me.
Both of us, sir.
I couldn't understand the word furrow because of the accent, right?
Yes, sir.
All right. Let's talk a little bit about the hematoma above the right eye for a second. That's basically damage to subdural blood vessels that causes acute swelling, right?
Correct.
And a very common cause of a hematoma over one's eye could be being hit or punched in the face. We talked about that.
There could be several causes for hematoma, such as that.
Obviously. I mean, it could be a golf club, a baseball bat, or it could be a fist.
It could be.
Okay. We talked about that last year. I asked you if the injuries that you saw on Mr. O'Keefe's face, including the laceration over his right eye, was consistent or inconsistent with a physical altercation, and you said it was consistent with a physical altercation as well.
Excuse me?
Objection to referring to past testimony before a question is asked.
So sustained.
Sure. Do you remember a laceration, in addition to the hematoma, about a 0.8 centimeter laceration over his right eye?
I do.
Tell me I'm using a word that maybe not everybody understands. I didn't understand it when we first started this thing. What's a laceration? What's the difference between that and a cut?
A laceration is they're basically the same thing. A laceration is just a deep cut.
Okay. So it's a parting of the skin.
Correct.
In other words, where the skin separates.
Yes.
And that can be from blunt force trauma, meaning something hits it rather than cuts it.
You can get
sustained.
What are some of the causes of lacerations?
You can get a laceration, as you noted, blunt force, but you can also get a laceration from a slashing movement, from a stabbing. I mean, that is still a laceration.
What about a hematoma?
That is primarily caused by blunt force trauma.
Right. And the hematoma and the laceration were right next to each other, correct?
Yes, sir.
Okay. And you indicated last year, or let me ask you this way. Is that consistent or inconsistent with a physical altercation?
Objection.
Can you answer that?
I could not say, Your Honor.
Okay, next question.
Well, last year, you indicate you can't answer that. Last year, you did answer it, didn't you?
Objection.
So I need to see counsel at sidebar for just a minute, please.
Hi, I'm a towel. That was very interesting, wasn't it, folks? Now, what's very interesting is we have a live view of the courtroom about 40 seconds ahead of time, so we know when the court is going to come back. Hold on one second. We already have a view of Karen Reed. I think it's very interesting that because Towel has permission to broadcast this very unique feed, we have a view of Karen Reed for this entire trial. She is going to be on camera for 6 weeks on this stream. Other streams may not have figured it out, but Little Towel, oh yeah. And I think it's because most streamers can't get access to this feed. The only people who have access to this are credentialed media, so there you go. We can actually see the full unique perspective here. Give me 1 second. I don't want to miss the shot of Mrs. O'Keefe. I'm switching screens here because I'm a towel. We are in sidebar, folks, by the way. We are in sidebar. We're a little bit into lunch already of day 1 of the Karen Reed and John O'Keefe trial. There is certainly a lot going on. There is a witness up on the stand you can still see, and we are just waiting for Judge Canoni to come back into session. I'm going to get rid of that main window for you. No. I missed the shot of Miss O'Keefe. I'm so sorry. Well, I'm a one-towel operation over here, folks. I am a one-towel operation. You know what we can do, actually? Because I'm a one-towel operation, I can command my one-towel operation to go back about 40 seconds. Not that far, just about that far. And we can watch Miss O'Keefe, because I think eventually the camera goes to Miss O'Keefe. And then all right, we're about to come back, folks, so I'm going to jump ahead. Let's see if we can get at least one shot of Miss O'Keefe now. There we go. Hi, Miss O'Keefe. Towel loves you, Miss O'Keefe. All right, I think it's going to be lunchtime when we come back, folks, so let's watch this together. You can already see Judge Canoni kind of motioning that it looks like we're heading into lunch, but let's wait for formal confirmation from the Law and Crime stream. Oh, there's John's brother, Paul. Very nice to see you, Paul. Oh, yep. Okay, so we are formally in lunch recess, folks. So, gonna just take a listen now. You can see we're in lunch recess because we got kicked out of the Zoom in the courtroom. They don't put it on pause. They just restart
Mr.
it.
Nettle, we are going to let you take a break and come back and join us after the lunch break. So this is
Sounds good.
The lunch break. There's lunch here for you. I assume, Tony, is it here?
It is here.
Okay. There's lunch here for you. We'll see you in about a half an hour.
All right, there you go, folks. So I am not going to make you watch The Fan. I'm not going to make you dizzy, but we can take a look at some of what just went on during the first day of the Karen Reed and John O'Keefe trial. That was certainly very, very interesting. I think this moment where Hank Brennan used Karen Reed's own words against her was the most interesting. Sorry, you're hearing the line. So I'm going to leave the Law and Crime feed muted. We are formally on break until 2 o'clock. My name is GrantSmithEllis. I'm very interested to hear all of your thoughts as to the ongoing situation. We actually we're getting we're actually getting an overview on Law and Crime. This is great. Let's watch it, actually, folks. Give me 1 second here. We're gonna watch Towel's overview of Hank Brennan's opening as well, but for now let's watch the Law and Crime highlights. Although that last Law and Crime sound bit was a little bit loud, let's watch a little bit of what Law and Crime has to show us here.
4, 3, 2.
We are here today because John O'Keefe was killed by the actions and conduct of that defendant, Karen Reed.
There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty.
2, 1, go.
Hey there, everybody, and welcome to our special live lunch.
All right, so there was definitely a hot mic there. We don't have to... I like Law and Crime's feed, but we don't have to watch that. Instead, let me bring up for you what I thought was the most impactful part of the first day of the Karen Reed and John O'Keefe trial, and that was Hank Brennan's use of Karen Reed's own words against her. Let's watch it together, friends. Let's watch it together.
Against the defendant in this case, the first one, second degree murder. When most people hear murder, they instantly think shooting somebody, stabbing somebody, spraying, deliberate premeditation. For all I will instruct you on the law, I'm not going to trample in that area, but I can tell you clearly, we are not going to try to prove that Karen Reed tried to kill John O'Keefe. We're not going to try to prove to you that she intended or wanted him dead. That's not second degree murder. What we'll prove to you is she engaged in an intentional act, driving back at him at that speed, in the storm, in the darkness, knowing that he had just gotten out of her Lexus. She intended that act would cause a plain and strong likelihood of death. That's what will prove to you second degree murder. Also, operating under the influence of alcohol, manslaughter will prove to you that she drove her Lexus recklessly. She hit John O'Keefe, and because she hit him and he fell back, she caused his death. The third charge is leaving the scene after knowingly causing death. Again, she hit Mr. O'Keefe with a car. She knew he was injured. She left him behind. And he died. That's the whole group. This case will come down to the science and the data. The science and the data that the cell phone is the best of historians. It doesn't suffer from intoxication. It doesn't suffer from memory loss. It doesn't suffer from emotion, pride, or prejudice. It is facts. It is data. And that facts and data will lead you to the truth in this case. But after Ms. Reed was charged, she began what you'll learn is a campaign. A campaign to make public statements. 2020, Nightline, Fox 25, a documentary. And we've had an opportunity to get many of her statements in the footage, and we're going to show much of it to you. And her statements to you will confirm what you already know from the science and the data, what you will already conclude from the facts independent about what she did that night. Her word simply confirmed. Lips in many of her statements, her admissions to extraordinary intoxications, her admissions to driving the Lexus, her admissions to being angry at dawn that night. And I dare say her admissions that she told the victim. But to play for you clip one, you're going to hear the first of the statements that she made after she was charged.
I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
Now, notice, folks, Alan Jackson misled the jury. Alan Jackson tried to say that Karen Reed talked about seeing John mortally wounded later in the morning. She didn't. Her own words just confirmed that Karen was talking about when she dropped John off at 12:31. Alan Jackson misled the jury. They're going to think he's a liar. They're going to think that he's a liar. No, Cookie Ramlald. Exactly. What a prescient question. I don't think they can get away with that. I really don't think they can get away with that. Because it's just so blatant. It shows that Karen Reed, in her own words, there's nothing ambiguous about that. There's nothing ambiguous at all. Karen Reed said she was talking about the moment she dropped John O'Keefe off when he got out of the car and she allegedly hit John with her car at 12:32 a.m. while going 24.2 miles an hour in reverse while drunk with a BAC between 0.13 and 0.29, according to the evidence. They're going to think Alan Jackson lied. Because he did. Alan Jackson told the jury that Karen said that at 6-something in the morning. Because every single time that comes up, it's going to be clear in Karen's own words that it's such a key section of this whole case. When Karen said she saw John not looking, quote, mortally wounded, it was referring in Karen's words to the exact moment, 12:32 a.m., when she dropped John off on that lawn and allegedly struck John while drunk driving and going backwards at 24.2 miles an hour with a BAC between 0.13 and 0.29. Murder by Maestro. Oh my God, my friend, did you hear my clairvoyance? I was thinking all day, I can't wait to see Murder by Maestro pop in. I bet he's working, and then he's going to come back and he's going to be like, I rushed home and I was excited to see you all. And I'm going to be like, oh my God, it's Murder by Maestro. And that's exactly what happened. It happened again. All right, hold on, folks. Hold on. It's not you. It is not you. Okay, hold on. It should be back to normal now. Give it 1 second. Towel has had some buffering issues today because, unfortunately, from time to time, I have been trying to upload far too many files at once. But I did make a promise, which was I would only experiment with trying to upload large files during the breaks. So the only thing you would miss is Towel ranting. Now, if you missed what I was just saying, I was saying how much I appreciate Murder by Maestro coming into the chat, and then I was apologizing for the fact that I, as a Towel, inadvertently caused the stream to buffer by trying to upload a large file, which is a very Towel thing to do if you think about it. Oh, lunch is only a half hour? That's even better. I don't have to talk for a whole hour. I love talking to you all, Towel friends. But I was thinking it would be really nice if I could eat lunch. Listen, I'm not going to lie. When I went out to get lunch, all that ended up happening was I got a bag of Cheez-Its. I got distracted. My friend called and he was telling me about how he had heard my family member was sick, and then I was saying, oh, do you want to come up and see my family member? And then we coordinated a visit, and I was like, it just became this whole production because it turns out, speaking very broadly, he works for the government. And I was like, oh my dear God. And then I was like, okay, we should talk. We have to see each other. So then I didn't pay attention to my actual task during the past hour, which was going to get lunch while I had stepped away, and all I ended up doing was getting a bag of Cheez-Its and then this Gatorade drink. I didn't even get my 7-Eleven pizza. I feel like a very unproductive Towel. But that said, that moment from Hank Brennan was absolutely brilliant. And I was thinking all day about how excited I was to see Murder by Maestro, and I'm very apologetic for my various experiences or experiments with the uploading large files. Murder by Maestro, you missed it earlier. We found out that Towel cannot simultaneously stream to YouTube X and upload large files that are recaps of the trial simultaneously. And I think that might actually be for the best, because I should be paying attention to what's happening, which I am, and I'm taking notes, and I'm going to do these clips later. One thing that's absolutely getting clipped is Alan Jackson talking about cancer in the way that he did. That was absolutely disturbing. Alan Jackson weaponized cancer during his opening arguments. Oh, wait a minute. I'm a towel. I have an idea. I have a brilliant towel idea. I can make a short clip of Alan Jackson saying that, and we together can do it in real time. Are you ready for this? Okay, watch me be it. Oh, that's quite an image right there. I actually really like that host of Law and Crime. He, Jesse Weber, he does a really good job. Oh, is that the, that's the analyst from Twitter who goes on WBZ sometimes. She's wonderful. Note my objection. I fully support her being on Law and Crime stream. I wish I could wave to her, but she's wonderful. She's an excellent analyst. I love Law and Crime. They do excellent work with Anjanette Levy. I like Court TV, Julie Grant. I think some of those hosts are wonderful too. But truly, now that Law and Crime is bringing on Note My Objection too, Christina Rex is a fan of Note My Objection. Towel's a fan of Note My Objection. This is just one big happy towel family. I'm sorry that this is such a sad case to talk about this in, but I'm thrilled that the right people, in my opinion, are getting their voices heard. All right, now we have to go back to the cancer situation with Alan Jackson, because I was seriously offended by this on a towel level that I'm not really even sure I can put into words. So what I need to do here is I need to, with you all in real time, I'm going to... Oh, you can't show transcript. All right, so what I have to do is I need to... Oh, I found it! Oh, wow. How did that happen? Wait a minute, you all just saw that live. Do you see what we just clicked to? Look at the caption on the screen. That's the moment. I didn't even mean to do that. Okay, I'm starting to believe... I don't know what's going on with this little towel. They're just weird. That's just weird. Well, you all saw that happen live. I literally was like, let's go find the comment where Alan Jackson talks about cancer in a very inappropriate way during his opening. I clicked right to it. Folks. Towel is a very religious person. Towel believes that was an act of God. Whether you believe it or not, doesn't matter. Towel believes it was an act of God. All right, so hold on. I got to do one thing. Give me 1 second. All right, so we're going to watch this together, and you're going to see how I make my clips.
Through the prosecution from the very start, from the jump.
Hold on.
Have answers. You'll see from the evidence in this case that this case carries a malignancy. One that is spread through the investigation. It's spread through the prosecution from the very start, from the jump. A cancer that cannot conduct. During the course of this trial, you'll find that the Commonwealth will not have answers. You'll see from the evidence in this case that this case carries a malignancy. You'll find that the Commonwealth will not have answers. You'll see from the evidence in this case that this case carries a malignancy. One that is spread through the investigation. It's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. And his name is Michael Proctor. Now, you didn't hear his name in the prosecution's opening statement.
That's sick. That's sick. That's sickening. That's disturbing. That's one of, now that I re-listened to it again, I was doing a lot of things earlier. That's disgusting. That's abhorrent. That is one of the most ridiculous, offensive statements I have ever fucking heard in an opening statement. Do you understand what that reference is, folks? That is a reference that John Dean used during Watergate, okay? He said that a malignant cancer was growing on the presidency in the form of Haldeman and Ehrlichman's little plumbers operation because of the breaking into Dr. Fielding's office and then eventually sabotaging the Daniel Ellsberg's prosecution, which was actually a good thing because Ellsberg should never have been prosecuted in that case, in my opinion, because of what the plumbers did to Dr. Fielding. But then also the June 72 break-in to the Democratic National Committee. That was John Dean saying to Nixon, this rogue group of former CIA operatives that helped in the Bay of Pigs. By the way, look into some of those CIA operatives that did the Watergate break-in. Howard Hunt, G. Gordon Liddy. Holy shit, those guys were high-level CIA operatives right through the 50s and 60s. I think Hunt resigned in like 68. They were handling very high-level informants who were like operating to break up communist rings in the United States. Just some crazy stuff. But Jackson there, Alan Jackson needs to understand that it is 2025, and outside of Little Towel, most people do not sit around watching documentaries about fucking Watergate and understand what Alan Jackson is saying there. Most people are going to fucking hear that and be like, why is Alan Jackson comparing people to cancer? My relative has cancer. I'm actually being very serious. My whole life have taken cancer very seriously. Now I'm fucking infuriated about it. I'm just like, what the fuck, Alan Jackson? Why are you doing that? Who the fuck does that? It's outrageous. Absolutely outrageous. All right, let me, we jumped backwards a little bit because I just wanted to yell things about Alan Jackson. But let me, we're not actually going to watch the interview on Law and Crime because I don't want to, if she wants to do an interview with me, I'll invite her on, but she's not doing an interview with me, so I'm not going to play her interview because that's their interview and you know where you can watch that. Okay, so, but what I do want to do, folks, is I want to show you further an image today that just broke my heart. And this is the image of Peggy O'Keefe, John O'Keefe's mom, as Hank Brennan was describing the life of service lived by her son. It was a touching moment. It was a heartfelt moment. It was a moment that brought Little Towel to tears. And I don't think there's a single person in the world who could look at Miss Peggy O'Keefe in that moment, look in that person's eyes, and feel anything but compassion. Murder by Maestro says, Granny, you're talking about a man who has ruined the lives of innocent victims for the last 20 years, including having them arrested. Yes, I'm talking about Alan Jackson doing something that, whether or not you want to offer a robust and vigorous defense, is so offensive to Little Towel, so offensive that I am literally screaming with incredulity. And sometimes Towel yells about things because he feels very strong moral conviction about a given topic. But this is just on a universal, fundamental level. Like, how many people are affected by cancer? A very horrific, fucking horrifying disease, okay? How many people are affected by it? And unless the audience that you're speaking to is going to understand you're making a reference to John Dean and Watergate, which 99.98% of modern people are not going to get, you come off like a fucking asshole. And that's how that man came across in that opening statement now that I rewatch it again. Not Hank Brennan, of course. Alan Jackson. Hank Brennan didn't bring up cancer. But how dare Alan Jackson invoke that disease? Not even making Towel upset, right? Because that's just a personal thing. But how dare he, on the sense of it sabotages his client's fucking opening statement because you're going to alienate the jury who has now heard you invoke cancer 3 times to insult someone. Maybe their family members have cancer. Maybe they recovered from cancer. Maybe they had cancer. How do you know? How can you feel so confident? That is just a horrific misstep, coupled with telling the jury a blatant lie about when Karen said she saw John, quote, mortally wounded, a lie that Karen is going to contradict. Alan Jackson not only did not endear himself to that jury, he literally exposed himself as someone who doesn't like people with cancer and as a liar. That's how he came across. And when you say to me, well, Grant, if he really was going for the Watergate thing, how can you be so harsh on his motives? It's because I'm analyzing this from the perspective of the efficacy of the implementation of his strategy. If he was trying to be effective with the Watergate analogy, he has to fucking say Watergate in that context. Otherwise, it comes across like he's fucking belittling cancer patients. And that's why I'm incredulous. No, and that's what I'm saying. Murder by Maestro, you are absolutely spot on. And Eva says, yes, you can see it in Peggy's face And yes, Jew drops. He can talk. Alan Jackson can talk about the first trial because those were all testimony under oath. So anything you testified to under oath can come up at subsequent proceedings. Alan Jackson has had the victims of SA and torture arrested. His opposing counsel disbarred and arrested to defend clients he knew were guilty. Facts, says Berto Maestro. Well, that is certainly your insight, sir. Murder by Maestro says Alan Jackson is a type of evil and is even growing the horns. Mo says, stupid Jackson needs to understand that there was a blizzard going on in the dark, so it's not going to be easy for the paramedic to remember everything. Jackson being dumb. The wind was crazy. Yeah, I agree with you. Dewdrop says, disgusting, repulsive. My mother passed with cancer. Oh, God bless the spirit and memory of your mother, Dewdrops. I'm so sorry to hear that happen. Alan Jackson's just disgusting. Deafwater, he maligned too many people in his opening. Is the bad guy Proctor, Albert, Higgins, the dog, Chewbacca, the Marshmallow Man? We're renaming this the Marshmallow Man defense because Jackson was like, wasn't it like, wouldn't you describe a puffy coat as a guy in a marshmallow, like the Marshmallow Man? So Alan Jackson decided Chewbacca wasn't the way to go. He instead went with fucking the Marshmallow Man. Alan the Marshmallow Man Jackson. Let's make it happen. Hold on here. Hold on. Start a poll. Oh, wait, I got to end the... Oh, no! That was such a wonderful message you left, Courtney Myers. I was so pleased to include that message. I'm sorry I left it pinned for like 6 hours, but don't redact it. That was wonderful. You said that I was Nostradamus, and I'm the kind of towel who will laugh about that kind of thing for months. Let's see. Hold on. There was something I wanted to pin, though. Hold on. No, it wasn't a pin. It was a poll, actually. I forget the person who made the comment that was pinned, but they're going to be like, Grant, you left me pinned in front of thousands of people for hours. Of course, I took my comment down. I'm sorry. I don't think about the scope of my own platform sometimes. All right, hold on. I got to start a new poll here. Should Alan Jackson's new nickname... This is a good one. New nickname B. Alan the Marshmallow Man Jackson. Alan the Marshmallow Man. Oh, goodness. And I just can't believe he went there during opening. I have to calm down after hearing that shit. Like, cancer? Are you fucking kidding me? Out of everything... Marshmallow, is that how you spell marshmallow? I had no idea. I would have got that completely wrong. I would have got that completely wrong. I thought it was more like mellow. I thought they were mellow. Marshmallow? Is that actually how you spell marshmallow? I'm now not inclined to believe that's how you spell marshmallow. Oh my God, that's how you spell it. I thought for my entire life. This is like when I figured out that afternoon literally meant afternoon. That was a very big moment in my life. I remember where I was walking on the street. I was absolutely mind blown that when you say to someone, oh, I'll see you in the afternoon, it can literally mean afternoon. Anyway, my name's GrantSmithEllis, and we're in recess of the Karen Reed trial, and I know this is the absolutely erudite legal commentary that you come to this channel for. One, Grant figuring out that marshmallow is not spelled like mellow, and therefore has nothing to do with being mellow, which absolutely blow my mind. Yes, Murder by Maestro, I'm glad that you also had this similar issue to me. I feel so bad for leaving that person's comment pinned for like 5 hours. You can just send me a message in the future. I just did not notice it. All right, so when we come back, we're going to continue with Anthony Flamatti's cross-examination, and then we're going to continue. Someone mentioned earlier that Hank Brennan will be able to rehabilitate Mr. Flamatti, and that is firefighter Flamatti. That is absolutely correct. On redirect, Mr. Brennan has the opportunity to rehabilitate credibility, to rehabilitate or to deal with any issues brought up on cross. So we will see more. Oh, you're so kind, Deafwater. God bless you for letting people know how to donate. That I didn't even do a donation read. We are 6 hours in. I feel like we've been going for 5 minutes, towel friends. I had no idea. And I do want to apologize as well for being a little bit all over the place on our first stream today. I had to take some time to learn just about how I was gonna present this trial to you all. There was actually a buffer in the pool feed earlier that absolutely infuriated Towel. It wasn't actually on my end; it was from the pool camera. So I'm going to send my tech team. People are volunteering to help, so I'm going to send my tech team, and they're going to go to the courthouse, and we're going to get a drop set up, and I'm going to actually have the raw feed, and I'm going to use a dedicated uplink so that from the courthouse to Little Towel is a firm stream, because the pool feed, it's good, but we can't rely on these uplinks potentially dropping. I do have direct access. By the way, if you're watching this stream, you're getting access to something that no one else has, which is a direct view of Karen Reed, authorized. Towel is authorized to broadcast it. All 6 weeks of the trial, Towel will have for you a direct view of Karen Reed during every single piece of testimony, every single section of the trial. I will have a direct view for you of Karen Reed. You can see it up in the corner there. We have that on this stream the entire time. It is court authorized. Well, it's authorized by way of Towel's standing and his media credentials. It is very unique for Towel to have this because other streamers are not credentialed. So if you see folks doing unauthorized broadcasts of the Zoom, first of all, they should not have that information. And second of all, please let Towel know. Not because I want to keep it to myself, but because there's a reason you have to be credentialed to use it. And I'm not going to get into the details, but if you have to be credentialed to use it and you're using it without credentials, that's not appropriate. Get credentialed if you want to use it. The other thing that I want to talk a little bit about is I'm going to try to join one more time. I'm going to get us about a 1-minute notice before we come back in from lunch recess. All right, folks? I'm going to use the special Towel, the Towel-approved stream to get into the thing. All right, good. Okay, so I have the Zoom up. As soon as the Zoom goes open again, that'll be our signal that lunch is just about ending. I expect lunch to be ending sometime in the next 5 to 10 minutes. But originally, I thought it was going to be a traditional 1-hour lunch until 2 o'clock. I'm hearing that might not be the case today. Now, also remember, folks, it is not just testimony today. We have to stick around because 2 big motions related to ARCA and related to there was one more. There was the compliance issue related to ARCA, and then one more like potential. They're going to drop a potential stay of the trial, but that's not happening. It already started. So really, the ARCA issue. Remember, Reed was banned from mentioning ARCA in her opening statements just 30 seconds before, 10 minutes before the trial started. And as a result of being banned from mentioning ARCA, what I'm thinking is Judge Canon later in the hearing is going to say she's inclined to ban ARCA from testifying because Reed failed to comply with reciprocal discovery. Hi, Drew Drops. Yes, I'm glad you're okay, but it was great. Text, be in chance. Which text? You gotta elaborate a little bit. Murder by Maestro said, "Damn, Grant, you got to make that screen bigger." Oh, the special Zoom. Don't worry, Murder by Maestro. I'll find a way. Here's the thing. The most important part of the testimony is the witness's body language and demeanor, facial expressions, etc. So I have to position the unique Towel court-approved camera stream that we can look at Karen 24 or throughout the whole trial, dedicated camera. I have to position that so it doesn't overlap with the witness's face. So I need to think a little bit about how I want to do it. I can sacrifice Elizabeth Little and David Yannetti to get better focus and a bigger picture of Karen, but I don't think we could call it the Karen cam. Why am I such a funny towel? I'm such an endearingly funny towel. Hello, all towels. Hello, HB. Very good to see you. We're looking for, I forget what the person's name is. They're such a kind towel. I'm checking back in the stream. Whoever made that wonderful comment earlier that I left pinned for 5 hours, I have to give them a special personal apology. They called me Nostradamus. I thought it was endearing and then left it up for 5 hours. And now being a towel, I feel embarrassed because they were like, that's a little much. Mo says, Yannetti looked like he lost a step. Last trial, he would be moving around on his seat and looking around. Now he's like, oh no, why did I do this? Good comment, Mo. Be in chance. She made a ruling about hundreds of texts Jackson didn't provide. Yes, actually, you know what? Thank you so much, Be in chance. Let's take a look at what Judge Canon ruled about that together, because that does impact what we're going to hear related to the ARCA motion. So here we go. Let's listen. Towel is an archiver.
Commonwealth's motion regarding defense opening statement. I think the first two motions we can do quickly. I'm not issuing an order. Mr. Brennan, the defense knows third-party culprit will not be in the opening. If you think that their opening goes beyond it, you can object. Defendant's opposition to the Commonwealth's request for use of independent readers, because there's an objection, the defendant's motion's allowed. So you will not have an independent reader. Is it fair to say that the third and fourth motions, Commonwealth motion to enforce compliance with court's April 16th ACCA discovery order and the Commonwealth's motion to preclude new expert testimony or alternatively to continue the trial date, that those motions will take a little bit of time, Mr. Brennan?
I don't think I'll be long in my argument.
I think that I need more information on one of them, and I think we'll do that at the end of the trial. I mean, at the end of today, we'll hear both these motions. Mr. Jackson, I did see that a list of text messages, 100 or so, is in your response to my order on Friday. Did you provide the text messages themselves?
No.
All right. In light of that and the fact that we don't have time, this juror's been waiting for some as many as 3 weeks now, I'm going to prohibit you from mentioning ACCA in your opening statement. And then we'll deal with this later today. I ordered those text messages and they weren't delivered. So we're going to be bringing the jury in. I'll be in recess for 5 minutes.
Heard on that, I think the court respectfully may be factually incorrect on a key assumption of what Your Honor is ruling.
5 minutes, Mr. Alessi.
Mr. Jackson couldn't give the facts. I would like to hear the law.
That's more than 5 minutes. I'll see you at sidebar. Come up here.
All right, folks. So you just heard the bombshell ARCA revelation. Bombshell ARCA revelation that although the defense turned over a list of 100 text messages, they didn't actually turn over the content. Also, I know I didn't do the donation read, but someone sent a very kind donation. I don't read the name out unless they take ownership in the comments, but I just want to say God bless you. And just so many towel friends have made me feel supported today. And just know that it's not, this stream isn't about donations or anything like that. Towel is happy to just get by, and I want you to focus on acts of service for others. But one thing that really brightens my day is that you all have sort of developed camaraderie here. You all sort of support each other, and that really, I think it's combining the fact that you all want Towel not to starve and wither away and feel supported with the support you have for each other that just, it's very humbling and touching to me, and it reminds me of the importance of this platform. And then also I want to say that if you are just finding this channel, I'll be doing live streams of the Karen Reed and John O'Keefe case every single day for the entirety of the trial, along with commentary during the breaks. There will never be a down or dull moment on this channel, I assure you. Towel thoroughly enjoys engaging with all his Towel's friends. Saw Francis Frutrell pop up earlier, always a name I love to see in the chat. Francis Frutrell donated 200 tomato plants the other day, and I think that is the very embodiment of the acts of service and compassion and love that I was talking about. And then also I want to mention, if you're new to this channel, apparently subscribing to the channel and clicking like on the video is exceptionally helpful for Little Towel. I think we're coming up on a milestone, which is 500 subscribers, and it's I am very excited. I just keep, like, it's kind of a weird thing, but I want to make a post being like, oh, we got to 500 subscribers on the YouTube. So if you want to help Towel on what we'll call the drive to 500 subscribers, that would make me feel very happy. And you can also like the video. Welcome Andrea Lynn as a new subscriber. I can't actually make it pop up on the screen yet. We're going to get there one day, but I do get a little notification in the corner of my screen, and that makes me a little happy, Towel. Kat, very good to see you. It's great to have you with us watching. We're just waiting for the lunch recess to end in the first day of the Karen Reed and John O'Keefe trial. Karen Reed and her lawyers were completely thrown off by being banned from using ARCA during opening statements in a clip we just watched. Alana says that they love this channel. I'm so grateful that you find the content helpful. Much like Lord Reith of the BBC over in Britain, my aims here are to educate, inform, and entertain you in that order, ideally. So if I have done any of those things, but in particular if I've educated and informed you with a little bit of entertainment thrown in there for good measure, then I'm living up to my vocation on the earth as a towel and absorbing information and therein relaying it to you all, hopefully in a digestible and understandable format to engender the cogency of public discourse as a bulwark against the usurpation of democratic republics by nefarious forces or well-funded defense, PR, innocent fraud campaigns, or otherwise. So if you have taken spirit or taken inspiration from that mission, if you found this information helpful, then truly I found my eudaimonia on the earth, or my summum bonum, as they may say in Latin, and I have lived up to my greatest good, asymptotic though that relationship may be with human perfectibility and truth. I am doing my best and I feel fulfilled, and that makes Towel happy. Yes, there's so many Towel friends. Sometimes I try to read the comments and they go so fast. Eva says, Deaf Otter, lots of love here. It's the love channel. Yes, I think another element of this channel, if you're just joining in and wondering why you've come across a guy who thinks he's an anthropomorphic towel that also has this giant blue wall of support and for justice for John O'Keefe, it's because I think fundamentally I believe that in a realpolitik analysis, a realpolitik, or pure realist political analysis, people tend to look at how they can expand, demonstrate, and preserve their power. But I want to bring about a new ethos where we focus on a soft power world order centered on expanding, preserving, and demonstrating unconditional love for one another. And I think that the best way we can do that is not through 6 degrees of Chewbacca, but through 6 degrees of authentic inspiration, where little acts of kindness exponentially impact more and more people, and then eventually the world order will come to reflexively embody that ethos through a Hegelian syntactical sort of thesis versus antithesis forming into a new synthesis, and therefore we can salvage the world order from a current epoch defined by self-interest and greed, and somehow uplift this human species once again into a more sort of refined alignment with the spirit of camaraderie and compassion, which I think underlies all of human existence, and the goodness which is latent and in some cases very overt in all human beings. So that's Towel's theory about how we should engender love among the world. I'm not really sure what that was. Oh, yes, someone made a comment about how this channel is rooted in a respect for such love. And then I went on one of my infamous Towel soliloquies because I was expressing thanks for that, which is bound to happen from time to time. Okay, do we have more questions about opening? Anthony Flamati, firefighter Flamati's testimony is going to continue, of course, after lunch. Now, folks thought it might have been a 30-minute lunch. I'm going to go ahead and say it was not, and we are aiming for closer to 2 o'clock. If we return earlier than 2 o'clock, that's fine. But Little Towel being as he is, I am happy to talk to you all for the duration of the hour. Apparently, and what I will try to do, by the way, feel free to recommend. Who would you like me to talk to? I've been getting lots of requests. People want to come on and share their thoughts with you all. Who do you want me to talk to? I feel like we can have a different person on every day. We could ask someone if they want to come on more often. But if you all have suggestions, I know some of you wanted me to talk to my mom. I'm happy to do that, but my mom is a little bit focused right now on her lawsuit against the government to prove that either women should be in the draft with men or that there should be no draft. I'm not really sure exactly what her argument is, but she has this big thing she's focusing on. So unless you want to hear a 30-minute soliloquy from her about why women should be in the draft, I'm not sure that's what I want to discuss during the trial, but, you know, maybe we can talk a little bit about it. It's very interesting. But other guests, if you want me to talk with people during these breaks, let's think a little bit about it. I'm happy to bring on, what I'd really like to do is bring on voices you think are erudite and cogent, but unheard. I think the theme of a lot of my work is trying to sort of uplift the voices of people who might be downtrodden or feel silenced. So if you have ideas for people who you really, really like, that seem like they're constantly offering good content, but they're kind of brushed aside by the powers that be or whatever because, you know, they don't play the right game or know the right people. That's the kind of people I want to interview. So yes, I would love to hear. Dixie Doodle says, Grant, were you ever a drum major? I played drums. I played percussion in high school, and I think what you're seeing is I have to parse through my mental mind map to take out all these different documents. So when I close my eyes, it's a little bit hard to describe, but what I see in front of me is like this endless sort of panoramic digital screen. And then what I'm doing is there's all these different folders and substructures, and I can just kind of go into any nestled sort of substructure that I need. And then there's all these documents and video clips and songs and movies that I have stored in full, and they play at 100 speed or whatever. So I'm just kind of picking out parts of that mind map, or this kind of nested tree that I want to talk to you about. So I guess it's not really rhythmic intonation for my syntactical precision. It's really for the purposes of me refining which documents that I'm seeing or material that I'm looking at that I want to present to you. Now, it causes a bit of a problem for me because although it's great for rhetorical flourish and command of my speaking skills as I'm delivering this information, it's very distracting. And judges won't like it, juries won't like it. You all, I think, find it a bit of a novelty. I find it a very helpful tool for keeping track of what it is that I'm saying, but it's not the best tactic. I have good news. The Zoom has come back on, folks. I have good news. That doesn't mean that we're going into session, but what it does mean is that I can do this. Give me 1 second. Sometimes I go on those random soliloquies and I'm like, what do they even make of this? Are they just utterly baffled? Hey, look at that. Look at that. You all, before the entire world, are going to find out when we are back in session because I'm a towel. All right, let's see. I'm going to continue. Eva says, Grant, Hank wears owl cufflinks. Isn't there an owl symbolism with the Bohemian Grove? Owls can mean a lot of things. It can mean the owl of Minerva for wisdom. Yes, it can also mean that Hank Brennan is worships an owl and belongs to the Bohemian Grove. I don't think so. I would guess that that's more of like an owl of Minerva type thing, but we can look into it. Murder by Maestro says, there are a few low-key mass attorneys on X I'd love to hear Grant talk with. Send them my way, Murder by Maestro. Let's do it. Audio getting tested. We might be coming back into session, folks. Get ready. Def Otter says, or Karen stopped paying for crowds for hire, but unless they are seen, they don't bother. Says a lot. HP says, I don't care what he is called. I'm a very honest person. I love people in general all over the world. I just can't stand liars. Hear to that. Grant, sounds like the don't have the data returning to the scene prior to gathering McCabe and Roberts. Maui Swift, it's very interesting. Hank Brennan didn't mention a lot of stuff that we know is coming into evidence. He didn't mention anything about Karen's movements at all between 5:08 and 5:35 when we know from the first trial there's evidence of 5:11 a.m., Karen's car on camera near the temple. 5:18 a.m., Karen's car coming out the other side of Canton Center over by the Purple Line stop down there by Fairview Road. And then there's the 5:23 a.m. voicemail. John, is that you? Is Hank Brennan saving it? Is it going to be a surprise? Not a surprise, but it didn't need to be telegraphed in opening. Your Dewdrop says, Cat, love this chat. I agree, it's a wonderful chat. Let's see. Yes, Bohemian Grove statue was an owl symbol of Baal, but owls are ubiquitous, common symbol. Yeah, it is. It was definitely adopted by the Grove, but owls as a symbol of wisdom existed long before the Grove and have meaning independent of the Grove. So I think it's a huge leap. Even if Alan Jackson wore owl cufflinks, I'd be like, it's a huge leap to say that they're in the Bohemian Grove. But yes, the symbolism overlaps. The double peel of the courtroom is great, says Def Otter. All right, I'm thrilled to be able to keep offering it. He might just like Tootsie Roll Pops. I don't understand necessarily what that means. Dixie Doodle says owls were referenced in the Adelson trial too. Oh yeah, the Adelsons I could see being in that Bohemian Grove circle. I was looking more into this the other night. Some occult stuff is really, really intense. A lot of it hides in plain sight. Owls, let's see. Wise old owls have been a thing forever. That's true, Francis Fertrell, and it definitely was a thing before the Bohemian Grove came into existence in the late 1890s. And I would argue it was even a thing before the groups that inspired the Grove, such as Asiatic Brethren or Scalafafia, which were two sort of German esoteric branches of Freemasonry. Even that stuff, I would say, came way after owls as a symbol of wisdom. But yes, I'm pretty well schooled in the development of those various branches. Alan Jackson did get dangerously close to violating the court's order about opening on a third-party culprit. That's right, B and Chance. Daffwater says maybe Hank Brennan just likes Twin Peaks TV show with the owl. There you go. You can always find an owl somewhere. Kat says, thumbs up. Dewdrop says she feels sorry for Brian and Higgins. They are gentlemen. I agree. B and Chance says maybe it was a gift from a loved one. That's true. Eva, I thought the owl symbol may have different meanings. Oh, it does. There are lots of different meanings, but the wisdom meaning is definitely the one that's most profound in Towell's mind. I love all birds. Love to study them, says Francis Fertel. I agree. I think birds are very interesting. They're the only, I think other than lizards, they're probably the only thing left from the Paleolithic era, prior to the Younger Dryas event. Now, if we want to talk a little bit about the Younger Dryas event and whether or not it represents sort of a cyclical repetition of the rise and fall of humanity, I do think there's evidence in the historical record of human footprints going back 22,000 years somewhere in the southeast of the United States. However, I don't think we should go on to a digression about the Younger Dryas due to the fact that we were talking about birds. I think that's a bit too attenuated, although it is interesting. Jew drops, yes, you have a few minutes, the top of the hour, 2 o'clock, folks, just a few minutes now. We will be getting back to the testimony, and if you missed it, it was certainly a wild morning, whereupon Alan Jackson invoked cancer in a very disturbing way during his opening statements, in a way that made Towell very uncomfortable. And actually, what we are going to do right now is I'm going to post that video clip because I really found that remark from Alan Jackson very unpalatable. Not just unpalatable, I found it offensive. Offensive to my humanity as a towel, offensive to my sense of moral righteousness, just latently offensive to everything that I hold dear. And so as a result, I clipped the part of me ranting about it, but I'm just going to post this video. It's only 25 seconds, and I just want to make sure it's right. So hold on, you're going to hear it play in the background.
You'll see from the evidence in this case that this case carries a malignancy.
All right, so that's what we want. So now, why don't we together write a little post about this? Here was the most disturbing moment of opening statements during today's John O'Keefe, during day one of today's John O'Keefe and Karen Reed retrial. Reed's lawyer, Alan Jackson, invoked cancer as a way to attack the police officers who who collected the evidence of Reed drunkenly hitting John with her car. Jackson may have been trying to allude to John Dean's infamous Watergate quip to President Richard Nixon as to the plumbers unit putting Nixon's presidency at risk. But no modern audiences are going to understand that. Furthermore, the jury is most certainly going to be offended.
I was told counsel wanted to see me about scheduling.
All right, we're back.
Your Honor, my apologies. That's actually a moot point at this point, so that there's no...
Okay. All right, bring the jurors in, please.
All right, folks, we're going back to trial coverage. I'm a towel. We'll see you after the next break.
Yes, Dave. Yes. Yes, please.
Court of the session, please be seated.
All right, Mr. Jackson, you can go ahead.
May I, Your Honor?
Yes, please.
Thank you. Firefighter Nuttall, over the lunch hour, did you discuss anything that we had discussed this morning or earlier in the session with anybody about your testimony?
No, sir.
Okay. You did mention earlier today the EMTs that were with you that responded to the scene. You mentioned, I think you said Tony Anthony Flamati,
Yes,
correct?
Yes, sir.
You mentioned Kelly, and I want to say Matthew.
Matt Kelly.
Matt Kelly?
Yep.
Yourself?
Correct.
And of the three of you, two of the three of you were and are paramedics, our firefighter Flamati and yourself, correct?
Correct.
Do you know the name Katie McLaughlin?
I do.
Who is Katie McLaughlin?
She is a firefighter paramedic for the town of Canton.
Was she also on the call?
She was.
You didn't mention her this morning.
It did not come up. She responded on the initial dispatch on engine 3.
You were asked who responded with you, correct?
Yes, sir.
By Mr. Brennan.
Yes, sir.
And you mentioned yourself. You mentioned Tony Flamati. You mentioned Matt Kelly.
Yes, myself, firefighter Flamati, and firefighter Kelly responded in ambulance 1 together.
Okay. And how did firefighter McLaughlin respond?
So she was assigned to engine 3 that night. She was with Lieutenant Woodbury and firefighter paramedic Frank Walsh.
Is she also, in addition to Walsh being, it's Frank Walsh?
Yes, sir.
In addition to firefighter Walsh being a paramedic, Katie McLaughlin was also a paramedic?
Correct.
Okay. So she responded to the scene at the same time as you, generally, but in a different ambulance?
In a fire truck, in a piece of fire apparatus. She was in engine 3.
Got it, engine 3, okay. And she was with you, generally, when I say with you, at the scene during the entire time that you're describing the events that you described with Mr. Brennan on direct examination?
For the most part.
Okay. She then left in a particular ambulance, correct?
Yes, she ended up driving ambulance 1 to Good Samaritan.
And ambulance 1 was which ambulance?
Ambulance 1 was the initial ambulance that myself, firefighter Kelly, and firefighter Flamati responded in.
So right after the scene you described, as you're leaving the scene, firefighter McLaughlin is in the ambulance with you and firefighter Flamati, correct?
She is driving. So the three of us are in the back in the patient compartment. She is up front in the driver's seat.
Once at the hospital, did firefighter McLaughlin go into the hospital with the other firefighters?
I believe so, yes.
So she was with you in the engine, she was, although in the driving cab, she was with you, ambulance in the driving cab. She was also with you right after the scene at the hospital, correct?
Yes, sir.
And she was also with you later after you cleared the hospital and went back to the station.
Yes, sir.
You had discussions with firefighter Flamati about the incident. That would be normal protocol.
Correct.
Almost like a debrief.
Sure.
You had the same types of discussions with firefighter Kelly, Matt Kelly.
Yes, sir.
I'm guessing that you probably had the same sorts of discussions with firefighter Walsh.
I actually don't know if I saw firefighter Walsh when we got back. The weather was right at shift change, and the weather getting back was also getting worse, so I honestly couldn't speak to that.
And you also had conversations with firefighter McLaughlin after you cleared the hospital and got back to the station as well.
She was part of the debrief, yes, sir.
Okay. And all of you discussed what you did, saw, and heard, generally speaking, while at the scene, correct?
Those are more in terms of getting equipment wrangled, really kind of how they go. What did we use? What do we need? What are we going to have to restock when we get back?
Right. But there also was obviously discussions about what had just happened. I mean, you were dealing with a dead or dying police officer on a lawn, on a snow-covered lawn in a cold environment.
I honestly couldn't speak to that, sir. I honestly don't remember.
It's because you don't remember, correct?
Well, like I said, it's mostly, those debriefs are usually, they're very
equipment, make sure that the ambulance is ready for the next call, etc. I'm asking about a general debrief with the fellow firefighters, male and female, that you were with at that scene. You're telling me that you don't remember debriefing and discussing the incident and your observations at the incident following that incident?
No, sir.
Okay. But your memory, you indicated earlier, gets better with time, right?
Yes, sir.
You don't remember it as you sit here today?
Ask the question again?
Sure. Do you remember discussing with firefighter Flamati, firefighter Walsh, firefighter Kelly, firefighter McLaughlin, any of them, your observations and what happened while at the scene after you cleared the hospital and got back to the station?
No, sir.
Have no memory of that whatsoever?
No, sir.
When we left off before lunch, I was asking you about a hematoma and a laceration over the right eye of Mr. O'Keefe. Do you recall that?
Yes, sir.
I asked you, is being punched in the face, can that lead to a small laceration like you saw and a hematoma like you saw?
Objection.
I'm going to allow it. Can you answer that question?
I couldn't speak to how that injury occurred.
Is it consistent? Are those injuries, just those injuries, are those consistent with being punched in the face?
Those injuries could be sustained from numerous ways.
And
yes, it could be from that. It could be from others as well.
Okay, so that's what I'm asking you. It could be, in other words, it's consistent
Yes,
with
sir.
being punched in the face, correct?
Correct.
Thank you. I want to ask you about this statement that you indicate that you heard that now is 3 statements, 3 phrases, correct?
Yes, sir.
When you heard this statement, describe for me exactly where you were. What were you doing and who was around you?
I was knelt at the head of John O'Keefe with a bag valve mask, delivering ventilations. Firefighter Kelly was to the right, and firefighter Flamati was on the left side of Mr. O'Keefe, and the 3 of us together were working to perform CPR and ventilations.
And your job, and I hate to butcher it, but you'll correct me.
Yes, sir.
Your job was to do the airway, correct?
Yes, sir.
And I'm picturing a big balloon-like apparatus that you put over the patient's mouth. And
Exactly.
squeeze it.
Yes.
That's as opposed to, it's an advancement on just mouth-to-mouth resuscitation, correct?
Correct, yeah.
You were the airway person doing the squeezing of the bag.
Correct.
What was Tony Flamati, firefighter Flamati, doing?
He was starting CPR, in which that point was taken over by firefighter Kelly.
Okay, so firefighter Flamati, when you say starting CPR, Describe what that means. What is the physical act of CPR?
So you put both hands together like this, one on top of the other. You put it right on top of the sternum, and you begin doing chest compressions 2 inches deep, allowing full recoil for 100 to 120 beats per minute, compressions a minute to sustain a cardiac rhythm. You're manually making the heart beat with each compression.
Which means that is a rhythmic pumping motion, correct?
Yes, sir.
So if you see someone doing CPR, you're probably going to see their shoulders moving up and down and moving rhythmically, correct?
Correct.
Do you remember what firefighter Flamati was wearing? You had just come off of actually you were just coming onto a shift, so you didn't have all your foul weather gear officially, correct?
I had my puffy jacket. Okay. I had my Canton Fire jacket.
Got it. Firefighter Flamati, on the other hand, had a bright yellow jacket.
Correct.
Sort of reflective and a safety jacket.
Yes, sir.
And he was kneeling to your left at the time doing, have I got that right?
Yep, nope, yep, you got that right.
Okay, he's kneeling to your left at the time doing chest compressions. That's when you indicate that Miss Reed walked over and made the statement.
Correct.
And Kelly was there as well?
Yes, sir.
Kneeling right beside all three of you as Firefighter Flamati was giving the chest compressions, correct?
Yes, sir.
Okay. You indicated that the statement was in response to a question that you asked of my client, do you know him?
Yes, sir.
Is that right?
Correct.
And she responded to you with the phrase that you've used, I hit him.
I hit him, I hit him, I hit him.
Right. So it's absolutely clear in your mind when that statement was made. You were knelt down over Mr. O'Keefe. Firefighter Flamati was doing the CPR, and Kelly was with the both of you when you posed that question.
Yes, sir.
It's a very detailed memory.
Yes, sir.
You indicated, Mr. Brennan, that sticks out in your mind. Is that right?
It does.
But that's not at all what you told Trooper Proctor on February 8th, just 10 days after this incident, is it?
I don't recall what I told Trooper Proctor.
I thought your memory got better with time.
I don't recall that meeting.
Okay.
I recall meeting with him, but I don't recall the extent of what was discussed.
You literally don't in that meeting in that formal interview with the lead detective on this case.
We discussed the case, but I don't, in his words, I'm not sure what he put down.
What you said to Trooper Proctor on February 8th, 10 days after this, was you overheard Miss Reed say, I hit him one time to another female that she was talking to. Correct?
Objection.
No, I'll allow it. Did you say that?
I have no memory of this, Your Honor.
Okay, next question.
Did you say that her statement was an answer to a question posed by the female or a discussion with the female?
Break that down for me, sir.
Sure. Did you tell Trooper Proctor on February 8th that what you heard was Karen Reed speaking to a female, not answering a question that you posed?
Again, I don't recall that specific question.
Did you tell Trooper Proctor on February 8th while you were rendering aid, and at the time you heard the statement, Miss Reed was actually praying over John? Your words, praying over John.
I don't recall ever saying that.
May I have just a moment, Your Honor?
Yes.
Did you say that you observed Karen Reed to have blood on her face from providing mouth-to-mouth breaths to Mr. O'Keefe prior to your arrival?
I remember Miss Reed having blood on her face, presumably from attempting CPR.
Do you remember telling Trooper Proctor on February 8th that you saw her with blood on her face from CPR?
I do.
So you remember that portion of your conversation with Trooper Proctor, correct?
Yes, sir.
But the praying over John, praying over the victim, you don't remember.
I don't remember ever saying that. Ever.
And the statement, I hit him to another female, you also don't remember that.
No, sir.
Would it refresh your recollection if you were to look at a report
Yes, sir.
authored by Trooper Proctor? May I?
Yes.
May I direct the witness's attention to the second page, Your Honor?
All right, why don't you take a look at that, sir?
May I approach, Your Honor?
Yes.
Thank you. Sir, did you have an opportunity to glance at the report that you were just shown?
Yes, sir.
Does that refresh your recollection about your conversation with Trooper Proctor that he put in a report?
It does not, sir.
So as you sit here, you have no memory of what you just read in this report from Trooper Proctor, the lead investigator on the case?
I have no recollection of ever saying that anybody prayed over anybody ever in this case.
You did see it in his report, though.
Right.
Sustained.
You've admitted under oath that your memory of the events at that time, from that time frame, January, February 2022, is faulty, correct?
No, sir.
In your April 2024, it's April 30th, 2024 testimony from last year, you were asked whether or not your memory was a little faulty, and your answer was absolutely, correct?
Could I have a page and number,
Where is
please?
that, Mr. Jackson?
Volume 8, page 151, lines 14 through 16.
Can you read the lines again?
Lines 14 through 16. I'll just allow counsel to get that up.
If we could pose the entire question and give content to it, please.
Okay.
May I?
Yeah, so do you intend to show the whole question?
The whole question that I asked and his answer, yes.
All right, now I'll give you the opportunity on redirect, Mr. Brennan, if it's not. Go ahead.
Is it true that in answer to the question, quote, so it's fair to say your memory is a little bit faulty as it pertains to that time frame, your answer was absolutely. Correct?
From last year?
What you testified to last year about conversations that you had with Trooper Proctor around February 8th of 2022.
Yes, sir.
And you would agree, as you sit here, that your memory is still faulty about your conversation with him.
With
Correct?
Trooper Proctor? Yes,
Yeah.
sir.
So you're not saying you didn't say that the statement was made to a woman, correct?
Objection.
Are you saying that?
No, ma'am.
Okay, next question.
Thank you. And you're also not saying that you didn't say to Trooper Proctor that you saw Karen Reed praying over John O'Keefe.
Objection.
So I'd like you to ask that differently. Did you say that?
I have no recollection of saying that ever.
Okay. Next question.
My point is, if you have no recollection of it, you're not denying saying it.
Objection.
Are you denying saying it?
Yes.
Okay.
So you do have a recollection that you never said it. Do you understand the difference?
Oh, sir, I don't believe I've ever said praying. That's really not something that I would have said. I didn't see it that day. It didn't happen. I don't remember ever saying prayed.
You didn't
in regards to this case ever.
You didn't see it that day, and it never happened. That was your words just now, correct?
Break that down for me.
You didn't see it that day, and it never happened. That's what you're saying about the praying statement, correct?
Yes, sir.
And in that same exact statement, you also included the phrase, I hit him, correct?
No, sir.
In the statement that you made to Trooper Proctor?
The report that Trooper Proctor wrote?
Correct.
Again, I don't remember ever saying the words praying over him. I do distinctly remember I hit him, I hit him, I hit him.
Which doesn't appear in that report, does it?
Objection.
I'm going to sustain that, Mr. Jackson. You directed him only to page 2.
Understood, Your Honor. I'd like to show you a short portion of a video, the same video that you were asked to look at on direct examination. And Your Honor, I pray to the court, I can certainly mark it as a defense exhibit or for
So is
identification.
this going to be an exhibit by agreement?
It is.
Okay,
It is.
so we now that, Madam Court Reporter, thank you.
See the course on my.
Thank you, Your Honor. With the court's permission, may I play a portion of that video for the jurors, publish it?
Okay. Which portion, so people know?
I'm going to start it at about, I want to say 6:55. Mr. Wall could cue that up. Before you play it, can we have it on that screen as well, or is it only playing to this screen?
I don't know. When Ms. Gilman did it, it was both. Great.
There we go. All right. Before we play it, can I ask you a quick question about this?
Sure.
It appears that this is paused. Do you recognize this as being the same video that you were shown this morning by Mr. Brennan?
I do.
All right. Describe the scene.
So, that is 34 Fairview Road. The lights in the background, I believe it is either right as we pulled up or right as we're pulling up.
Okay. Same dash cam video.
Yes, sir.
Can we scroll this to the 6:55 runtime spot, please? Pause it. Okay. Do you see the individual on the left? Far left.
Yeah, the jacket?
Correct.
Yes, sir.
Who's that?
I believe that's Firefighter Flamati.
You previously indicated that firefighter Flamati was on his knees providing CPR at the same time you were knelt down providing the airway.
This isn't when it was
That's
stated.
not my question. Is that what you said?
Can you repeat the question, please?
Sure. You indicated earlier when you heard this statement by my client, you were very detailed. Firefighter Flamati was knelt down providing chest compressions at the same time you were knelt down providing airway support for Mr. O'Keefe, correct?
I had also said that at some point,
That's a
Firefighter
yes or no
Flamati
question.
had
Objection.
So I'm going to let the witness answer the question.
transferred CPR to Firefighter Kelly. Firefighter Kelly did take over compressions at one point.
Okay. That's not my question.
Okay.
My question is an easy one. Did you say that when Miss Reed walked over to you and you had this dialogue with her, she made that statement that Firefighter Flamati was on his knees providing chest compressions at the same time you were knelt down providing airway support?
Yes, sir.
Okay. Firefighter Flamati, your testimony, appears to be standing up right there, correct?
Yes, sir.
Let's play the video forward for just a second. Stop it. What did you see Firefighter Flamati do just now?
I believe he just knelt down.
Okay. So at this point, he's kneeling for the first time, correct?
Yes, sir.
And he's about to provide chest compressions as your memory serves, correct?
Yes, sir.
All right. Let's go ahead and play it forward. Pause. Did you see my client in that photo? I'm sorry, in that clip?
No, sir.
You didn't see her?
Oh, no, I did see her, yeah. I don't see her on right now.
Right. She just walked off frame, correct?
Yes, sir.
Let's go ahead and play it forward. Stop it. You see my client walk back into the frame?
Yes, sir.
At this point, you were watching firefighter Flamati. He appears to be now providing CPR, correct?
Yes, yes, sir.
Okay. And my client is nowhere near you, correct? At least for this clip.
No, sir.
Okay.
Correct.
And the clip that I just played before, the few seconds that I played before, nowhere near you, correct? Is that right?
Yes, sir.
Let's go ahead and play it forward. Pause it, please. What do you see happening on the screen from screen right to screen left at this juncture?
We're bringing in the stretcher.
Okay, go ahead and play it. Pause it. Do you see where my client is right now?
Can you back it up 2 seconds? I'm sorry, I lost view.
With the court's permission, I need to ask the court's permission. Thank you. Okay, let's go ahead and play it. Pause. Did you see my client?
Yes, sir.
Where is she in the frame?
Behind that other individual.
Behind the SUV?
I believe she's in front of the SUV and behind the other individual.
Okay. I'm at the SUV, that's the white SUV that's in
Yes, sir.
the far distance.
Yes.
That's the back of the SUV. She's behind it, right?
Correct, yes.
Okay. Not near you.
No.
Okay. Let's go ahead and play it. Go ahead and pause it. Do you see what firefighter Flamati is? Entire clip.
Chest compressions?
Okay, let's go ahead and play it. Pause. What's happening now?
Where Mr. O'Keefe's on the scoop stretcher and he's being transferred to the ambulance stretcher.
So that's the entire time Mr. Flamati, firefighter Flamati, was giving chest compressions. It's captured right here on this video, correct?
Yes, sir.
Okay. And now Mr. O'Keefe is up on the stretcher, and you are no longer knelt down?
No, sir.
And firefighter Flamati is no longer knelt down?
No, sir.
And you're now following the stretcher with, it looks like, 2 or 3 other EMTs, correct?
I am not in that frame, sir.
Okay, so you've walked away.
Yes, sir.
All right. Let's go ahead and play it forward. Pause it. You see where my client is?
Yes, sir.
Go ahead and play it. Do you see firefighter Flamati or firefighter Kelly continuing to give chest compressions?
Yes, sir.
Which one is that? Do you know?
I believe it's firefighter Flamati.
Flamati?
Believe so.
Okay, so he's still doing all the chest compressions from start to finish?
Yes, sir.
Okay. And what's happening right now?
Now we are transferring to ambulance 1.
And where's my client?
Right front and center.
May I have just a moment, Your Honor?
Yes.
We can move on. If I may have just a second. With regard, just a couple of more questions with the court's permission.
Okay.
I'm going to change gears with regard to what you talked about On direct examination, the hypothermic conditions, you're not a medical doctor, correct?
No, sir.
You don't diagnose patients?
Sir.
You're not diagnosing that John O'Keefe suffered from hypothermia that night?
No, sir.
Thank you. That's all I have.
Can you follow up?
Please. Firefighter Nuttall, the video the defense just showed you, did you notice any differences between that video and when I showed it to you, and that it doesn't have the time on it?
Yes, those were two different time frames on that video.
And when we spoke about when the defendant said to you, I hit him, that wasn't shown to you in that video just now, was it?
No, it was not.
So if we go back, will you be able to explain where you came from and firefighter Flamati came from and when you first went over to John O'Keefe?
Sure.
With the court's permission, Ms. Gilman, if you could start that video. I think it is 6:11, please. Now stop it there. Do you see that this exhibit has timestamp on the top?
Yes, sir.
Okay. Please continue. Could you stop, please? Do you see the red lights on the left?
Yes, sir.
Is that when you believe that you first arrived?
Yes, sir.
And that note says 6:11:05. Could you continue, please, Ms. Gilman? Please watch to the left. Stop, please. Is that when you first arrived and walk over to help John O'Keefe?
Yes, sir, that's me.
I'll note that the timestamp is 6:11:21. Okay, continue, please. Stop, please. Did you see firefighter Flamati come after you?
Yes, sir.
Was any of this shown to you during those questions?
No, sir.
No. Continue, please. Stop, please. Okay. Do you see the defendant in that screen?
Yes, sir.
Do you see her moving from right to left towards you?
Sustained is to the form.
Okay. What direction do you see her running in that screen from right to left?
She's running towards where the three of us are grouped.
Okay. Please continue. Stop, please. Is it at that time the defendant said to you that she hit him?
Yes, sir.
And you remember that?
I do.
Okay. I'm done with the tape. Thank you very much. Now, you were asked questions about your memory?
Yes, sir.
Okay. When you were asked the questions about Trooper Proctor, when you were saying that you didn't remember, were you referring to the conversation with Trooper Proctor, or were you suggesting you didn't remember what happened that morning?
I don't remember the interview with Trooper Proctor. I remember it happened. I don't remember the substance of what was discussed entirely. I remember we discussed that morning, but...
Do you know if that conversation was recorded or just a conversation between you and the trooper?
I do not know if it was recorded.
You asked questions. I want to ask you about questions on Mr. O'Keefe, and you mentioned that there was some type of blood clotting on the back of his head?
Yes, sir.
Okay. You noticed there were abrasions on his right arm?
Yes, sir.
You noticed there was a hematoma on the right side of his head?
Yes, sir.
Did you see any bruising on his right knee?
Don't recall, sir.
Did it stand out to you that all of his injuries, all of them that you saw other than the cut on the back of the head, that they were all on his right side?
Yes, sir.
Did you notice any hematomas on his left side?
I did not.
Did you notice any scratches or abrasions on his left side?
I did not.
Did you notice any marks that would be consistent with an altercation on the left side of his body?
I did not.
You were asked about the cause, and you said that you don't know the cause. You weren't there, were you?
No, sir.
You asked if it was consistent with being punched, and you said it could be.
Yes, sir.
Could it be consistent with being clipped by a car?
Objection.
Sustained as to the form.
You were asked questions about clothing.
Yes, sir.
And you had at one point said you thought that Mr. O'Keefe was wearing a winter jacket. Do you have any memory that when you first got there, or when you first got there, do you have any memory whether there were any towels wrapped around Mr. O'Keefe's head?
I remember there was a white cloth of some sort on the scene.
Okay. And when you were asked about your memory regarding the clothing, was the clothing of what was utmost importance to you at that time?
No, sir.
And why is that?
I was, again, focused on Mr. O'Keefe's airway and ventilation.
Okay. And when you were asked about uncertainty about clothing when you previously gave a statement or testimony?
I believe when I testified last year, I did note I had no part in removing any articles of clothing or anything like that. That was not my job in the back of the truck.
Do you remember any recognition of the fact whether you were certain or not about clothing?
Repeat the question, sir. I'm sorry.
Well, is there anything that would refresh your memory about what you had said about clothing?
Objection.
Ask a different question first.
You had mentioned that you had some difficulty about clothing. Do you remember what you had previously said?
I remember there was some difficulty of getting the individual's fingers through clothing just because they were so cold. They were difficult to manipulate. Just they really was not conducive to getting clothing off easily.
Okay. You met with me 3 times?
Yes, sir.
I had not met you before any of your prior testimonies, had I?
No, sir.
Do you remember meeting with me and discussing this case with me?
I do.
Do you remember me asking you to tell me what you remember?
I do.
Do you remember what I told you about testimony when you come into court?
Yes, sir.
What would I tell you?
I remember we discussed that just tell the truth.
Did I tell you that it doesn't matter, there is no side, doesn't matter if it helps or hurts, that you just tell the truth?
Sustained.
Did I ever suggest to you that you should stick to a story?
No, sir.
Did I ever suggest to you you should offer your testimony in any certain way?
No, sir.
When I talked to you, did I ever ask you to say anything about your testimony to this jury?
No, sir.
Other than what?
Speak to the jury.
Did I need to tell you to tell the truth?
No, sir.
And in telling the truth, did the defendant say to you, I hit him, I hit him?
Objection.
I'll allow it.
Yes, sir. 3 times.
And in fact, do you remember, in addition to her saying, I hit him, I hit him, I hit him, when you asked her the question, kneeling down over John O'Keefe's body, do you remember if you ever talked about other times that she said it, not to you?
I do not.
Okay.
The answer is I do not. Next question.
Okay. Do you remember testifying previously in this case?
Yes, sir.
Okay. Do you remember at all discussing whether or not after she left you, whether or not the defendant was still talking and speaking?
I'm sorry, sir. Repeat the question.
Do you remember after the defendant left you and made that statement to you, do you remember did you hear her speak to other people after you?
I heard her having conversations in the background, but that was not my focus at that time.
Okay. And during those conversations in the background, did you hear her talk about that same issue again?
I believe she said it several times, but the 3 times she said it to me were what stuck out to me.
Okay. And when she said it to other people, it wasn't directly to you?
No, sir.
So watch the form of the question, Mr. Brennan.
And when she said it
stating the objection.
When she said it to other people, do you know who she said it to?
I do not.
I'll allow it. So the answer is I do not.
I'm sorry. Do you remember when she said it other times who she said it to?
I'm going to see counsel at sidebar for this.
Well, that was certainly some interesting moments, folks. Where's our Karen cam? Did Karen actually go up to sidebar? Maybe she did. Yes, I guess Karen doesn't want to be on the Karen cam. My name's GrantSmithEllis, by the way. That's a shot of John O'Keefe's brother, Paul O'Keefe. Aaron O'Keefe, his wife, is next to him. I can show her. There's Aaron and Paul sitting together. I shrunk the Karen cam. She is not actually Karen. Karen cam's over there. Such a sad series of moments, and that is John O'Keefe's dear friend behind there. I believe that's Tara Kerrigan. Might not be. I can't see everyone that clearly, but that is some of John O'Keefe's family members. We're going to pan now, and we're going to see a shot of Peggy O'Keefe. Margaret is her full name, Peggy O'Keefe, John's mom. In the back there is one of the Dougals. Good man. And then I think Mr. O'Keefe is just out of shot to the left. I think it's hard for Mr. O'Keefe to go to court on those benches. He definitely, he looks like he's the most uncomfortable, so I can see why it's so hard for him to go all the time. But just a sad moment for Miss O'Keefe during opening statements earlier. And what you'll also be able to see, by the way, the court feed, the law and crime feed that we're watching from the court pool is about a few seconds behind the Zoom. So we will know when we're out of sidebar quite early. Also, of course, we have the Karen cam, the David Yannetti cam, and Alan Jackson is now named Marshmallow Man because he started talking about Marshmallow Man earlier. All right, we're about to come back from sidebar, folks. Tal's going to leave you to the return to the hearing. Give it about 20 seconds, maybe a little bit less. Come on now. I'm a little Tal. Come on now. Come on, law and crime. Well, it's actually the court TV pool operator, but come on now. I'm a little Tal. There's Mr. O'Keefe. There's Karen Reed's brother. There is the lawyer who's also a juror from the first trial. There's Mr. I almost said Mr. Burns, but that is Mr. Reed. There is Miss Reed, Miss Janet Reed. And can't really see who's in the back. All right, here we go.
Sir, after the defendant came over to you and spoke and then left, do you remember hearing her make further statements?
Yes, sir.
And do you remember her making further statements similar?
I do.
To the statement to you?
Yes, sir.
Could you share with the jury what you remember her saying, not to you, but after she left you?
I remember hearing I hit him several other times. Again, not directed to me, just kind of off in the background. I'd like to reiterate, we were really focused on the patient at that point. We were trying to provide care.
Thank you, sir.
So now, after Mr. Brennan asks you a few questions, now you remember her saying, I hit him a bunch more times. correct?
I remember hearing it in the background several other times.
Really?
Yes, sir.
Never mentioned that on direct examination, did you?
I don't remember being asked about it, sir. I remember saying what was asked to me.
You were asked, did you ever hear the defendant, Ms. Reed, say anything about I hit him? And your answer was, she said to me, in answer to my question, I hit him, I hit him, I hit him 3 times, and that's it.
To me.
You didn't clarify that, oh my gosh, she's running around like a chicken with her head cut off, screaming I hit him to everybody else under the sun.
It was, again, it was behind me in the background as I was providing patient care. Again, that was not my focus.
Okay, so you didn't really hear her say anything in the background because you weren't focused on that, right?
I remember hearing a generalized commotion in the background, but again, that was not our focus.
So generalized commotion is very different than hearing her say, I hit him to other people, correct? You'd agree with that?
Yes, sir.
So what you actually heard was the chaos and the commotion of a chaotic scene, correct? In the background.
In the background.
As you focused on your patient care, correct?
Yes, sir.
Okay, not specific words coming out of my client's mouth, correct?
To the question that I posed, do you know him?
You're right. We're off that question.
Okay.
That question, I got it.
Yes, sir.
Triple I hitters.
Correct.
But with regard to what Mr. Brennan just asked you, the generalized commotion, to use your phrase, in the background, you didn't hear any specific words coming out of my client's mouth, did you?
I heard I hit him. But again, it was in the background and it was not my focus.
Well, why didn't you say that on direct? That's kind of an important point. That's why you're here.
Again, if it was neglected on my part, it was not intentional.
Not intentional to neglect that part for the jurors on direct examination?
No, sir.
Certainly not intentional to neglect that part of your testimony on cross-examination?
No, sir.
But you decided to bring it up on on recross examination when Mr. Brennan is asking you questions again, correct?
It was asked of me. Yes, sir.
And it was after, of course, that your new statement that you've never testified to before, ever, is this generalized commotion included a bunch of I hit hims in the background, correct?
Sir.
And that comes after you saw the video that clearly shows that when you describe having heard this statement, my client was nowhere around you, correct?
That segment of the video that you showed me?
Yes.
That was not the time frame in which she said that to me.
Well, that was the time frame when Flamati was giving CPR, correct?
He was doing CPR down prior to that as well.
Really?
Yes, sir.
Well, you just testified that you saw him standing up in a big yellow jacket and then kneel down and start giving CPR. We just watched that video. Correct?
But again, the clip of the video that you showed me,
right,
that was not the segment in which he said that to me.
Well, that's what you're saying now, but what I'm asking is, you described a very distinctive scene, a very, very specific scene.
Yes, sir, I remember it vividly.
She said that I hit him, friends, when Lonnie was down giving CPR, and you were kneeling down giving airway support, and he was doing rhythmic CPR chest compression.
Yes, sir, that's what happened.
And then I showed you that very scene, didn't I?
Yes, you showed me that clip prior to that.
I showed you the very scene that you described where Flamani gets down and starts chest compressions and never stops until the gurney is taken off the frame of the camera to the end. Isn't that what I showed you?
That is.
Sure. I don't know if I can do it again. I showed you the scene where firefighter Flamani gets down on his knees, begins chest compressions, and never stops until that gurney is taken off camera, off frame, into the ambulance. That's the clip I showed you, correct?
That is the clip you showed me.
And that's exactly when you described your vivid memory from 3.5 years ago. That's exactly the scene that you described when my client supposedly said, I hit him to you, correct?
Again, the clip that you showed me, that was not when it was said. That segment that you showed, that was not when it was said. It was said prior to that, when the three of us were together.
So Flamati was not giving chest compressions then?
He was. The CPR was a continuous effort throughout the resuscitation.
But we saw him start it. Firefighter Nuttall, we saw him start it. We saw him walk into the frame, kneel down, and begin the chest compressions, didn't we?
We did.
And at no point, at that time or after, did my client even approach you, did she, in that clip?
She did.
What?
Objection.
Just a question.
Sure, sure. Do you need to see the that clip again?
Yes, please.
We're not going to show the video again. We've seen 2 videos. Which one is marked?
The
The
Commonwealth.
one with the timestamp at
Right.
the top?
It's the exact same video. One has timestamp, one doesn't. Just to be clear, you described a very detailed scene in which firefighter Flamati got down on the ground, on his knees, and began CPR.
Yes, sir.
We saw a clip that it played fully through.
Mm-hmm.
Starts and stops, but it played fully through, correct?
Yes, sir.
That was true and accurate video of what happened that day,
Yes, sir.
that morning, correct?
Correct.
And from the time firefighter Flamati began his CPR, he never stopped. Went all the way through until the gurney was taken off the camera, correct?
Correct.
You also described very clearly, before you saw the video, that the time when my client walked over and you had this dialogue and you heard this statement, it was during the time that firefighter Flamati is giving the CPR, correct? You described it.
Yes, sir.
But when we actually see firefighter Flamati giving the CPR, as per your description, at no time did my client walk over and have a conversation with you, did she?
She did in the video.
In the portion that Mr. Brennan played you, was firefighter Flamati giving CPR at that point?
As I said previously
Was
as well.
he or was he not? Yes or no?
Objection.
I'm going to let the witness answer the question.
Firefighters Kelly and Flamati were trading off CPR. Tony started doing CPR, and it was passed off at one point to Firefighter Kelly. Firefighter Kelly at that time was a BLS EMT. Firefighter Flamati was a paramedic. They're going to move towards Firefighter Kelly performing CPR because at that time his skill set was not as advanced as Firefighter Flamati's, as Tony's. But they did switch off. That is a routine cardiac arrest. We switch off compressions.
But the video that Mr. Brennan showed you was earlier in time, a few seconds or a minute or two earlier.
Yes, sir.
You'd agree with that, correct?
I would.
And firefighter Flamati had not begun CPR, had he?
I don't believe so.
That's right. He hadn't. But that's the time that my client walked over your general area, correct?
Correct.
Before CPR was started, correct?
CPR was started immediately, sir.
Can we wrap this up?
I don't know if we can, Judge.
Give you a couple more minutes.
I don't believe so.
That's right. He hadn't. But that's the time that my client walked over your general area, correct?
Correct.
Before CPR was started, correct?
CPR was started immediately, sir.
Can we wrap this up?
I don't know if we can, Judge.
Give you a couple more minutes.
Do you understand the confusion?
Objection.
Sustained.
All right, a couple more questions on this. The video that Mr. Brennan showed you.
Yes, sir.
And you pointed to and said, oh, that's the time when she walked over and said the statement.
Yes, sir.
Remember that?
I do.
Firefighter Flamati was not even kneeling down giving CPR, was he at that point?
No,
The answer is yes or no?
No.
Okay, he was not. Later, as the video continues to run, at some point, we see firefighter Flamati enter the screen, kneel down in that bright, reflective yellow jacket, and begin CPR, correct?
Yes, sir.
You had previously said that when you heard the statement and she walked over to you, it was when firefighter Flamati was giving CPR, correct?
Yes, sir.
And at no point, you'll agree with me, we just played the video, at no point after he started giving CPR did my client come anywhere near you. Isn't that what the video showed?
That was the segment that you showed me.
You indicated on redirect, that Mr. O'Keefe did not have any injuries to the left side of his body.
Not that I recall.
Isn't it true that in addition to the egg on the right side of his head, he also had a black eye on the left side?
I remember that the swelling had started to, it's referred to kind of as raccoon eyes. It's a bruising of both eyes.
Do you remember
battle signs.
Do you remember saying, in answer to the question, did it look like, in addition to the egg on the right side of his head in the front, did he also have a black eye on the left side? Your answer is, if memory serves correct, yes.
Yes, sir.
So it's not true that he didn't have any injuries on the left side of his body or face, correct?
That swelling kind of migrates over time to both sides. That is a common occurrence for both eyes to be swollen.
Did he have an injury to the left side of his face?
He did not.
Did he have a black left eye?
Yes, he did.
Would you consider a black eye an injury?
Yes, sir.
Let me ask you the question again then. Did he have an injury to the left side of his face?
Yes, sir.
Thank you. One last question. You indicated that it was a chaotic scene outside on that front yard.
Yes, sir.
Fire engines, ambulances, patrol vehicles, engines running, diesel engines, flashing lights, people screaming, people talking over the howling wind, correct?
Yes, sir.
Did you ever see the homeowner come out the front door?
Don't recall.
You don't recall, or you didn't?
I have no idea who the homeowner is.
And you never saw anybody come out of the front of the house?
No, sir.
That's all I have.
One issue.
Okay, we're going to
Briefly.
sidebar.
I want to see counsel at sidebar.
Folks, we are in recess. My name's GrantSmithEllis. Our Karen cam is live. You saw me jumping forward a little bit. You can see the Karen cam. All right, we're back.
Sir, in Mr. Jackson's questions, he asked if you had ever said that you heard the defendant say, "I hit him," separate from when she approached you. Do you remember previously testifying that you heard her saying, "I hit him in the background," separately from you?
Yes, sir.
You remember testifying that before under oath?
Yes, sir.
In court?
I do.
Anything, Mr. Jackson?
Yeah, just a second, Your Honor. Thank you, Ron, if I may.
Yes.
Just a quick question, Firefighter Nuttall. When you were asked to recite your memory of that day on February 8th, 2022, just 10 days after this incident, did you ever say that you heard in the background, "I hit him" over and over again?
I don't recall.
All right.
When you testified at the grand jury, last question. When you testified at the grand jury, did you ever say that?
I don't recall.
But again, your memory is better now than it was then. Right.
Yes, sir.
All right. Firefighter Nuttall, you are all set.
Thank you, ma'am.
All right, your next witness, Mr. Brennan.
Thank you. The Commonwealth calls Kerry Roberts.
Chrissy, could I get anything?
In the stand, I did have an exhibit I would like to introduce and play for the jury.
Okay.
And this is clip 2.
No objection from the defense?
No, Your Honor.
And you're marking this as an exhibit?
Yes, Your Honor.
Okay. Do you have something for the court reporter to mark?
We can put it on a zip drive. We can discuss collecting all the clips and putting them on the same zip drive, or we can use different zip drives, whatever the court's preference is.
So we need something. So we need something physical. You can play it and then we'll mark it.
Ms. Gilman, do you have a separate clip?
Jim, is that right?
Thank you. I can have this marked, Your Honor.
Thank you.
Bye.
All right, Ms. Roberts, please. Okay, thank you.
We'd like to play this first and then call Ms. Roberts.
Oh, okay, I'm sorry.
Thank you, Your Honor.
Every day they come back to you with something. I mean, how much do you remember?
I remember it, but I question, do I remember it because it's been relived so much? I mean, when I see the video of me driving from the waterfall, like what I just described, tapping the brakes when I crossed the intersection, Washington over Sherman Street, do I actually remember that I kind of slowly proceeded through that green light? No, I don't actually remember that. But I've seen the video so many times that you then question, did I remember it on my own? Or was my memory jogged? But I also wondered, did I say, could I have hit him? Or was it told to me that I said I hit him? And I knew I never could have said that, so the closest I must have said was, did I hit him? I know I said I hit him, but did I really say it as many times as law enforcement's claiming I said it?
Thank you. I now call Kerry Roberts.
Stand and face the clerk. Raise your right hand. You solemnly swear the evidence given to the court and jury in the case down here to the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. You may take the seat.
K-E-R-R-Y. All right, Mr. Brennan, whenever you're ready.
Thank you, Your
Good
Honor.
afternoon, Ms. Roberts.
Good afternoon, ma'am.
Good afternoon.
Could you please introduce yourself to this jury?
Hi, my name is Carrie Roberts.
Ms. Roberts, where do you live?
I live in Canton, Massachusetts.
How long have you lived in the area for?
I was raised in the Boston area, North Shore, South Shore. I went to high school in Braintree and I moved to Canton about 12 years ago.
Do you live alone?
No, I live with my husband and 2 children.
How old are your children presently, this day?
My son is 13, my daughter's 15.
Do you work?
Yes, I do.
Without identifying specifically where, can you share with us a little bit about what you do?
I'm an executive assistant, and I've been with my company for 18 years.
Ma'am, if you could just move the microphone just a tiny bit closer. Thank you very much.
You have 2 children, you're
Yes.
married,
Yes.
and you live in the area.
Yes.
I want you to tell us whether you know a person by the name of John O'Keefe.
Yes, I do.
Would you be willing to share with us when you first met Mr. O'Keefe?
Well, I went to high school with John in Braintree. He played soccer, I played soccer, so we probably hung out in middle school, but we went to 2 different middle schools. And then I hung out with him more in high school. He was a year older than me. His sister was 2 years older than him in school, and his brother was younger, so at some point I was in high school with each of his siblings.
Did you at some point become friendly with John O'Keefe?
Yes.
Could you tell us about that?
When his sister Kristen passed away, and then her husband Steve passed away, they lived in my neighborhood. John took over for the children and moved into my neighborhood as well.
When John took in the children, did you offer any assistance or any help to him?
Yes, before John was even going to take over, he was going to potentially move in with his brother-in-law and the children to help out. And then when his brother-in-law passed away unexpectedly, John took over. And I jumped in because I was a friend from high school that he knew, and he had all kinds of people helping, but he sort of said, I'm going to lean on you for right now because I know you best. And I knew his parents and his siblings, and so I introduced him to my husband, and we jumped in. It was, preschool drop-offs, preschool pickups for my son and his son, and just from then until the time of his death, we were just friends, very close friends, and we hung out all the time. The children hung out all the time, and he was the emergency contact list at my children's school to call if something had happened.
Were you close friends before he took over the care of the children?
No, I wasn't very close friends with him then.
Were you close with his family before he took over care of the children?
No.
Did your friendship with him develop after he took care of the children?
Yes.
You mentioned you have a son?
Yes, I do.
And is your son the same age as John's nephew?
Yes.
Was there any common interests or activities that engaged your son with John's nephew?
Well, they went to in-home daycare together. They went to preschool together. They went to pre-K together. Then they went to elementary school. They played baseball together since they were T-ball. My son plays hockey. Patrick tried hockey. He didn't like that. So we spent a lot of time at the baseball fields together.
As you spent a lot of time together and had mutual care of children, did your relationship with him grow closer?
Yes.
And can you share a little bit with the jury how close you became?
Well, John was a bachelor, and he didn't have any children of his own, so when he took over for the children, he sort of, leaned on us to kind of guide him and, all the things to do if there's someone has a headache and, if there's an ear infection or, he had his mom and dad also helping as well, but I was right up the street. So if I would go to BJ's, I would call and say, can I grab you anything? If I would go to Walmart, any of the places I would go, I would call and say, do you need anything? Can I help you? Can I grab something for you? And he did the same. We just sort of all chipped in and helped.
As your friendship grew, could you tell us a little bit about your relationship with John?
John and I were very close. We spoke on the phone and hung out. He became very close with my husband as well because he was right down the street. But we just had a friendship, a very close friendship.
Tell us about the day-to-day activities and how you would try to assist John with the children.
Well, John moved across town. I don't remember when. I forget how many. Patrick, I think, was in 5th grade or 4th grade. And I would take him home with me on Wednesdays because John would be working. So it was more of a, if he was at my house and my daughter needed a ride the other side of town, he would take her with him. We were just very close friends. We did a lot together. We would do baseball tournaments together. We would have drinks together. We would, all the things friends do.
As you grew closer to John and helped with the children, did you become closer with his family?
Yes.
And who specifically did you become closer with?
Mrs. O'Keefe and Mr. O'Keefe, his parents, and Paul I would see from time to time, but not a lot. He doesn't live in Canton. But Mr. and Mrs. O'Keefe would be there all the time to help as well. And Mr. O'Keefe would take my son and Patrick, the nephew, out to Dunkin' Donuts all the time.
Can you tell us a little more about the collective effort of other people, including his family, helping John raise these children?
There was a lot of us that jumped in to help. It was not just me. There was a lot of Kaylee's friends' parents that jumped in and helped for Kaylee, his niece, and Patrick. There was a lot of us that helped out with Patrick. All of the community all came together to help him because there was this guy that just lost his sister and brother-in-law, and he stepped in to take care of these two kids, and he didn't really know what he was doing at first, but he got the hang of it pretty quickly.
You have a son that shared a lot of interests with his nephew.
Yes.
He also had a niece.
Yes.
Did you spend more time helping with his nephew or with his niece?
With his nephew.
Were there other people in the community you knew of who spent more time helping with his niece?
Yes.
And who was that?
Jen McCabe.
Did you know Jen McCabe?
I had met her once. John got a discount at Reebok, so he would take the kids, well, he would take anyone with kids up with him to get shoes, like sneakers for back to school or whatever. So one day he did take Jen and I up to Reebok, but other than that, I never talked to her on the phone. I never saw her out. Her children are older than mine, so we never really crossed paths.
As it relates to the night of January 29, 2022, how much earlier was it that John took you out with the children and Miss McCabe out with her children to get sneakers? How many years before that?
Years, like 6 or 7 maybe.
Okay. And from that time you met Jen McCabe in the years past, did you ever spend time with her again before January 29th, 2022?
No, I did not. I didn't know her.
Were you friends with her?
I was not.
Did you speak on the phone with her?
No, I did not.
So other than that one meeting, you were strangers?
Yep, that was the only time. I knew her. I knew of her. She has 4 girls, but I didn't know her.
At some point, as you were part of John's life, did you learn that he was dating a person by the name of Karen Reed?
Yes, I did.
And do you see that person here in the courtroom today?
Yes, I do.
Could you point her out and describe an article of clothing that she's wearing?
She has a black suit jacket seated at the front table.
When did you first become familiar or know about Miss Reed?
July, I think it was, of 2020. John, we were having people over, and so I invited him, and he said, I'm going to bring Karen over. And I was like, I don't know who that is, but okay. He assumed I knew because he had been dating her for a little bit, but it was COVID, so we didn't see him very often during that time. So Karen came over that night.
And this is early 2020?
I think it was summer, so I think it was around June or July.
Briefly, just tell us a little bit about where and the circumstances of meeting John and Karen for the first time.
They came over to my house and we hung out on the back porch, had some drinks, there was music, kids were around, just a nice normal summer night. We had other people over as well.
Over the next coming months, did you become more familiar with the defendant?
Yes.
Did you see her more often?
Yes.
And could you generally describe for the jury how you learned more of her and saw her more often?
She would take care of the kids a lot, mainly, well, not mainly Patrick, but not mainly Kaylee either. She helped out a lot with the kids, so if we were at baseball, she would come to all the baseball games, or she would drop off or pick up my son or Patrick if they were going to the golf course or the driving range.
Would you see her during events with your son and John's nephew?
Yes. We did baseball tournaments and
so when you go to baseball tournaments, would that be away, an overnight type trip?
One of them was. It was down the Cape.
Okay. How often would you spend time with John and the defendant?
Not that often together, but John would stop by himself. My husband would go out more with John, but I didn't spend much time with the two of them, not a lot of time outside of the baseball field.
Did you become friends with the defendant?
We were friendly.
Did you ever spend time alone to go out or socialize?
I did not.
Would you see her when you would pick up or drop off kids, or she would pick up or drop off kids?
Yes.
Did you ever speak to her on the phone?
Yes.
In relation to what?
Corresponding with the kids, pick up, drop off, mainly Ryan and Patrick, not about Kaylee.
Did you ever spend any important dates or times or holidays with John and Miss Reed?
No.
I want you to take us ahead to January 28th, 2022.
Okay.
On January 28th, 2022, do you remember that day?
Yes.
Generally, what do you remember about the day of January 28th, 2022?
There was a blizzard coming, and it was my daughter's friend's birthday. So we were going to be going out celebrating that night, but we did it on the early side because there was a blizzard coming.
What was your plan for that evening?
We went bowling. We got dinner, then we went bowling, and then I came home because I wanted to be in before the snow started.
Had you communicated in any way with John that day?
Yes. He texted me. My son had had an issue at school. Patrick had been dismissed, I think, for a doctor's appointment. So he did text me to see how my son was doing.
Did you simply text, or did you get a chance to speak to him that day?
I believe we just texted.
Did you go out that night after bowling?
No, I did not.
Was your husband home?
Yes.
Did he go out that night?
He did. He went out with John.
And do you know where he was planning on going?
They went to McCarthy's, a bar in Canton Center.
Had you been to McCarthy's before?
Yes.
Can you just briefly describe what McCarthy's is?
It's a restaurant bar. There's a large bar in the middle, the seating on the left and the right. It's right in the center of town.
Do you remember about what time your husband went out?
I do not remember exactly. I don't know if I got home and then he went out, or if he was already gone when I got home. I don't remember. But it was he went out around the same time that I arrived home, which was on the earlier side.
How many times had you been to John's home, would you say, over the past couple of years before this night?
Oh, many.
Many times?
Many times.
Were you familiar with the house and the driveway?
Yes.
May I approach you on?
Yes.
Should I return to the podium and ask the questions?
You can ask them from there.
Thank you. Ma'am, I'd ask you to take a look at that photo in front of you. Do you recognize what is in that photo?
That is John's house.
Is that a fair and accurate depiction of how his house looks?
Yes, it is.
I'd like to move this to evidence, please.
Okay, any objection?
No objection.
Six.
May I publish to the jury, Your Honor?
Yes.
Thank you. Thank you. You can take it down. I've shown you a second photo. Do you recognize what's in that photo?
Yes, that's John's driveway.
Is that a fair and accurate depiction of how John's driveway appears?
Yes, it is.
I'd move that into evidence. No objection.
Okay.
Exhibit 7, so marked.
May I publish?
Yes.
Could. Thank you. I'm showing you a third photo. Do you recognize what's in that photo?
Yes.
And could you share with the jury what's in that photo?
It's the side of John's house looking up from the driveway.
Is there anything you notice on the side of the house?
The lights. Or the ring camera.
Are you guessing, or do you know that's a
No, I know there's one there.
And how do you know that?
Because I got a ring camera and I could look and see who was at my door. And then he said, why didn't you tell me about these things? So he bought one.
I move to introduce this photo.
Okay.
No objection.
Thank you.
Exhibit 8.
May I publish, Your Honor?
Yes.
Ms. Roberts, with the laser pointer, could you just point at the picture and show where the Ring camera is?
On this screen?
Yes, please.
Whichever one you can do.
Okay. Why isn't it working?
Nope.
It's on.
Okay, well, you know what? Rather than use the pointer, why don't we can you describe where you see the Ring camera on that picture?
It's in where the two lights are under the top window.
Okay, thank you. We could take that down, please. How many times would you guess you had been over to his house?
I don't know. More than 50,000. I don't even know. A lot. It was weekly.
That night you told us that your husband went out to meet John at McCarthy's, a bar.
Yes, he did.
Do you remember your husband coming home that night?
Yes.
Do you have any memory of about what time he returned?
I'm guessing, but somewhere around 10:30.
So I'm not going to let you guess. Do you know? Do you have it?
I don't know. It was around 10 or 10:30. I can't be exact.
Did you see him come home?
Yes.
What was the forecast for that night and the next morning?
There was a blizzard coming.
Was that part of the decision making of going out or staying home?
Yes.
At that time, when your husband came home, did you look outside? Do you have any memory of what the weather looked like around 10:30?
I remember the snow started to fall somewhere around 12 because I remember looking out the window and I could see it starting.
And that was the beginning of the snowfall?
I believe so.
What was the weather out that night?
The weather that night, I think, was fine. It was cold, but it wasn't snowing yet.
I see. I want to move forward ahead. At some point that night, did you go to sleep?
Yes, I did.
Did you sleep through the night, Ms. Roberts?
Yes, I did.
Okay. At some point, did you wake up?
Yes, I did.
I want you to tell us what was the reason that you woke up.
I got a phone call at 5 o'clock in the morning from Karen Reed.
Were you expecting a call?
No, I was not.
Had you ever received a call at 5 in the morning from Miss Reed before?
No.
Share with us what happened that morning. What did you hear?
Karen called and the first thing she said was, Carrie, John's dead. And then she hung up. And then...
When she said that, did you have a chance to have a conversation with her?
No, I did not.
Describe her demeanor when she said that.
She was yelling loud enough, my name, I think it was 3 times, it might have been 2. She was yelling loud enough that she woke my husband.
Your husband was sleeping next to you?
Yes, he was.
Was she loud, yelling, screaming?
Yes, she was very loud. She was screaming.
After she said, Carrie, John's dead, did you know what she meant?
No.
And did you say this was around 5:15?
This was at 5. She called me at 5 on the dot.
After she hung up, what did you do?
I was half asleep still. I didn't know what was going on. So I started to get up, and I think I tried to call her back. I know I tried to call her back, but I don't know exactly when, because I was like, what? So my husband said, what was that? I said, I don't know. Something's going on. I don't know what's going on. That was Karen. And then I tried to call her back. I know I tried to call her back, but I don't know if she answered or if she called me back the next time I spoke to her.
After she called you again, did you have another discussion, or did you hear her say something else the second time you spoke to her?
Yes, the second time she said, I think something happened to John. I think he got hit by a plow. He didn't come home last night. Kaylee was home. He would never leave her by herself, and I was not supposed to stay at the house last night. So I think something happened to him.
Did she say anything about drinking?
Yes, she said, we drank so much, I don't remember anything from last night. And I said, okay, where are you now? She said, I'm driving. And I said, you need to go home. Where's Kaylee? And she said, at home. I said, you need to go home and be with Kaylee. She cannot handle this, thinking, her uncle's missing. I said, you're going to get a DUI. You need to go home.
Was there anything else in the conversation that she said to you at that time?
She said, I'm going to drive to your house. Would you drive my car? And I said, yes. So at that point, I started to get dressed. I turned on the automatic car starter so it would warm up. Told my husband, you know, I don't know what's going on. John didn't come home. And so I think my husband tried to call him, and I tried to call him. And my husband said, you're not going anywhere. It's a blizzard. He's probably on somebody's couch. And I was like, I know, but she's really upset. I'm just going to go. She wants to come here. I'm going to drive her car. And then I went out to my car and sat and waited for her.
When you called John, did you get any response?
No, I did not.
As you were waiting for the defendant, did you make any other phone calls?
I did. When I was in the car, I thought to myself, well, she thinks he got hit by a plow. I'm going to call the police and see if there was any accidents or maybe something happened. They brought him in. And I spoke to the officer who said, no, nothing of that sort. I've been here all night. And then I called the Good Samaritan Hospital and Milton Hospital to see if they had anybody that was taken in an accident.
When you called the police to look for Mr. O'Keefe, did you call 911?
No, I called the non-emergency line.
Do you know if that call was recorded?
I believe so.
I'd like to introduce an exhibit.
Okay. Any objection?
No objection, Your Honor.
Okay.
Exhibit 9.
When you called the police, what was your level of worry at that point?
I wasn't super worried. I mean, he didn't come home, but they were out drinking, so I assumed, like my husband said, he's probably on somebody's couch.
The second call you had with Miss Reed, can you describe her demeanor in that second call?
She was frantic. She was frantic. I mean, she couldn't find John, so she was very worried.
How soft or loud was that phone call?
It wasn't as loud as the first one, but it wasn't a regular conversation.
With the court's permission, I'd like to play the exhibit of the call.
Okay.
Hi, my name is Sarah. I'm calling because my friend's boyfriend did not come home last night. They were at waterfall, and now she is calling me hysterical because she doesn't know where he is. You didn't take anybody outside the name of John O'Keefe, did you?
John O'Keefe?
Yeah, he's about to cop, and it would be on post, but...
No.
I think he probably got a ride and passed out at someone's house. I don't know, but...
Yeah, no, we didn't lock anybody up or anything like that. And where does he live?
He lives on Meadow, down the Pleasant.
He lives on Meadow, off Pleasant. Okay, and where's the wife home? You said your girlfriend?
It's his girlfriend, yeah. They were out having drinks, and then she left and expected him to come home at some point, and he never did.
Yeah.
And so I said to her, even my husband had been out with them earlier in the night, but then he obviously came home. And he has custody of his niece and nephew because their parents passed away.
Okay.
And so she's home with the niece and nephew, but they're old enough to be home. And so she's nervous because she never even called me.
Yeah.
So she's like, I feel like something happened. And I said, okay. Well, so call the area hospital and nobody happened. I personally think he probably picked him up and he got there. I don't know.
Yeah, where? Did he didn't drive last night?
No.
No. Okay. Again, it's more, it would be driven by you. She would have to, call in a conversation and talk to us. But I mean, as of right now, it's more, he just didn't come home last night. Is this common sometimes happen with him?
No, that's why. That's he didn't call his niece. That's kind of why she's more freaking out. So I figured I called the area hospital and then I would call Kansas police just to make sure he didn't get picked up. But like I said, he's about to police officer and he knows best people. If anybody could pick him up, please get it off.
Okay.
Again, we're doing having a bullshit party or something.
No. Unfortunately, I wasn't there. I was not there. But we didn't get any calls, anything like that. Nobody was arrested or anything like that. All righty.
All right, well, thank you.
All right, no problem. Good luck.
Okay, thank you. Bye-bye.
Were you in your car when you called the police station and the hospitals looking for John?
Yes, it was.
Do you know at that point whether anybody else had called the police station?
No, I don't know.
Do you know at that point if anybody else had called any hospitals?
I don't know.
How long did you wait in your driveway?
I don't know. I'm sorry.
Okay.
Maybe like 7 minutes, 8 minutes.
What were the conditions like out that morning?
It was bad. It was in the middle of a blizzard.
When you were outside in your car in the driveway waiting, describe the lighting conditions for us.
It was still dark out. It was 5 o'clock in the morning and it was snowing, so it was not great.
How was the visibility?
Not great. It was coming down really fast at that point.
You said that night when you went to bed, the snow just started. Had snow accumulated at that point?
No, I don't think so. It was just starting to stick.
I'm sorry, that was the night before, but at this point when you were in the driveway, had the snow accumulated?
Oh, yes.
Do you know how many inches it was?
No, I don't.
Okay.
Enough that the plows are out.
As you were waiting for the defendant, did she arrive at your house?
She did not.
What happened?
Again, I don't know if I called her or she called me, but eventually we connected on the phone and she said, I said, where are you? I'm waiting. And she said, I'm at Jen's house. And I said, Jen who? And she said, McCabe, she's going to drive my car. And I said, okay, well, listen, they don't want cars on the road because it's so bad. I'm already in my car. I'll come there to Jen's house, stay there, and we'll follow each other and we'll go back and drop your car off. Did you look in the house for John? Could he just be in the house, passed out somewhere? And she said, no, she hadn't looked in the house. So I said, okay, now I'm going to come to Jen's. We're going to take the car home, drop it off. We'll check around the house. And then I don't know what the next step at this point was. I just wanted to check the house.
At the time you directed that you were going to meet at Jen McCabe's house and then drive to John's house, was there any suggestion by the defendant where she wanted to go?
I didn't know where Jen's house was. I knew the street. I had dropping Kaylee off or picked her up a few times. So I said, stay on the phone with me so I don't know which house it is. And so when I got there, I pulled in the driveway and there was some conversation about...
Can I back you up and just ask you a little bit about the drive there? I don't mean to interrupt. When you left your house, you talked a little bit about the weather conditions. How long did it take you to get from your home to Jen McCabe's?
Oh, it's quick. Probably 4 minutes.
What was the driving like?
It was not good driving. That's why I didn't want 2 cars on the road.
Did you have any difficulty driving through that storm?
No, I mean, it was treacherous. But I was in 4-wheel drive. I have an SUV.
You mentioned you didn't know exactly where Jen McCabe lived. Had you been there to drop off John's niece before?
Yes, but I didn't know which house it was because when I picked her up before, she was either getting out of the car at the driveway or waiting at the end of the driveway. So I didn't know which house it was.
I think I interrupted you, but were you telling us that as you drove to Jen McCabe's house, you were on a Bluetooth, on an open conversation with her to help with directions?
Yes, Jen and Karen were in Karen's car, and I was on the phone essentially with both of them.
Do you know what type of vehicle the defendant was driving at that time?
A Lexus SUV.
As you drove over to Jen McCabe's home and you had some guidance finding it, did you hear any conversations in that open line with, or even any statements by the defendant?
I remember when I pulled in behind her car in Jen's driveway, and at some point Karen said, my taillight, and I looked, and Jen she must have had the brake done because you could see that there was missing taillight.
When you say missing taillight, was it merely cracked?
No, there was a piece missing.
Could you see that as you were parked right behind the defendant's SUV or Lexus?
She must have been applying the brakes because you could see it, but there was a lot of snow.
When you saw that the taillight had a missing piece, did you say anything?
No.
Did you think anything of it?
No.
How long were you parked behind the defendant's Lexus while it was parked in Ms. McCabe's driveway?
Not long. We were just, I pulled in and then we stopped, and then the next plan, at some point in that conversation as well, or maybe on the ride, because now we're heading to John's house to drop a car off. I pulled out of the driveway, Jen pulled out, and I followed behind all the way to John's house. And at some point, Karen said, I left him at Waterfall. And I heard Jen say, no, I saw you pull up in front of my sister's.
Was anything else said about the broken taillight?
No.
You followed Miss McCabe?
Yes.
Where did you go?
To John's house.
Did you arrive?
Yes.
I want to ask you some questions about when you arrived and what you did next.
Okay.
When you arrived at Mr. O'Keefe's home, you were in two separate cars. Who pulled into Mr. O'Keefe's driveway first?
Jen pulled Karen's car in first.
So Miss McCabe was driving the Lexus?
Correct.
And the defendant was in the passenger seat?
Yes.
After you both pulled in, tell us what happens next.
We went, I wasn't sure if it was, at some point Karen showed us the taillight up close, but I didn't know if it was when we arrived or when we left. But we went into the house to look for John.
Okay. When the Lexus was parked by Miss McCabe in Mr. O'Keefe's driveway, was it facing the street or facing away?
Facing where the basketball hoop is, not facing the street.
I'd like to approach.
Okay.
Going to show you a photograph. Do you recognize what's in that photograph?
Yes, that's John's driveway. That's Karen's car on the left and John's car on the right.
Do you recognize both those cars?
Yes, I do.
Do you recognize that photo as a fair depiction of his driveway?
Yes.
Do you recognize it as a fair depiction of the motor vehicles?
Yes.
Now, when you went there that night and you pulled in behind Ms. McCabe and the defendant, is there any differences between how that area looked when you pulled in as opposed to that photo?
Well, it was the early hours of the morning, so it was dark out, and there was much more snow. And there was snow coming down.
I'm so sorry. You want to finish?
Nope.
Other than the snow and the lighting, is there any other differences?
Nope.
I'd like to introduce this as an exhibit, please.
All right. There's no objection, Mr. Jackson?
No objection. With the court's permission, I'd like to publish.
Okay.
And to help us understand, you see on the left is the house.
Yes.
There's a motor vehicle in the middle of the driveway, but it's the vehicle to the left.
Yes.
And whose vehicle is that?
That's Karen's.
Is that where it was parked that night when you went into the house?
Yes.
In the motor vehicle to the right, you recognize that?
That's John's car, or SUV.
Thank you, you can take that down. I'm showing you a second photo.
Okay.
Do you recognize that photo?
Yes.
What is it?
It's the back of Karen's car.
Does it look like a fair and accurate depiction of her car as it appeared that morning in the early morning hours to you?
Yes.
Do you notice anything that's distinguished in that photo?
The piece that's missing in the taillight.
Which one?
The right passenger rear.
Do you know when? I'm sorry. Do you know when this photo was actually taken?
I do not.
Although you don't know when it was taken, is that a similar depiction to your memory of how it appeared that morning at 5?
Yes.
Or a little after 5?
Yes.
I move to introduce this exhibit.
Okay.
No objection.
Okay.
The court's permission, I'd like to publish.
Yes.
We could take that down, please. After you arrived at Mr. O'Keefe's house, what was the plan to go inside? What were you looking to do?
To go inside and look and see if he was passed out somewhere. So we went in through the garage, and I started looking. I think Jen ran upstairs to Kaylee's bedroom, and I just started looking through the living room. Basement door was locked from the inside, so I knew he wasn't in the basement. And then I checked the other living room. He has a big house. Then I went to the top of the stairs to check his bedroom.
As you looked around, what was your mood?
What was my mood?
Yes. Were you calm?
I mean, I was worried, so we would, at this point, Jen had already established that they went to her sister's.
Sustained.
Okay.
Jen had already.
Hold on, Ms.
I'll
Roberts.
ask the question better. My apologies. How many rooms did you look through in John's house?
1, 2, 5 or 6.
Did you see Miss McCabe looking in rooms as well, searching?
She went upstairs when I was looking downstairs.
At some point, as you were looking, did you see the defendant?
Yes.
Was she looking with you?
She was in John's room.
What was she doing?
She was just standing there when I came up to the top of the stairs.
Did she say anything?
No.
Did she do anything?
No.
Was she searching?
I don't know. She was in the room.
What happened next?
At some point, Jen earlier had said...
Well, let's not talk about what was said. Okay. Let's just talk about
the plan
best
at this
you can,
point is to go to 34 Fairview.
Ms. Roberts, I know that I'm just going to ask you to wait for a question because we can only get one person at a time. So next question, Mr. Brennan.
Again, my apologies. And so as you're looking through the house, you don't find John. What happens next?
The plan was to go back to Jen's sister's house.
Who made that plan?
Karen wanted to go back there.
Well, tell us a little bit about that. How did that conversation come up, and share with the jury what was said?
And the car ride to Meadows, Karen said, I left him at Waterfall, and Jen said, no, I saw you pull up in front of my sister's. So then Karen said, we need to go back to your sister's, and I said, no, we're going to go to Meadows, and we're going to drop the car, and we're going to look there, then we'll go there if we don't find him.
When you were at the house, Meadows, John O'Keefe's house, and you didn't find him, was there any further conversation about what the next steps would be?
I said, let's go. He's not here. But I didn't know where Jen's sister lived, so we got into the car. Jen was in the passenger seat. I was driving my car. Karen was in the back seat. And Jen was giving directions.
Did you begin your way towards Meadows?
Yes.
And it was Miss McCabe who was giving directions?
Yes.
As you began driving to head towards Meadows, in addition to trying to drive, were you doing anything like looking or searching?
Well, yeah. We were looking on both sides of the... I was looking on both sides of the road in case he was walking home.
Did you see Miss McCabe searching?
Yes, she was looking out as well.
So describe a little detail about what you saw Miss McCabe doing.
She was looking out the window as we were driving. So was I, as I was driving.
And where was the defendant during that time?
She was in the back seat.
Was there any conversation, comments, statements?
Well, she would be in the back seat, and then she would be in between Jen and I, in the back seat, and then in between Jen and I. She was just very frantic.
Okay. Was she saying anything?
Specifically, I mean, there was conversation on the way there.
Okay. Was she looking as well? Did you see her looking out the windows like you and Jen?
I don't know if she was because she was in the back seat.
Okay. As you drove to Meadows, what was the visibility? The same or better or worse?
No, it was poor.
Did you make your way towards Meadows?
I did.
As you finally got to Meadows, was the house on your left side, your side, or on the other side?
Are you talking about Fairview or Meadows?
I'm sorry, Fairview.
Okay. The Fairview house came up on the left-hand side.
Before you got to the house, is there a tree line between that house and the house before it?
Yes. There's a cluster of trees and bushes.
All right, take us back. I want to talk about that morning. As you're driving and approaching Fairview, tell us what you hear, what you see, what's happening.
Jen's giving directions, and it was really bad driving. I was white-knuckling because it was getting slippery. Karen wouldn't put on her seatbelt because she was in between us again the whole ride, and then sitting back. But she was worried because we weren't finding John.
Were you having words?
Yes.
Tell us.
I said to Jen, where are we heading? And she said, my sister lives on Fairview. And I said, where is that? She said, off of Chapman. I said, oh, okay, near Spring Lane. At some point, Bella's mom came up.
Tell me what that means.
I didn't know who it was, but it was one of Kaylee's friends, Bella's mom. Well, the directions, At some point, Karen was talking about Bella's mom to Jen, saying she never liked me. I didn't know who this woman was that they were talking about. But apparently, Bella's mom lived near where Jen's sister lived on Fairview.
Did you learn any more about the relevance of Bella's mom?
No. Oh, well, I think John had dated her.
Objection.
I'm going to allow it.
So as you approached Fairview, tell us what happens.
As we approached Fairview, at the house. You mean the house or the street?
Yes, the house.
The house. Jen said, my sister's house is right up here. And I said, okay. And as we approached the house, Karen from the back seat is now screaming, there he is, let me the F out of this car. And she's out kicking the back door to get out.
When you heard the defendant scream, there he is, and started kicking the car door, did you see anything?
I did not.
Did you see anybody?
I did not.
Did you look?
I looked.
Was there anything that impeded your ability to see far?
No, it was just snow.
How far could you see when she was yelling, there he is?
How far could I see?
Yes.
I mean, the visibility wasn't great.
Okay. Was she pointing or giving any direction?
No, she just said, there he is.
Okay. What happens next?
And then I unlocked the car. I looked over, I didn't see anything, and I unlocked it so she could get out of the back seat. I looked at Jen and I said, she's crazy. And then I turned around and watched, and she ran over to a mound of snow.
When she started running, before she got anywhere, did you see anything at that point?
I did not.
Were you looking?
I was looking. She said, there he is, so I'm looking around to see where he is.
And you could see nothing?
I did not.
Did you see her run around or directly?
She ran right over to the mound of snow.
Could you tell what the mound of snow was from the car?
Once she got to it, yes, it was. Once she got to it, you could tell it was a mound of snow that was the length of a body.
Okay.
All right, I'm going to stop you there, Mr. Brennan. I need to see counsel at sidebar for just a minute, please. Regarding.
All right, folks, GrantSmithEllis here. We are at sidebar for a second. However, for some reason, we can see the sidebar, but I'm not supposed to publish that, so we're going to leave that exactly as is. And we are going to wait for the lawyers to come back. They are going to sidebar just now, and Judge Canoni should be directing them to return shortly. What you see, of course, now is John's family, Miss O'Keefe in the center there. My name is GrantSmithEllis. We are getting close to the end of today's session. We're coming
so
back
Ms.
into
Roberts, we're going to have you come back tomorrow.
Okay.
Jurors, we're going to break for today. So
But
we're
not
send
actually
you,
stopping.
The same 3 cautions that I'll tell you every single day. Please do not discuss this case with anyone. Don't do any independent research or investigation in this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. And please be extra careful with your social media. Okay?
All right, now
We'll see you tomorrow
stick
morning.
around, folks. We're going to have a further session here without the jury present. So we're only going to have to watch the fan for a second. Because remember, we're going to do a motion hearing now. So just give it a second while the jury takes some time to file out of the room. I'm sorry we have to watch the fan, but this should be relatively quick. I can imagine Judge Canoni brought things to a halt there because Judge Canoni wants to make sure we get through these motions. So hold tight. Here we go, folks. We should be coming back shortly. Only takes so long for 16 people to walk out of a room. All right, we're back. I don't know if the Karen cam's coming back, but we'll see. Give us the Karen cam. The world wants the Karen cam.
To enforce compliant with the court's April 16th ARCA discovery order and the
All right, here we go.
motion to continue. All right, thank you.
Thank you.
Sorry, Chrissy, I didn't mean to do that.
So it looks like we're going to take a short recess. I didn't catch all of that, and then we're going to come back and hear those 2 motions. I'm not going to make you watch the fan. Give me 1 second. I'm a towel. My name's GrantSmithEllis. We have been going for over 8 hours today, but I am still here with you. I got myself some 7-Eleven pizza. It was delicious. Thank you to everyone who has been so kind to Little Towel. As a reminder, if you have been here and you haven't clicked the subscribe button on Little Towel's YouTube feed, you can do that. You can click the like button on the video. Those apparently help Little Towel out a lot. I don't really understand why or what that does, but you can help Towel out. Towel appreciates you all. Then now, it does say the jury is going home for the day, but we are waiting for the court to come back in session because we have 2 motions to deal with, one of which has to do with the court's discovery order related to ARCA, so that's a big one. If you've been waiting for that, that's going to happen any second now. And, I find even watching that fan, like the corners of it, disorientating. So another benefit of watching Towel stream is I can do things like that for you. And then I can also do things like this for Little Towel. Oh, there's the court officer taking a walk for the day. We are waiting now, of course, for Judge Canon to come back into session so we can do our motion hearing. Towel is going to go and grab your comments quickly. I know a lot of you have been watching all day. Kudos to you for your commitment to the watching this trial, and kudos to you all for staying around. It's wonderful to have so many Towel friends. But yes, I do think Bella's mom, who's someone clearly Karen was thinking about for some strange reason at 6 in the morning as she was going back to Fairview Road. I think Karen Reed knew Bella's mom had been with John many years ago, and when Karen Reed got directions from Jen McCabe the night before over to Fairview Road between 12 and 12:24 when they arrived at the house, Fairview, and then Karen Reed and John O'Keefe sat outside that house from 12:24 until 12:31 in Karen's car. Jen McCabe had also mentioned Bella's mom apparently to torment Karen. Cordy Myers, it's so good to see you. I don't know if you missed my apologies earlier. I'm sorry for pinning your comment for 6 hours. I just like that you used Nostradamus and then I forgot about it. Thank you. I really try to provide as much information as I can. I hope that you all find it helpful. And I see Def Otter said we are only 11 subs away from 500. So if you want to join the Towel subathon, that would be wonderful. We can get Towel to 500 subs so Towel can make his post and say thank you all to the Towel friends on YouTube who make a wonderful Towel universe so tightly knit together with washcloths and soap dispensers and flannels and beach towels and hemp towels and paper towels and towelettes and all the wonderful friends within the Towel fold. The whole testimony analysis I'm going to think about. I think Carrie Roberts is a very authentic witness, very authentic indeed. B and Chance says, after 500, then we'll get to 1,000. Oh, we're up to 492. Towel friends, we are only 8 away. It is a Towel celebration. We are over 8 hours. I make no representations about my ability to not become delirious after streaming for 8 hours and watching this with you all, but I am doing my best. I have kept going. We are still going. You Towel friends have warmed Towel's heart with all of your wonderful camaraderie in the comment section and all your lovely support. I want to send all a special Towel thank you to everyone who has reached out or sent support or liked the stream or subscribed. It does mean a lot to Little Towel, and much like every 90 minutes while watching PBS, this is a public information service, and Towel's public information service can also be found on toweltribune.com, which just launched. But in general, I strive to educate, inform, and entertain you all in that order, in descending order as to priority, and I hope that I have done at least 2 of those 3 things today, and if we hook in a little entertainment with Marshmallow Man or other such nonsense, then I have done my job and fulfilled my vocation as a Little Towel. That said, I do agree Carrie Roberts is very credible. I do think she is also very sad. Kim Courteau, it is great to still have you with us. Welcome to the ranks of honorary towels. It is quite an honor to become an honorary towel. You then join the blue wall. That is just an irresistible force. And then the other people who come into this chat say, wow, I've never seen a YouTube chat like this before. It's just a blue wall. And then they don't engage in disrespectful comments or derogatory comments or discriminatory comments or sea lion. And then everyone's pleased. And we're all just a bunch of happy towels. That said, we are waiting for the court to come back from its recess so we can deal with these final two quite important motions in today's Karen Reed trial. If you missed the beginning of the day, I think the highlight was, unfortunately, Alan Jackson grotesquely referring to cancer in a weaponized form during his opening. We can take a listen to that now, actually. Welcome, Honorary Towel, Kim Corteau. I'm Croteau. I do, if you spell it phonetically, I'll get it eventually. It takes me a while. I'm working on it. Carrie seems annoyed. I would say Carrie seems frustrated that she has to again relay facts that are very upsetting. But that's just a read. I don't know Carrie Roberts. Yeah, I don't really see it that way, Jesse. I see it more as a frustration with actually having to do this again. Wait, what? Oh, so I'm not sure why. Law and Crime ended their stream, but Court TV has not. Or did Court TV end their stream too? I can't imagine they did as well. So I don't think this day's actually over yet. I don't know why were they not listening? Because I think we have to come back and do the motion hearing. I don't think we actually ended for the day. I'm actually positive of it because Judge Canoni said she wanted to do it at the end of the day, and the only reason we would end so early. So I don't know why did they do that? Did they all? I hope they all didn't end their streams, because if Court TV ended theirs, that means the pool feed might have ended. But why would you're going to have to restart it? I mean, clearly you all heard maybe they missed it, but Judge Canoni said very early in the day, we are going to do a motion hearing. Crow-Doe. Well, thank you, Kim. I appreciate you helping me. Pilgrim Shadow, it's great to see you, friend from the Finger Lakes region of New York. Lake Sconatales. But yes, folks, if you're wondering what are we doing here, well, all the other channels, including the pool feed, seem to have decided that they just should have gone home. But from what I understand, we were doing a motion hearing related in particular to ARCA being potentially excluded as witnesses or the defense's failure to comply. And then furthermore, with regards to the motion to continue, Judge Canoni specifically set aside time for that today. And the fact that the Zoom has not ended means that it's going to keep going. So I don't understand. Yes, it is possible, Cookie Ram Law, that Judge Canoni can throw ARCA out, and that's why she didn't allow Jackson to mention them during opening. If you missed that part earlier, I will bring it up for you now. But by the way, I might be one of the only people who is, because the other streams, I'm talking about the national streams, bailed. And I'm wondering if because the Zoom would have just ended if we're done for the day. I'm wondering if those other national streams absolutely didn't realize what's going on, which is that we have a motion hearing to do. So Little Towel is not going anywhere. I'll tell you that right now, friends. I will tell you that right now. I am a Little Towel, and I will stay with you until the end. But what I do want to take a look at is let's take a look at why I think Karen Reed could be in so much trouble here, because she, I think, does indeed run into this issue of potentially having to deal with ARCA being excluded. So give me 1 second here. Where is this thing hiding? Is it hiding right? It's not hiding. Oh, it is hiding. What I need to do is bring the window up. Not that window, that window. So let's take a look at what happened earlier with Judge Canoni and ARCA. That was quite a situation. Let's watch it one more time. Hold on 1 second. I have to unmute the website. There we go. And then let me see if I can make that a little bit wider. All right, let's do it.
Commonwealth's motion regarding defense opening statement. I think the first two motions we can do quickly. I'm not issuing an order. Mr. Brennan, the defense knows third-party culprit will not be in the opening. If you think that their opening goes beyond it, you can object. Defendant's opposition to the Commonwealth's request for use of independent readers, because there's an objection, the defendant's motion's allowed. So you will not have an independent reader. Is it fair to say that the third and fourth motions, Commonwealth motion to enforce compliance with court's April 16th ARCA discovery order and the Commonwealth's motion to preclude new expert testimony or alternatively to continue the trial date, that those motions will take a little bit of time, Mr. Brennan?
I don't think I'll be long in my argument.
I think that I need more information on one of them, and I think we'll do that at the end of the trial. I mean, at the end of today, we'll hear both these motions. Mr. Jackson, I did see that a list of text messages, 100 or so, is in your response to my order on Friday. Did you provide the text messages themselves?
No, Your Honor.
All right. In light of that and the fact that we don't have time, this juror's been waiting for as many as 3 weeks now, I'm going to prohibit you from mentioning ARCA in your opening statement. And then we'll deal with this later today. I ordered those text messages and they weren't delivered. So we're going to be bringing the jury in. I'll be in recess for 5 minutes.
Heard on that, I think the court respectfully may be factually incorrect on a key assumption of what Your Honor is ruling.
5 minutes, Mr. Alessi.
Mr. Jackson couldn't give you the facts. I would like to hear the law back.
That's more than 5 minutes. I'll see you at sidebar. Come up here.
Okay, you see what I mean? Towel was listening closely. There is going to be a motion hearing. I don't know why the pool feed's cut. That's absurd. We're the only one who actually paid attention. Listen, this is absurd. I can't. Oh, sorry, folks. That's the Zoom. Hold on. That's the Zoom. We might be coming back into session soon. But the point is, I can't believe they didn't. You just heard it from Judge Canoni. She said today, and all the other feeds cut. They don't pay attention. Like Little Towel and all the Towel friends. And look at the reward. Now we're the only ones who are actually going to see what could be a very important moment. Disposable towels. Yes, of course, disposable towels can be included. And I just want to say, being chance, this is only initial reports of arrests. I'm trying to confirm them. There's actually 2 incidents going on. One that I reported related to Causeway Street in Boston, which is not related to the Karen Reed and John O'Keefe trial. Those were 4 arrests related to men wielding guns, apparently, although no shots were fired per towel sources. However, the arrest in the buffer zone at the Karen Reed trial, I am only hearing initial information. I have not confirmed the arrests. The initial reports are 1, potentially 2 arrests related to the buffer zone. Someone carrying a flag, someone else yelling free Karen Reed from a truck during in the middle of the buffer zone. As soon as I get confirmation on that, I will give it to you. If you're just tuning in, you just heard the clip play from Judge Canoni, where Judge Canoni said just right now to us, to the Pressy and Towel friends, that we are going to come back for a motion hearing. The court pool feed cut, everything else cut, but Little Towel keeps pressing away. Also, Towel is only 7 subs away. Oh, we might be coming back, folks. Oh, here we go. Wait a sec, folks. As soon as we come back into session, Towel will have it for you. Here we go, folks. We're back into session. We're the only people who have this.
All right. So we'll have a quick hearing on paper now 682 and 680. First, Commonwealth's motion to enforce compliance with the court's April 16, 2025 ARCA discovery order. Mr. Brennan, you said you could be brief on both of these, so I'll hear you.
Your Honor, I'll get right to the point. On the motion for compliance, our position is that the defense did not comply with your order. This has been an ongoing issue which relates directly to the credibility of potential ARCA witnesses. This is information based on the history and representations made in this case that we're entitled to. I did note before these were produced that we have watched video footage from unaired video from the documentary. We clearly knew that there were text messages and correspondence beyond what was represented to the court. It is not a surprise that I did receive these lists of text messages and calls after I made those comments. However, there is no text message content. There is 99 texts to Mr. Wolf, 6 texts to Mr. Rensselaer. That does not reconcile with the past positions and representations of the defense to this court, to the Commonwealth. In addition, there are a number of phone calls. And those phone calls, again, I would suggest do not reconcile with the past representations. We have 52 minutes of phone calls on 5 calls with the ARCA main line, 133 minutes, 20 calls with Dr. Wolf, 57 minutes, 23 calls with Dr. Rentschler. I find it difficult to accept that these are all for scheduling purposes. We also had your Honor's order, not just for the communications, which are not a complete or a fair production, but there was a order by the court to provide all correspondence, text messages, emails, not just with Attorney Jackson, but with the entire team, including the defendant, Karen Reed, and we have received nothing. This is important because if we look at the first half of ARCA's potential testimony, which is limited to their prior report, we cannot fairly and effectively cross-examine the witnesses until we have the information we're entitled, and that's why I've also asked and suggested that ARCA should be ordered and required to provide that evidence as well, so that we can see what is there. It is concerning that there are this many texts, this many phone calls, and the fact that this is totally in contrast to what was represented in the past. So before there's even a thought of ARCA testifying, I think we're entitled to the full discovery that we asked for, the full discovery that the court has ordered. I don't see anything to do with billing or anything else beyond these text message and phone call logs. I want whatever content is available. I think it's relevant material. It's pursuant to your order, and this is woefully incomplete. Should I dive into the second motion?
Yes.
Move quickly. The second motion, part of it is moot in some respects. I won't go through the tortured history of discovery. We've gone through it too many times. We don't have time for it. But inevitably, it is clear that we have played by the rules, met our discovery obligations, and as we stand here now, the defense is proposing new opinions, new testing, and they don't even have the parts of that testing yet. This is 2 weeks into trial after we picked a jury. This is at the time of the opening. It is ambush. It is unfair, and we have no ability at this point to reconcile or deal with new opinions and new information. Importantly, the defense's position is they may or may not have a report by May 1st. Our expert will be testifying somewhere at the beginning or middle of May. He is away. He is not available. And so anything we receive at the beginning of May or end of April, we'll have no opportunity to look at, vet, test, reconcile, or even engage in our own testing. This was my concern all the way back in November. I'm not Nostradamus, but this obviously was something that worried me that actually occurred. And so at this point, it would be fundamentally unfair for the defense to get a benefit for failing to comply with discovery orders by waiting until February to seek permission with ARCA. They could have called any expert, asked any expert they wanted. They didn't. They chose this method, and this is the consequence of it. And at some point, the defense has to bear the burden of their decisions. We will not have the ability to rush through, have Dr. Rentschler come in day before his testimony, try to reconcile, be inadequate. I've had a brief correspondence with him. It's simply impossible. That's why we suggested, although we certainly didn't want to move the trial date, that was the only remedy if the court was going to allow any new opinions, evidence. I say to the court that they should not be allowed to offer absolutely anything new, not only because they missed the discovery deadline, that's technical, but the reality is we're all trial lawyers, we've all tried a lot of cases. It would be a disadvantage, fundamentally unfair, and because of their own choosing. And so anything new we will not be able to reconcile, we would not be able to proceed with our expert in a fair manner. Thank you.
Okay. Mr. Lessie's issue, I'm going to ask you to be as brief as you can be, please.
Your Honor, I understand your request to be as brief as possible, but this is the first opportunity the defense has had to respond to almost every allegation that's been made. We haven't had an opportunity, so I certainly respect the court and what the court's request is, but it is going to take a bit of time to put facts out. And I want to separate two categories that the Commonwealth has conflated. The Commonwealth has conflated the issue of what text messages exist, which text messages don't exist, what's been turned over pursuant to orders, and I would like that to be clear to the court factually, because the Commonwealth has misstated just now 3 times the facts.
So I asked this morning, there were 100 or so texts referenced in the exhibit, whatever was presented by you folks. I asked if Mr. Jackson, if he provided them, because my order was clear they would be provided, and he said no. And I asked you at sidebar whether they were deleted, and you said yes, in due course. I have no idea what that means, Mr. Alessi. Why don't you explain that?
Well, thank you for the opportunity to explain it. Here's what it means. Like anybody's phone, those text messages are 2 years old. They don't exist.
So can you also tell me, aren't the ABA guidelines the council is supposed to keep everything in a case for 5 or 7 years?
I do not believe that is the ABA rule with regard to experts. I'm unaware of that.
With regard to your client, and this was in regard to your client's case, right?
I'm sorry, Your Honor, I didn't hear you.
Records kept regard to your client's case, which these are experts that were, I mean, there's 100 text messages leading up to trial when I was told that by you that there was a pause email, and then all of a sudden out of the blue a bill appeared in July. This shows that's not true, Mr. Alessi.
Your Honor, that was a different question that Your Honor asked me back then. That was about emails. That was not about text messages.
Have emails been provided?
Yes, Your Honor.
Okay.
All emails have been provided. And that is why we are in compliance with all orders. And I will say also with regard to text messages, we have provided pursuant to every order, every single text message that exists. Mr. Brennan just said, I believe there has to be more there. There's not more there, and I don't believe there can be an order of preclusion based upon the speculation of opposing counsel that there must be more. We affirmatively created a document, Your Honor, to be more transparent than the records, where we summarized all of the communications. Yes, we don't have the text of the text messages, but we were completely forthright and set forth every text that was made. Plus, we turned over from Ms. Little, the only other person on the defense team who communicated with ARCA, we turned over her text and the text of her text messages. There is nothing else in existence to provide, and importantly, the defense was under no order to preserve the text of text messages. And we have never received, as part of discovery in this case from the Commonwealth, any communications between the Commonwealth and its several experts. That has not been what has occurred in this case. But of course, once Your Honor on Friday issued that order to provide everything, we provided everything we can that we had. The bottom line is, Your Honor, we've turned over absolutely everything we have, and in addition to that, we created a document so that it would be easier. We're the one who showed all of these text messages from Mr. Jackson historically. We created that document. There's no basis for a discovery violation. There's no basis for an order violation. We are in full compliance. So that's the prong one, Your Honor. Prong one is what Mr. Brennan has alleged is incorrect because we turned over, and we did it recently and consistently. We've turned over all emails and Ms. Little's text we provided. There are no text messages in 2024, and there's no order that required those to be preserved. And there is no discovery violation because we can't be in violation of not turning over something that doesn't exist.
All right, go to the second
Thank you,
motion.
Your Honor.
Motion.
The second part of the motion, Your Honor, is the most maddening for the defense. And this is the timeline that I can go through very, very quickly. And essentially, what the Commonwealth just argued is we will be so prejudiced that if we get the work that ARCA is underway, working on, that we will be prejudiced because we won't have enough time to address it. Your Honor, the facts show that the timeline for this has been caused by the Commonwealth, not the defense. And I can do it quickly. July 2024, the first trial concludes. November 2024, 4 months later, the Commonwealth decides to retain Aperture. Their decision to wait 4 months to retain an expert, we're the defense. We defend what the Commonwealth alleges. January 30th, 2025, 2 months after that, and 6 months after the first trial, we get an Aperture letter report that's barely discernible about what they've done. It's a 1 page and 1/4 of conclusions and opinions in outline form. Next, January 31, 2025, we get the initial Aperture 140 slide presentation. January 31st, February 5th, we get the case file. In February 19th, we finally get the raw images from Aperture and the scans. That's the first time we get raw images and scans. You can't have an expert work on anything until you even get those raw images and scans. We move, and we have a hearing on March 20, 2025, to preclude Dr. Welcher because the slides are so incoherent and the report is so insubstantial. We can't tell what it is their theory is. So then on March 24th, and at that hearing, the Commonwealth agrees to redact and revise that. So we're already into March 20th, the Commonwealth agrees to redact and revise. Your Honor put the defense on a short leash. We accepted it, and by March 24, we received the PowerPoint that was of the Aperture that was supposed to be, have 2 things happen. It was supposed to be redacted, and there were certain things that were supposed to be changed. What did we get on March 24th? It wasn't redacted, and there were 3 substantive changes to it. The Commonwealth has said twice, including today, there were no substantive changes. There's 3 of them, and to the extent Your Honor wants to hear, I can detail exactly what those changes.
So why don't you highlight them very quickly, because I need to say something.
I can do it quickly. Thank you for the opportunity. First one, slide 36, they changed the image of 34 Fairview. No small change. 102, they changed the conclusion regarding the time that the taillight was broken. No small change. 123, they changed the image of 34 Fairview. No small change. So we ended up getting those changes, and I want to be clear on the date. That's March 24th. We have a hearing on March 25th. We agreed to provide our response to these revised Aperture documents. Here is the key data point. On March 26th, the defense engages ARCA. Just 2 days after we get the revised PowerPoint with 3 substantive changes. And then we started to respond and provide more information. On March 27th, we responded to the Commonwealth's revised PowerPoint and the Welch report, and then the last 2 items, we renewed our request to preclude Dr. Welcher on Dalbert Lanigan grounds. April 1st, and this is another key date, the court decision allowed Dr. Welcher to testify, but also allowed the defense to re-raise objections at trial when Dr. Welcher testified. What does that timeline show? That timeline shows that the Commonwealth took 6 months from the last trial, 6 months, and the defense took merely 2 days after they got the final report of Aperture to retain ARCA. Last point I want to make, Your Honor, is the argument of the Commonwealth that we strategically waited to retain ARCA. Nothing could be further from the truth. As the court knows, and has been the case with this unorthodox situation, ARCA was retained by the U.S. government. They worked pursuant to the U.S. government, and we had to get the permission of the U.S. government to retain ARCA. We moved expeditiously to do that. We got the permission from the government, and as soon as we got the permission from the government, and as soon as we got the final version of Aperture documents, including scans, we put ARCA on it. It has only been since March 24th, not even a month, have we had finally the information from Aperture, which is still inadequate. Our experts still say, with regard to what Aperture did, in some instances, they can't even figure it out because the information is so inadequate. Nonetheless, because of all the considerations we're aware of, we had ARCA proceed forthwith with post-haste. And they are working post-haste, but, Your Honor, we are the defense. That's where I started. We had to understand as best we could what Aperture did. In conclusion, 2 points. No violation whatsoever on text messages, emails, court orders. All complete, robust compliance. And with regard to the allegation that there was something said, that there's some surprise that there were so many text messages, on June 10th, 2024, and I've got the transcript albeit on an electronic device, right in front of me, I just got to get the passcode. Mr. Jackson read a text message right live that he had with ARCA. He read it, and here's what it said. The court, okay. Mr. Lally, so her issue is that she is available this week, but not next week, so I really need to get her in on Friday. Mr. Jackson.
Hold on. The court reporter can't hear you. She asked you to stop.
Oh, I'm sorry. My apologies. Am I going too fast? Yes. Thank you. All right.
Go ahead.
Thank you. My apologies. So, Mr. Lally, so her issue is that she is available this week, but not next week, so I really need to get her in on Friday. Mr. Jackson. Dr. Wolf just texted me and said, I presumed you were in court. Give me a call when you're available. The court reporter, I'm getting an interference. Mr. Jackson, I'm so sorry. The court reporter, that's okay. We have been completely transparent that there were text messages, as opposed to emails, text messages about scheduling, about other administrative matters. Mr. Brennan is completely free on cross-examination of ARCA to address every one of his speculations, every one of his suspicions, every one of the ghosts that have been created on this topic. He can address them. If he thinks that we're wrong, we're misstating, he's got the opportunity to speak to ARCA and ask those questions. Your Honor, it is improvident to, based upon speculation, preclude the defense.
I'm not making a conclusion today regarding precluding the defense.
Okay, all right.
All right, so I need you to wrap it up because there's something I want to say.
Certainly, Your Honor, I'm going to wrap it up in 10 seconds. There are no violations of any discovery order, no violations of this court's order, and with regard to the retaining of ARCA, because we're the defense, we acted expeditiously in response to the information we're getting, and this can be tested with ARCA, the statement I'm going to make. To this date, ARCA still has trouble understanding what it is that Aperture did and didn't do, which was the reason for my Daubert-Lanigan motion, but we proceeded nonetheless. Happy to entertain responses to any questions.
All right, no, thank you. All right, so as you all know, I previously wanted you to have a seat, Mr. Alessi.
Thank you, Your Honor.
I previously found, and I believe Mr. Alessi, when he was talking about the rules of professional conduct, did say, I agree, a violation of Rule 14, but not regarding the rules of conduct. At a prior hearing, I found a violation of the defense's reciprocal discovery obligations. It was clear to me, and I found that it was deliberate. This appears to me, contrary to what you've argued, Mr. Alessi, that this is another violation of my order and of the reciprocal discovery violations. We need to figure all of this out before you're allowed to call these witnesses. So I'm going to have a voir dire hearing this Friday. I know we planned on having the view. I need the ARCA witnesses here Friday morning. So we need a voir dire, if you intend to call them, a voir dire on all of this. And I will be sending an order for production of records. I just need to amend it for ARCA to bring all these items with them. So Friday will be for ARCA for a voir dire hearing in the morning. So we'll see you tomorrow for trial, Friday morning for this.
May I inquire briefly for scheduling purposes?
Yes.
In light of the hearing on Friday, will it still be half a day, or are we expected to call witnesses on Friday?
No, it will be, if we could do, Mr. Alessi, how long do you think this voir dire might take?
I don't have an answer for you, Your Honor, right now, because I've got to talk to ARCA and I've got to understand what they have and what they don't have. So I think it could take some time.
All right. So no witnesses for Friday, and I think we'll give the jury the day.
And will it be a full day on Thursday?
Yes.
Thank you very much.
Yes. All right. So we'll see you then. I will issue an order hopefully before the close of business today. Jimmy, can you stay and get this out today?
Sure.
Okay. All right. Thank you.
All right.
Folks, did you hear what just happened? I don't know if you heard it. I heard it. My name is GrantSmithEllis. ARCA has been ordered to appear on Friday. That is just a few days from now, in order to come before the Karen Reed trial, not before the jury, but for the Karen Reed trial for a full voir dire. Judge Canoni has found another violation of reciprocal discovery rules. It was intentional, Judge Canoni just said, unlike what Bob Alessi asserted. And Judge Canoni has found that now on multiple occasions, Karen Reed's team has tried to withhold communications related to payments or communications or otherwise documents related to those communications or payments between Karen Reed's team and ARCA. That's huge. Never seen anything like it unfold in real time, folks. You just saw it unfold. Other networks apparently abandoned the coverage, but you saw it here on youtube.com/@GrantSmithEllis, and I'm so thrilled that all you towel friends got to see that. The implications are shocking and stunning and momentous, and I am going to finish this clip and write this up now. Folks, Thursday will be a full day now in the Karen Reed trial with witnesses. No trial witnesses on Friday. A full day of voir dire for ARCA. Just a stunning development. Just stunning. Stay with me. My name is GrantSmithEllis. Okay, so I'm going to upload that in real time now, and then we can talk about that. That was an absolutely momentous development, folks, and we are going to talk about it together as Towel writes this up, because that is what towels do. Breaking news. There will be a full day voir dire of Karen Reed trial experts from ARCA on Friday, which is, hold on, I'm pulling on my calendar, April 25, 2025, related to what Judge Canoni has just found was another violation of discovery obligations and court orders by Reed's defense. Karen Reed trial defense experts. There will be a full day voir dire of Karen Reed trial defense experts from ARCA on Friday, April 25th, 2025, related to what Judge Canoni has just found was another violation, another blatant, a court order compelling ARCA to bring with them all such documents, including any further communications, payments, or otherwise related to Reed's defense team ahead of Friday's hearing. This voir dire was not initially supposed to happen until mid-trial, right before ARCA testified during Reed's case, during Reed's defense presentation of evidence. However, this morning, before opening arguments began, just minutes before opening arguments began in Reed's retrial as to the death of John O'Keefe, Judge Canoni banned Reed's team, Alan Jackson, from mentioning ARCA in his opening due to Reed's defense turning over a list of 100 text messages without their content to prosecutor Hank Brennan over the weekend, in violation of Judge Canoni's order from last week requiring the content of those messages to be turned over. It may well be that Karen Reed is heading towards a calamitous reckoning, and the loss of ARCA from her already meager and humiliating witness list on Friday, as a result of Friday's hearing. Earlier, Reed's lawyer, Bob Alessi, was screaming at Judge Canoni during a motion hearing after the first day of opening arguments and evidence in Reed's retrial. It did not go well for Alessi, and the shocking Friday voir dire stunned Reed's defense team into silence as court ended for the day around 4:20 p.m. Eastern Time. Oh, that was hard to write up. Well, towel friends, I'm sorry that you couldn't hear probably all of that because I wasn't as great as I wasn't talking as directly into the mic as I wanted to, but I wrote the whole thing up. I wrote that ridiculous situation up that just occurred. That was one of the most ridiculous things I've ever seen in my entire life. I cannot believe that just happened. I am thrilled that Judge Canoni issued her ruling in the way that she did. And now I, as a towel, will somewhat try to summarize my thoughts. I have not been reading chat because, as you know, I cannot simultaneously write up what just happened in real time and read your chat. However, that was a major development, folks, and you just saw it happen in real time, and then you got to hear Little Towel overview it to overview it for you in real time as well. So what a special treat. And yes, I will return to your chat because we apparently on this Little Towel stream were one of the only people to actually stay and cover that part of the hearing. I don't know why the pool feed dropped. If you were any sort of prescient or listening or paying attention, you knew that a motion hearing was coming. So I'm not really sure why the pool feed dropped. I'm thrilled that we stayed around to cover that. And let me just make sure this is the video that I want.
As you all know,
Okay, that's the video I want. So Towel has written up his article. All I'm waiting for now is this video to upload. You all are seeing in real time, by the way, just how much it takes to process all of this information, to get the clips to write them up. You actually just saw it. So a lot of people are like, Grant, how do you write that up? Well, I sit there and exactly what I would say to you out loud, I just type in real time, and I can type as fast as I think. So if I'm just writing what I'm thinking, it's the same as me explaining it to you. But when I type it out, it's for a wider audience, which I think is important, because as much as I love to explicate these important developments for you towel friends, really there needs to be some kind of record of this beyond this niche YouTube stream, and the best way to do that is for me to write it up. So please, I beg your indulgence, and thank you and your patience for me being able to have done that. Oh, now that I can take a breath, I want to take a look, by the way, at where we are in our towel subscribers. I'm so thrilled, by the way, that so many of you have been taking part in our towel quest towards 500 subscribers. I'm grateful, and I'm honored to have your support. We are certainly heading in that direction, and I would say we are going to get very close to that sooner rather than later. So thank you to everyone. Whether you've considered subscribing or you've gone through with subscribing, it means a lot to Little Towel, so thank you for that. And as I mentioned, I just took a little bit of time to get that post out, so thank you very much for your indulgence. I'm coming back to your comments. So I saw a comment saying, Grant, you're the towel of all towels. No, you all are the towels of all towels. The towel universe is defined by its constituent parts. It's not defined by any one entity or element, even Towel himself. I'm just a towel. So all of you truly are what define the Towel universe, and Towel just comes along for the ride and is honored to stitch together this wonderful group of various Towel friends. It means so much to Towel. Truly, it's not just all of your support of my efforts and what I'm doing, but it's your engaged, informed participation in our larger democratic process, which of course has three constituent parts, one of which is the judicial branch. And so we're at 498 subscribers. If we get just 2 more subscribers, we will have reached 500, and Little Towel will do some kind of towel celebration, which will involve me drinking some water and smoking my cigar, I suppose. Oh, Towel friends, I think we broke our record again for a live stream. I don't know how. We're definitely past our record because we're at 8 hours and 59 minutes. And if the rumors are true and there really is a 9-hour limit and I get cut off on YouTube, I just want to say thank you all to the Towel friends. I'm going to come back and try to read your comments. Hopefully I don't get cut off in 30 seconds. But yes, thank you to Dewdrops and Amber Am and Eve. Eva said, I don't know how you type so fast with no mistakes. I don't know. I suppose it's just a gift. I think I had 5 or 7 corrections in that post after I went and reviewed it. We are absorbent towels. That's true. I'm going to send Grant up with a decent voice to text. Oh, you're very kind, Murder by Maestro, but I think I can keep persevering. All right, we're about to find out if there's a limit on YouTube. Nope. Okay. I was able to keep going. So at least for now, it turns out we have just broken a towel record. We are 9 hours in. I'm going to go back and read some of your comments. Yeah, so normally a voir dire would just be about the scope of their testimony. This is a different kind of voir dire. On Friday, if you're just catching the news, Karen Reed's experts from ARCA are going to be subject to a expedited voir dire that was not supposed to happen. Okay, it was not supposed to happen this quickly. It's going to be on Friday, and it's not about the scope of their testimony. It's about what's called Rule 14 reciprocal discovery violations. That has a much more serious penalty for Karen Reed, because a normal voir dire is about competency of the expert, which is a Daubert Lonergan hearing. This is not what's about to happen. What's about to happen is a voir dire hearing specifically for the purposes of determining whether ARCA themselves have text messages or communications or otherwise, or payment records from Karen Reed's defense that would indicate a material violation of another material violation or misrepresentation by Reed's defense related to those discovery violations. And if that happens, then ARCA can be excluded on the basis of the Rule 14 violations, regardless as to the scope or content of their testimony. That's why Karen Reed's having an absolute conniption, and her Bob Alessi was screaming at Judge Canoni. I've never seen anything like it in my entire life. I don't know if the media, yeah, exactly, Angela Wittick. I don't know if the media cut off and didn't want to post that because it was bad for the defense. I don't know if you all saw Bob Alessi screaming at Judge Canoni. I have never seen anything like that in my entire life. That was just absolutely astounding. yeah, I don't even know how to respond to the fact that the media, even though if you were prescient, even on this towel stream, I was saying, okay, folks, we're ending early because Judge Canoni is going to have us come back for a voir dire related to ARCA, and then we're going to talk about these two outstanding motions. By the way, the other major implication of what just went down with ARCA is that there's going to be an order that's going to come out, and I will try to stay with you for as long as I can. There's going to be an order that's going to come out from Judge Canoni, I imagine right now, and what is that order going to do? It compels ARCA themselves to bring evidence and documents to on Friday. I don't know if I'm trying to put in context for you all how big of a deal that is. I think I'm more just pleased YouTube allows the stream to go over 9 hours, but this is an absolutely, I'm trying not to reach Bob Alessi's level of hysterics, but this is an absolutely momentous situation. It is absolutely shocking that Bob Alessi did that and was screaming at Judge Canoni. And it's even more shocking that Judge Canoni ordered the Friday voir dire. This, as I mentioned, this voir dire was supposed to be on this voir dire was supposed to be on in the middle of trial, not right now. So I have to upload, and maybe you towel friends can watch me do this too. I have to upload this video of Bob Alessi just screaming at Judge Canoni, because I don't really know how else I don't know how to describe this. This was one of the most ridiculous things I've ever seen. So I'm going to take I think I have to take my prior post about when Hank Brennan made his argument, and then what I'll do is I'll repost this. And the post I'm going to make now is about Bob Alessi, and I'm going to say, so here is the full Bob Alessi ARCA meltdown from Tuesday's Karen Reed and John O'Keefe retrial motion hearing after jurors went home and the court pool feed cut for some reason. Bob Alessi got scolded by Judge Canoni. Then Alessi started yelling at Judge Canoni, saying the defense had no obligation to disclose or retain their text between ARCA and Reed's team. Judge Canoni was not pleased. Judge Canoni noted Reed's lawyers had an obligation to retain those documents for 5 to 7 years, even if judges' orders for more discovery didn't come down until last Friday. Judge Canoni, in shocking moments, then responded to Alessi's screaming fit by issuing an order for a Friday voir dire with ARCA and announcing Judge Canoni will be issuing a written order of production to ARCA themselves for records and payments related, records, communications, and payments related to their relationship, related to ARCA's relationship with the defense. Absolute scenes, towel friends. Absolute scenes. That's a British word, by the way. When you say absolute scenes, those were absolute fucking scenes. I have never, ever, ever seen anything like that in my entire life. Just absolute fucking scenes. I don't even know how to process this. What do I do? How do I interpret what I just saw, other than Bob Alessi having an absolute meltdown on national television? It wasn't even national television. It was national television, because I was one of the only people who knew what was going on and stayed on the stream. Oh my goodness. Oh my dear God. I just cannot process what just happened. I mean, I'm processing it as I'm writing this up, but I think scenes, absolute scenes, is the best way to sum up, even me, who's seen a lot of crazy stuff in this trial. That was one of the most ridiculous things I've ever seen in my entire life. And now, if you're wondering, I'm going to actually post Alessi's full argument with Judge Canoni, because I have never seen anyone in my life scream at a judge like that. And she told him to be quick. Bob Alessi went for 15 minutes. That's Bob Alessi's version of quick, I suppose. By the way, I'm so thrilled that YouTube allows us to go over 9 hours. I had no idea this was even a thing. Apparently, I can now break all sorts of towel records. We can do 9-hour streams, 10-hour streams. I think at a certain point, there's just going to be a stream of me just talking all the time, and all the different time zones of the world will get up and go to bed, and people can be like, oh, Grant's just still talking. He's still going. I don't understand how this happened. Well, I can tell you how it happened, actually. I don't know how many milligrams of caffeine this thing has, but today I had a Recon 1 energy drink, which has 200 milligrams of caffeine. And I'm sure there are, well, maybe there's not other. 1 gram of L-carnitine, 1 gram of taurine, and vitamins B6, B12, and B5. I'm sure some of those things are very unhealthy. I'm sure some of those things are making towel able to cover this for 9 hours. Needless to say, when we get to the point of 11 and 12-hour streams, I think we're going to have to clone towel, because I don't think a single human can just talk all the time, 24 hours a day, even if this trial is very interesting. You can do 24 hours. Yes, Cory Booker just broke the record for the longest speech on the Senate floor the other day at over, 25 hours or something. So if Cory Booker can do it, by God, towel can do it too. Let me keep reading some of your comments, though, even as I get this absurd video of Bob Alessi being absurd up on the internet. I don't even really know how to process the fact that Bob Alessi was that absurd. That was a level of ridiculousness that I think is even up there for towel. Free Bob Alessi and Karen Reed. Joel says, I think you can go 12 hours one day. Well, yes, and we've talked about this before. If you're new to the Towel stream, please subscribe. By the way, I hope we didn't hit 500 subscribers without Towel paying attention, because I owe you all some kind of celebration, as I promised. We're at 505. We did it. Thank you, Towel friends. Congratulations. Well, I guess I'm saying congratulations to all of us, but we have done it. We have reached 505 Towel friends. God bless you all. Welcome to the new Towel friends. Welcome to the old Towel friends. If you're new here, you can pick what kind of towel you want to be. We have washcloths in the fold. We have paper towels. We have beach towels. We have towelettes. We have flannels. We have soap dispensers, although I'm not really sure how a soap dispenser can be a towel, but we've decided that the towel universe encompasses many fabrics. And so if you can somehow justify yourself being a towel in some way, shape, or form, you are welcome into this welcoming universe. Murder by Maestro says, women are really pushing boundaries and they go into space. That's true. Actually, Murder by Maestro, I think the first woman to ever go into space was the teacher on the Challenger flight in 1986. I forget her name, but she was very inspirational. I mean, it was an unfortunate situation, but the female astronauts have been around for a long time in NASA, and I don't think we are the first and only country to send women to space by any means. I think Jeff Bezos was a little bit jealous of Elon Musk, but I don't think we should really have private space races going on. I think we should really have the government using the space race as a way to protect the national interest. But that's neither here nor there. I'm glad more women are going into space. I think we should send women into space, men into space. We should be populating space, but it should be in the protection of American national interest. We do have a special place here for microfibers. If you are a microfiber cloth, that makes you even more useful. It was a Russian lady in 1961 who was the first person to go into space. If we could get that was it a cosmonaut? Was it a cosmonette? Was their special name? It was a female cosmonaut, a comrade, as they used to call them, I'm sure, back in the Soviet days, who was the first woman sent into space in 1961. Very interesting. I'm new here. Your reaction to Judge Canoni was hysterical. I don't know exactly what I was saying at the time. I think if you just have joined the Towel fold, you will find I have a propensity or a proclivity to just start yelling things sometimes if I get into a mood. Oftentimes, they're very insightful and useful pieces of information that align with my Reithian values from the British Broadcasting Corporation, which I try to honor with this public information service, which are to educate, inform, and entertain the public in that order, ideally. So if it was hilarious, then that is a hook that facilitates your cogent engagement with the public sphere by way of listening to the parts of this program that educate and inform you, then I have done my job. There was also a woman on, what? Okay, Murder by Maestro. That's wonderful. I don't know. I have never looked into that. Macy says, Linda A., Grant is the best. Welcome to the towel fold. Yes, welcome indeed. Let me, for those of you who missed it, I am just getting this clip up of Bob Alessi being ridiculous, and then we'll take 1 minute. We are celebrating, by the way, because we hit 500 subscribers. Oh, I got to get rid of this pin because that was about Bob Alessi. Okay, so I'm going to put up a poll here. This will, as we continue to reflect on today. How do I even summarize this? What is your reaction to the shock ending? What is your reaction to the shock ending of day one of the Karen Reed and John O'Keefe retrial? Option 1, ARCA is F-U-C-K-E-D. Karen Reed is F-U-C-K-E-D. Okay, now we need to add an option. Bob Alessi screams like a banshee. Alan Jackson is a marshmallow man. Okay, enjoy that poll, friends. I'm very interested to see what your thoughts are. The choices are ARCA is fucked, Karen Reed is fucked, Bob Alessi screams like a banshee, and Alan Jackson is a marshmallow man. That's one of the funniest things I've ever seen in my entire life. So now it comes to a question of who is more fucked, Karen Reed or ARCA. I don't know who allowed me to stream for 9 hours and 12 minutes, but this is the funniest thing that I have ever seen in my entire life. I think the general consensus is that Karen Reed's defense is in a very bad shape. So I'm about to get this video up, by the way, of Bob Alessi screaming, and then we'll take a look at some of the quick, ridiculous moments from today. I'll read some of your comments. If you're just getting caught up, if you didn't watch what was by far and away the most ridiculous first day of a criminal trial or retrial that anyone, I think, has ever seen, it ended with Bob Alessi, Karen Reed's lawyer, screaming at Judge Canoni, and then Judge Canoni dropping the hammer by ordering Karen Reed's lawyers and her experts from ARCA into court on Friday, sending the jury home on Friday, and ordering an expedited voir dire due to Reed's failure to comply with Rule 14. And my friends, I don't think anyone has ever seen anything like that in a million years. I have never seen anything like it. And what I want to do for you now is play for you some of the moments that went down today. So allow me to bring that up for you now, because I think as much as towel ranting and reading your comments is hilarious, we actually should watch some of the material that occurred, because that, even if you caught some of the day, I don't think everyone watched for 8 hours. So first of all, to start off, there were only about 25 Karen Reed fans in attendance today, if you missed it. There were not a lot of people there. I heard reports of arrests. I have not been able to confirm that. I am looking more into it with the arrests within the buffer zone. This was the arrival of the O'Keefe family, if you missed that earlier. John O'Keefe's family and friends and supporters. Now, this was the moment at the very, by the way, just so folks know, I don't understand how the conventional media and the pool feed can say they didn't know that Zoom hearing was going to happen, that only towel broadcast, when this happened at the very beginning of the day. Reed, right out of the gate
Commonwealth's motion regarding defense opening statement. I think the first two motions we can do quickly. I'm not issuing an order. Mr. Brennan, the defense knows third-party culprit will not be in the opening. If you think that their opening goes beyond it, you can object. Defendant's opposition to the Commonwealth's request for use of independent readers, because there's an objection, the defendant's motion's allowed, so you will not have an independent reader. Is it fair to say that the third and fourth motions, Commonwealth motion to enforce compliance with court's April 16th ACCA discovery order and the Commonwealth's motion to preclude new expert testimony or alternatively to continue the trial date, that those motions will take a little bit of time, Mr. Brennan?
I don't think I'll be long in my argument.
I think that I need more information on one of them, and I think we'll do that at the end of the trial. I mean, at the end of today, we'll hear both these motions. Mr. Jackson, I did see that a list of text messages, 100 or so, is in your response to my order on Friday. Did you provide the text messages themselves?
No, Your Honor.
All right. In light of that and the fact that we don't have time, this juror's been waiting for some as many as 3 weeks now, I'm going to prohibit you from mentioning ACCA in your opening statement. And then we'll deal with this later today. I ordered those text messages and they weren't delivered. So we're going to be bringing the jury in. I'll be in recess for 5 minutes.
Heard on that, I think the court respectfully may be factually incorrect on a key assumption of what Your Honor is ruling.
5 minutes, Mr. Alessi.
Mr. Jackson couldn't give the facts. I would like to hear the law back.
That's more than 5 minutes. I'll see you at sidebar. Come up here.
Okay, so that was how the day started, and already Bob Alessi set himself up to really upset Judge Canoni. It just got worse. So Hank Brennan did wonderful during his opening, but it just got worse during the day. First of all, look at what Alan Jackson said during his opening. All right, he really disturbed Little Towel. Oh, I guess I made some more posts that need to load up. Give it a second here, folks. Look what Alan Jackson said during his opening. Do I have the clip of it here? It was not that. It was this. This was just disturbing. When Alan Jackson started talking about cancer during his opening, I became an incredulous Little Towel.
You'll see from the evidence in this case that this case carries a malignancy, one that is spread through the investigation, it's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. His name is...
It's sick. It's sickening. It just makes me
You'll see
sick.
from the evidence in this case that this case carries a malignancy, one that is spread through the investigation, it's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. His name is...
That is just the most disturbing thing, and I'm not going to go on another towel rant about how profane that is, but just recognize that tactic, although Alan Jackson may have been trying to reference Watergate and John Dean's invocation of the plumbers being a malignant cancer on the presidency of Richard Nixon, that failed so poorly. I cannot tell you how poorly that made Alan Jackson look. It made him look like an absolute idiot. Nobody's going to understand that reference to 1972. People are just going to think Alan Jackson is a fucking asshole for bringing up cancer and making people, like, insulting people based on it. That is how he's going to look. Nobody knows what Watergate is. It's 2025, Alan fucking Jackson, Alan Marshmallow Man fucking Jackson. What the fuck do you think you're doing? All you did was offend a bunch of fucking people, including me. Like, forget, like, the tactical pitfalls of doing that. You just fucking offend people. No one is going to say, oh yes, Mr. Jackson, brilliant reference to John Dean's Oval Office discussions with Richard Nixon. Are you fucking out of your mind? All people are going to hear when you say that shit about cancer is Alan Jackson used cancer as a fucking insult. That is all. Sorry. First of all, someone mentioned that I should stop cursing. I have done extensive research on the Bible about this, and it turns out that the passage in the Bible about cursing, not various papal interpretations or bulls, but the passage in the Bible about that part of cursing has to do with if you're malevolently invoking God's name or using a curse word. I am being benevolent in that I am calling out Alan Jackson for using cancer as an insult during his opening arguments in a criminal trial for murder, for a murder defendant on national television. There is just no way in my... I offend people. Thank you for those who align with Towell's interpretation of the benevolent deployment of curse words. And by the way, I will do my best. I try not to become incredulous, but that cancer is something that whether you have been impacted by it personally, whether it has touched your family member, whether it has somehow impacted your extended network, there is not a person in this world, I believe, who has not in some way, shape, or form been impacted by cancer. So, in that way, I have to say in some sense that people have to be able to decompress about that. Okay, if you bring up cancer in a criminal trial as an insult, even though Little Towel understands Alan Jackson was referencing John Dean calling the plumbers a malignancy on Richard Nixon's presidency, okay, I understand that was the reference. No one else is going to understand that. Absolutely not. People are going to think that Alan Jackson was just talking about cancer gratuitously as an insult. Yes, those of you who are asking or saying hello or saying I'm going to be tired, I realize I'm going to take some rest. Don't worry. We are getting to the end here. We're just going to watch a few more reviews of what happened. One thing that I do want to watch is this aired exclusive footage from the documentary of Karen Reed that has never been aired before. It was turned over in Discovery to Hank Brennan by the producers of the HBO Max Investigation Discovery documentary. This has never been seen before. This was unaired. Brennan referenced it as unaired. Oh, by the way, I don't remember who was the wonderful person who made the comment about Nostradamus. Hank Brennan called himself, he was like, I'm not Nostradamus later in the hearing. It blew my mind when he said that. But let's take a look at this unaired exclusive footage of Karen Reed from the new documentary.
All right, Ms. Roberts, please. Okay, thank you.
We'd like to play this first and then call Ms. Roberts.
I'm sorry.
Thank you, Your Honor.
Oh, special good night to 5MEO DMT, who was here from the very beginning. I salute you, 5MEO DMT. God bless. Do enjoy your rest. Thank you so much for being with Little Towel and all the Towel friends. I hope to see you come back for more streams. We'll be here every day.
I remember it, but I question, do I remember it because it's been relived so much? I mean, when I see the video of me driving from the waterfall, like what I just described, tapping the brakes when I crossed the intersection, Washington over Sherman Street, do I actually remember that I kind of slowly proceeded through that green light? No, I don't actually.
She's talking about driving at between 5:08 and 5:23 a.m. towards Fairview Road right there. She's admitting that was her in the video.
Remember that, but I've seen the video so many times that you then question, did I remember it on my own, or was my memory jogged? But I also wondered, did I say, could I have hit him? Or was it told to me that I said I hit him, and I knew I never could have said that, so the closest I must have said was, did I hit him? I know I said I hit him, but did I really say it as many times as law enforcement's claiming I said it?
Wait a minute. What did she just say?
Or was it told to me that I said I hit him, and I knew I never jogged, but I also wondered, did I say, could I have hit him? You then questioned, did I remember it on my own, or was my memory jogged? But I also wondered, did I say, could I have hit him? Or was it told to me that I said I hit him, and I knew I never could have said that, so the closest I must have said was, did I hit him? I know I said I hit him, but did I really say it as many times as
She said, I know I said I hit him.
law enforcement's claiming?
Oh my God. Okay, SCG, thank you so much for that helpful recommendation. I have to stop before 12 hours. Good to know. That was one of the best moments of the day. Yeah, my word. Karen Reed confirmed that she said she hit John O'Keefe. Aiden just reported the judge. Yeah, no, I know murder by Astro. Trust me, I was a little bit ahead of that. Oh, Samantha Barbosa, you are going to meet a wall of towel friends. You aren't going to last very long. No derogatory, discriminatory comments or sea lioning. You have to deal with like 70 towel friends. I don't imagine you will be around very long. Yes, that drop by Hank Brennan was huge. Yes, indeed, Macy, it was perfectly dropped. And Hank Brennan said he's going to play these clips, which are unaired and have never been seen before, throughout the trial. Well, Mo, on the whole, I mean, generally people can curse as long as they're not being like malevolent. And that guy was definitely being malevolent, or that person who I don't think they're going to be around very long. They're gone now. But needless to say, I just don't like people who are malevolent in their use of that language, because I think that it's anti-cordial. But yes, that footage from Hank Brennan, my word, Karen Reed admitted to saying she hit John O'Keefe, and she laughed as she was saying it. I know I hit him. That was grotesque, just grotesque. But then we're not going to watch this whole clip, but let's take a look at how the day basically crescendoed, which was Hank Brennan making his argument for why Karen Reed had violated the discovery. Now, folks, this order is about to come down. I'm going to stay with you until I get the order from Judge Canoni for ARCA on Friday. But let's listen to Hank Brennan's argument for why we have to even come into court on Friday. And Hank Brennan won this argument, hands down.
All right. So we'll have a quick hearing on paper now 682 and 680. First, Commonwealth's motion to enforce compliance with the court's April 16th, 2025 ARCA discovery order. Mr. Brennan, you said you could be brief on both of these, so I'll hear you.
Your Honor, I'll get right to the point. On the motion for compliance, our position is the defense did not comply with your order. This has been an ongoing issue which relates directly to the credibility of potential ARCA witnesses. This is information based on the history and representations made in this case that we're entitled to. I did note before these were produced that we have watched video footage from unaired video from the documentary. We clearly knew that there were text messages and correspondence beyond what was represented in court. It is not a surprise that I did receive these lists of text messages and calls after I made those comments. However, there is no text message content. There is 99 texts to Mr. Wolf, 6 texts to Mr. Renschler.
Do you all hear what Hank Brennan just said? He said that he got unaired footage, and that's what helped him confirm that there were more contacts, and then Reed's defense turned them over. Wow.
Does not reconcile with the past positions and representations of the defense to this court, to the Commonwealth. In addition, there are a number of phone calls. And those phone calls, again, I would suggest do not reconcile with the past representations. We have 52 minutes of phone calls on 5 calls with the ARCA main line, 133 minutes, 20 calls with Dr. Wolf, 57 minutes, 23 calls with Dr. Renschler. I find it difficult to accept that these were all for scheduling purposes. We also had your Honor's order, not just for the communications, which are not a complete or a fair production, but there was a order by the court to provide all correspondence, text messages, emails, not just with Attorney Jackson, but with the entire team, including the defendant, Karen Reed, and we have received nothing. This is important because if we look at the first half of ARCA's potential testimony, which is limited to their prior report, we cannot fairly and effectively cross-examine the witnesses until we have the information we're entitled, and that's why I've also asked and suggested that ARCA should be ordered and required to provide that evidence as well, so that we can see what is there. It is concerning that there are this many texts, this many phone calls, and the fact that this is totally in contrast to what was represented in the past. So before there's even a thought of Arthur testifying. I think we're entitled to the full discovery that we asked for, the full discovery that the court has ordered. I don't see anything to do with billing or anything else beyond these text message and phone call logs. I want whatever content is available. I think it's relevant material. It's pursuant to your order, and this is woefully incomplete. Should I dive into the second motion?
Yes.
Move quickly. The second motion, part of it is moot in some respects. I won't go through the tortured history of discovery. We've gone through it too many times. We don't have time for it. But inevitably, it is clear that we have played by the rules, met our discovery obligations, and as we stand here now, the defense is proposing new opinions, new testing, and they don't even have the parts of that testing yet. This is 2 weeks into trial after we picked a jury. This is at the time of the opening. It is ambush. It is unfair, and we have no ability at this point to reconcile or deal with new opinions and new information. Importantly, the defense's position is they may or may not have a report by May 1st. Our expert will be testifying somewhere at the beginning or middle of May. He is away. He is not available. And so anything we receive at the beginning of May or end of April, we'll have no opportunity to look at, vet, test, reconcile, or even engage in our own testing. This was my concern all the way back in November. I'm not Nostradamus, but this obviously was something that worried me that actually occurred. And so at this point, it would be fundamentally unfair for the defense to get a benefit for failing to comply with discovery orders by waiting until February to seek permission with ARCA. They could have called any expert, asked any expert they wanted. They didn't. They chose this method, and this is the consequence of it. And at some point, the defense has to bear the burden of their decisions. We will not have the ability to rush through, have Dr. Trentler come in days before his testimony, try to reconcile, be inadequate. I've had a brief correspondence with him. It's simply impossible. That's why we suggested, although we certainly didn't want to move the trial date, that was the only remedy if the court was going to allow any new opinions, evidence. I say to the court that they should not be allowed to offer absolutely anything new, not only because they missed the discovery deadline, that's technical, but the reality is we're all trial lawyers, we've all tried a lot of cases. It would be a disadvantage, fundamentally unfair, and because of their own choosing. And so anything new we will not be able to reconcile, we would not be able to proceed with our expert in a fair manner. Thank you.
Okay. Mr. Alessi's issue, I'm going.
So we are not going to watch everything Bob Alessi said, but I do think it's important to watch just some of how this tone went down. Listen to some of how Bob Alessi was yelling at Judge Canoni here.
Adequate. Nonetheless, because of all the considerations we're aware of, we had ARCA proceed forthwith with post haste, and they are working post haste. But, Your Honor, we are the defense. That's where I started. We had to understand as best we could what Aperture did. In conclusion, 2 points. No violation whatsoever on text messages, emails, court orders. All complete, robust compliance. And with regard to the allegation that there was something said, that there's some surprise that there were so many text messages. On June 10th, 2024, and I've got the transcript, albeit on an electronic device, right in front of me, I just got to get the passcode. Mr. Jackson read a text message right live that he had with ARCA. He read it, and here's what it said. The court, okay. Mr. Lally, so her issue is that she is available this week, but not next week.
We're going to jump forward.
Those questions. Your Honor, it is improvident to, based upon speculation, preclude the defense.
I'm not making a conclusion today regarding precluding the defense.
Okay, all right.
All right, so I need you to wrap it up because there's something I want to say.
Now, let's skip Alessi's 40 seconds of closing, and what did Judge Canoni have to say, you might ask, if you missed today's bombshell motion hearing that for some reason the court pool feed cut off before it aired, but Towel stayed on and kept covered? This was the crescendo, Towel friends, and it was quite a moment, and it was what everything led up to today. And Friday, my word, get ready for the Towel fireworks.
So as you all know, I previously wanted you to have a seat, Mr. Alessi.
Thank you, Your Honor.
I previously found, and I believe Mr. Alessi, when he was talking about the rules of professional conduct, did say, I agree, a violation of Rule 14, but not regarding the rules of conduct. At a prior hearing, I found a violation of the defense's reciprocal discovery obligations. It was clear to me, and I found that it was deliberate. This appears to me, contrary to what you've argued, Mr. Alessi, that this is another violation of my order and of the reciprocal discovery violations. We need to figure all of this out before you're allowed to call these witnesses. So I'm going to have a voir dire hearing this Friday. I know we planned on having the view. I need the ARCA witnesses here Friday morning. So we need a voir dire, if you intend to call them, a voir dire on all of this. And I will be sending an order for production of records. I just need to amend it for ARCA to bring all these items with them. So Friday will be for ARCA for a voir dire hearing in the morning. So we'll see you tomorrow for trial, Friday morning for this.
May I inquire briefly for scheduling purposes?
Yes.
In light of the hearing on Friday, will it still be half a day, or are we expected to call witnesses on Friday?
No, it will be, if we could do, Mr. Alessi, how long do you think this voir dire might take?
I don't have an answer for you, Your Honor, right now, because I've got to talk through ARCA and I've got to understand what they have and what they don't have. So I think it could take some time.
All right. So no witnesses for Friday, and I think we'll give the jury the day.
And will it be a full day on Thursday?
Yes.
Thank you very much.
Yes. All right. So we'll see you then. I will issue an order, hopefully before the close of business today. Jimmy, can you stay and get this out today?
Sure.
Okay. All right. Thank you.
All right, folks. I have breaking news. The order has issued. The order from to compelling ARCA to produce records has issued. I do not have the text of the order. The court is closed. This was something the folks stayed late for this, but I have confirmed that the order compelling ARCA to produce records in the Karen Reed case has gone up. I'm going to get this uploaded for you. I can't really tell you anything other than it says order for production of records. Now, you just listened to the clip from Judge Canoni, so you heard, we know what this is about, right? There's no secrets here. Folks watching this towel stream are able to interpret it, but if you just looked at the docket, all it says is order for production of records. Now, as you know, is tradition on Towel Stream, when something happens, you all get to watch Towel draft stuff up in real time because, I don't know, I think people are interested in Towel's process, but also I think a lot of people are just interested in how it's possible that Towel can even do this. So let's do it together. Okay. Here we go. Just in. I think that's the best way to start this. Just in. The Judge Canoni's order in the Karen Reed trial following a bombshell motion hearing at the end of the first day of evidence and opening statements in Reed's retrial for the death of John O'Keefe has entered Judge Canoni's order in the Karen Reed trial related to forcing Reed's experts from ARCA to bring documents, records, and other communications with communications related to Karen's team with them for a Friday voir dire hearing. This news followed a bombshell motion hearing at the end of the first day of evidence and opening statements in Reed's retrial for the death of John O'Keefe on Tuesday. And then what I'm going to do is I'm actually going to upload the video of Judge Canoni's ruling into this coverage. What a unique hybrid form of coverage. So I'm going to take what we just saw from Judge Canoni, that clip, and then I'm going to upload it. and I'm going to embed it into the reporting on the order. And then I'm going to put the order for the production of records right above that. And then I have to expand the article. Give me 1 second. Okay. Watch the video below in full of Judge Canoni announcing she would issue that order to ARCA themselves before the close of court on Tuesday, which in turn explains this late filing on the docket. I will have the full document when it is available. All right, so I have done what I set out to do, and now I have one more thing to do, which is watermark my coverage. There you go, towel friends. You not only did you get the chance to stream in real time with Towel, but you also got to see me write up a number of articles in real time. Okay, so with all of that said, let me circle back one more time to the YouTube feed here. Let me say a thank you. First of all, I want to say God bless you and thank you to the people who stayed and were kind enough to watch this long. That means a lot to Little Towel. We've gone 9 hours and 43 minutes. I mean, do we just hit the 10-hour stream now? I'm afraid if we keep breaking these records, we broke the previous Towel record years ago. Yes, I think it is huge news indeed. Artworks too. I was so pleased to be able to bring this Towel coverage to you all. I'm so pleased to see so many Towel friends. Today really was a record-breaking Towel stream. We were able to go past 500 subscribers. A lot of new honorary Towels joined the ranks. The honorary Towels were on guard at all times for subversive influence. Yes, and if you do, the sunken grave says Granted as an animal. Oh, I'm just a towel. I don't think a towel is a form of animal. I think a towel is a form of fabric. But I guess, you know, the towel fold embraces all people and entities. So if animals want to become towels, we can welcome them into the towel fold. Towel will never turn down anyone who in good faith wants to become a towel. I feel like that's the essence of the Towel universe. We welcome all creeds and faiths, and we just are wonderful towels together. But that said, you know what I actually want to do with you, because there is some benefit to sticking around and potentially going 10 hours. I might be able to hunt down this document related to the order for the production of records. So stay with me, friends. Stay with me. I'm going to do a circuit of the usual suspects to see whether or not there is a picture of this order up yet. Of course, Little Towel is left on his own to do this because it's the end of the day and all the other Towel friends, not Towel friends, but all the other colleagues are very, very tired, I'm sure. But I'm here, I'm monitoring. Let's see. Dee Dee, anything for us, Dee Dee? Team Docket Rocket Stars, I need you to come through. Come on, Christina. Let's see. Nothing from Christina yet. Nothing from Dee Dee. I'm not really sure because it was a late order in the day. So it's one of those things you might not see right away. But if we can get this order for the production of records from ARCA, we pretty much know what they're going to say. But I'm going to actually try to get the ARCA order. I'm turning into Judge Canoni. ARCA order itself. I'm going to try to get that for you all. And if I can't find that in the next few minutes, then we will call it a day. But that said, I'm also very pleased that so many of you Towel friends stayed around. And I'm so, I see Trevor McIntyre is here. Very good to see you, sir. Trevor McIntyre said, Towel, you're a tour de force. I'm just a tour de towel. Alana says, thank you for your great coverage. Oh, Towel friends, it really means so much to me that you all stuck around. And I guess because we're going to head on 10 hours and this is another 90-minute cycle, and some folks did remind me earlier, I will remind you that this is a public information service. It operates much in the spirit of the British Broadcasting Corporation, or PBS, and that means it's entirely supported by viewers like you. Now, you can take a look in the description of this YouTube video to see a bunch of different causes you can help. You can take a look at Lindsay Gattani's fundraiser. You can take a look at mine. But if you want to support or donate towards this little stream directly and say thank you to Little Towel and help, I actually have to get some equipment in the courtroom. And so there's a bunch of things I need to work on right now to expand this operation. It's definitely revenue negative. But if you want to donate towards obtaining that stuff, please consider doing so. It supports the stream. Don't feel obligated, please, to donate. Your comments warm Little Towel's heart, your participation, your camaraderie with each other, your acts of service, your kindness, all of that warms Little Towel's heart. And then, of course, you can also, if you're thinking, how can I support this public information service? Other ways. You can like this stream. You can subscribe. We hit a wonderful milestone and hit 500 subscribers today. I'm so honored to have so many of you along for this ride. I think we are going to try to shoot for 10 hours just to see if we can get a copy of this motion. And if we get through the next few minutes and the motion, the order text from Judge Canoni does not come down, then that will be our sign to call it a day. But what I can show you, let me just get the post up now, and then as I get the post up, I will be able to bring it up on your screen and show you how I went about doing it. But yeah, so I was able to create a nice post here that summarizes the order for the production of records and also shows, oh, of course I copied the donation text instead of the text of the post I wrote by accident. But yes, I took some time to write up, as you heard, the order coming in. And what I want to do is I want to grab that order. I want to grab because all we have right now is just the docket entry. But sometimes if I post the docket entry, that'll spur either Dee Dee or someone else on Team Docket Rocket Stars to post it. I spelled available wrong in the actual screen, the image itself, or the post, not the post, but the actual document I'm going to post, or the video, but that's okay. Towels occasionally make errors of that nature, and that's absolutely okay. Comes along with real-time towel processing. I also can't believe we're going to hit 10 hours. I feel like we just broke, what was our towel record prior to this? Like 7 hours and 35 minutes? Although in my defense, that was me talking for a majority of the time. This, at least there was some interspersed coverage with it. But yeah, I think we're going to hit these 10, 11 hour marks a lot more often, friends. Towel definitely appreciates and vibes with your energy, and that keeps Towel going. But yeah, let's take a look what I just posted so you can see the order for the production of records. It's not actually the text of it. I'm going to wait out about 7 to 10 more minutes. I just want to see if we can get to the 10-hour mark just so we can say that us Towel friends saw a 10-hour Towel stream. Try saying that 10 times fast. But yes, as you can see, I used the same clip of the video that we just watched, so I'm not going to show you that again. But you can see right up on your screen, it says, I believe it should say, let me double check. It should say order for production of records. Yes, it does. You can see it right there. Order, production of records. It doesn't even say ARCA. So if you weren't attentively paying attention, you wouldn't know. JI5 says, Grant, could you please go through the ARCA and may or may not happen in consequences? Yes, so on Friday, JI5, ARCA is getting called in for an expedited voir dire. This is a hearing outside the presence of the jury. The jury won't even be there Friday, so this hearing could go all day. A hearing outside the presence of the jury where an ARCA is grilled, not on the scope of their testimony like a Daubert Lonergan hearing like we saw with prior experts, but whether Reed's team violated reciprocal discovery obligations under Rule 14. We already know Reed's team has clearly hidden evidence of payments and contacts with ARCA on 2 occasions. Judge Canoni made that ruling today and made it clear to us. Now we're looking at a situation where ARCA itself is subject to an order for production. They have to bring documents with them on Friday, and they're going to get grilled by Judge Canoni related to that production. And the punishment for a violation is ARCA is not allowed to testify. You heard Judge Canoni say to Bob Alessi, I'm not going to exclude them today. But she's hinting at him that after this voir dire, she's leaning towards, if there's sustained findings of Rule 14 violations, banning ARCA. That's the sanction. Reed loses ARCA as witnesses if there's sustained reciprocal discovery violations under Rule 14. That's what Judge Canoni said. It's huge. Murder by Maestro says, I never said I'd join a cult. Next thing you know, I'm a towel. Well, we're not a cult. We're just we're trying to live a life based not on 6 degrees of Chewbacca, but on 6 degrees of authentic demonstration of universal love in a way that flips realpolitik on its head and seeks to preserve, expand, and demonstrate that universal love through acts of service, either on the micro or macro level. And Murder by Maestro, I know you speak hexadecimal, so I don't know quite how to translate that into zeros, A's, E's, and X's and F's, but, take your programming and interpret it into your language. Murder by Maestro is absolutely not some kind of computer hiding in a 26-year-old's body. Although I think we've just decided Murder by Maestro is 26. If M says, if Karen Reed said that she didn't think that John O'Keefe didn't look mortally wounded, wouldn't that suggest she knew she hit him and that she left the scene of her crime? Yes, Ems, that is exactly why Hank Brennan played that clip during his opening. Jewdrop says, thank you, Grant, we love you. Oh, I appreciate it, Jewdrops. Dixie Doodle says, any further hearings should be done in their own time so it doesn't delay the trial. Yeah, well, it's not really delaying the trial, it's that they're going to lose the experts, so they absolutely are entitled to it. But yeah, it's a huge deal. Mo says a lot of people are becoming towels nowadays. A lot of people are towels, Mo. So many towel friends. It's wonderful to have you all. Mo, you can become an honorary towel. Just don't take advantage of your towel status. For example, it's okay if people cuss, and generally don't ban them unless, just be very gentle and try to just act as a camaraderie towel. The wall of towels is to just kind of reinforce, not necessarily tell people, you can't do X, Y, or Z. Generally, unless I'm saying to someone like, I think you're being malevolent or malicious, or unless someone's being openly racist or discriminatory, you can let it go for a little bit, and then if I need to intervene, I will. But that's my advice. Welcome to the towel fold, Mo. Kat, it's great to see you. Kat says, Ems, yes, KR admitting she saw John wounded would definitely imply she was aware of hitting him. I agree. And there is a charge of leaving the scene of an accident. There is a GoFundMe as well. Thank you, Burner by Maestro. God bless you for sharing that. Dixie Doodle says, it was a pleasure to watch you all day seeking justice for John. That's the core of it, isn't it, Dixie Doodle? Seeking justice for John O'Keefe and explicating the details of this case in such a way wherein the system can function to bring about that justice and hopefully convict Karen Reed on at least one, if not more, charges that she's facing. Jewdrops, it was great to see her. I hope you have a great night's rest. Murder by Maestro, yes, you are a hero towel. You are a hero towel friend. Let's see. Jewdrop says, love you all. My Wi-Fi is slow, so I'm behind. Is there court tomorrow? Yes, Kat, we're in court on our regular schedule tomorrow, and then Thursday, full day, and then Friday we are here for a full day voir dire with ARCA outside the presence of the jury, where ARCA could be excluded as a witness. So Friday is a big day. Alana says, I hope ARCA gets banned from testifying. JF5 says, thank you for the explanation, Grant. My pleasure. Thank you for sticking with me. We're going to do it, friends. You are going to see a 10-hour towel stream. We are going to wait out these next 5 minutes to see if there's any update related to the motion for the order for the production of records from ARCA. Kat says they're going to need to switch their sleep schedule to East Coast time. Yes, this trial certainly, it begins every day at 9 a.m. Eastern, goes every day till 4:30, and it apparently means that Towel is going to join you every day at 7:30 and go until 5:30 or longer, because Towel just really enjoys discussing with all you Towel friends. Mo says, I'm an honorary Towel. Yes, thank you, Towel. Well, God bless you, Mo. Welcome to the honorary Towel fold. Christina, I don't... Fine. Christina, you have showed hours and hours of dedication. You have made it out of the doghouse. No Stray Ents, congratulations on being here for the 10-hour record-breaking towel stream. Mark, you have also been promoted as an honorary towel. Everyone is becoming honorary towels. They've made it. 5EMEODMT even decided to put off their bedtime to see the towel approach to the record 10-hour mark. God bless all you towel friends. As you're here, hold on, I should clip this because I know I'm going to find this interesting. As all you textiles gather for this record-breaking 10-hour towel marathon stream, I will reinforce to you the message that I have delivered so many times before while standing on my towel-based conduit soapbox hybrid thing. Please remember that in a world defined by so much greed and hatred and self-interest, and in a schema of realpolitik defined by preserving, expanding, and demonstrating one's power, let's flip that around and let the ethos and the fabric of the towel universe, so beautifully stitched together by all of the washcloths and towelettes and paper towels and hemp towels and soap dispensers and flannels and towelettes and otherwise, be defined by unconditional love, demonstrating, preserving, and expanding unconditional love for one another, for those around us, for our countrymen, for our countrywomen, for the world itself. And let little acts of service be not 6 degrees of Chewbacca, but instead 6 degrees of authentic inspiration, whereupon something as simple as a smile, a handshake, donating some money to someone on the street, donating money to homeless veterans, supporting a cause you believe in, doing something nice, driving to see a family member, whatever act it is, if we can do enough of those acts over and over and over and over again, then you will have honored the legacy of educating, informing, and entertaining that Towel is trying to engender by way of helping you all become cogent participants in the wider public sphere through this public information service. And God bless so many of you for spending some time with me. I know we're not quite at the 10-hour mark yet. We're coming up on 9 hours and 58 minutes, but it means so much to me that so many of you have stayed for this whole stream, that you all are so engaged and so active. It means so much. And to even start going through all of your names, Jewdrop and Trevor McIntyre and Evie and Macy and Christina and Kat and Mo and Eva and Murder by Maestro, and Alana and the Dixie Doodles, and the names, just, they are so familiar now. They feel like parts of my life. And you all have changed how I think about going about public service. You've changed how I feel that this public information service can serve the wider public good. That was the word public a lot. But needless to say, you've really helped me think about my role in the wider world, and it means a lot to me. Artworks, too, thank you so much as well. I'm trying to thank as many people as I can while going through the chat. It moves so fast. Potluck, Second Beach Girl, really, all of you, it means so much to me that you spent time. Jimbo, it's great to see you. I'm sorry I missed your comment. The Sunken Grave. And I know there were more towel friends. Unfortunately, the chat only scrolls back so far. But there were so many of you that when I see your names pop up, it truly brings a smile to my face. And I don't think there's any better way to honor the 10-hour mark, which we're going to come up on here in just over 45 seconds, than by Towel getting the chance to go through and say hello and thank you to so many of you wonderful Towel friends. If I'm saying your name twice, that's fine, but Kim Courteau, you might have to remind me how to say that. It's great to see you. Potluck, Jeff Williams, the Pilgrim Shadow, that you are so wonderful. Pilgrim Shadow asked if I could post my GoFundMe. Okay, I will absolutely do that. That's not exactly how I wanted to honor the 10-hour mark, but if that's what God is calling you to ask for, I cannot say no to that. And here it comes, friends, in just over 10 seconds. 9, 8, we should be coming up on the moment, and we are there. 10 hours, we reached it. You're all here for the moment, the celebratory moment. All of you who have made it 10 hours with Towel, it truly means so much to me. God bless you in so many ways. I'm sorry we didn't get to actually read the text of the order for the production from Records from ARCA, but that just means we can start our stream tomorrow analyzing that and talking about it. Kim asked if I can get Kim Cordo. I think I'm saying that. Cordo. I think I'm saying it right. I cannot get super chats yet. Maybe sometime soon. I don't know how all that works. I'll ask Murder by Maestro. He's a really smart guy. Maybe he'll tell me more about it. I'll figure it out. Diana Natale, oh, it's so great to see you as well. And 5EMODMT, of course, it was great to have you here. Murder by Maestro says, whoop, of course, it was wonderful to have you. Diana Natale says, you're awesome, Towel. Understanding, giving, and loving, Grant. Well, thank you. Fare you well, my fellow textiles. Yes, goodbye, friends. And thank you so much to everyone who made it 10 hours. Jeff Williams, I will get some rest. I'm going to end this clip now. Thank you, towel friends. YouTube.com/@GrantSmithEllis. Join the towel fabric. We have a lot of fun. As to you, towel friends, allow me to say goodbye to you personally. I read all of your comments. Macy says, wow, 10 hours. It was a lot. Melly Mel, you made it. You were here at the 10th hour. You get added as an honorary towel. So many honorary towels flying around. Wall of Blue, says Christina. Beautiful blue wrenches. Buy Textiles, says Angela Whittick. Share Grant on your socials. Let's help to get his subs up to Super Chats. Yes, you want to share the channel. If you appreciate this work, you can definitely make a post and say Grant's streaming on his YouTube. You can link to it. You can say thank you. I will be grateful. I'll reshare your post. Great idea. We probably need a huge towel rail. Yes, all right, friends, good night. Signing off. Towel is going to go get some rest, and I'll be back with you bright and early tomorrow. We'll do it all again. Thank you, friends. Truly, God bless you. My name's Grant Smith Ellis. Until next